Open this public hearing of the Parliamentary Joint Committee on Human Rights. I acknowledge the Ngunnawal and Ngambri peoples who are the traditional custodians of the Canberra area and pay respect to the elders past, present of all Australia's Indigenous peoples. I'm Anne Webster, the Chair of the committee, and I have with me Mr Graham Perrett, Deputy Chair, Senator Janet Rice, and we are awaiting Senator Deborah O'Neill. Joining us via video conference is Ms Celia Hammond and Senator Ben Small. Joining us by teleconference is Senator Andrew McLaughlin, and Ian is not on this list.
Yes, I am.
She's on the telephone.
Yeah, but he's not on this list. Can I quickly confirm that those on video and telephone links can hear us?
Andrew McLaughlin, yes.
Excellent. I can't see anyone on video, but I'm sure that you are there. On behalf of the committee, I welcome all here today. The committee is hearing evidence on its inquiry into the Religious Discrimination Bill 2021, the Religious Discrimination Consequential Amendments Bill 2021, and the Human Rights Legislation Amendment Bill 2021. Together, these are referred to as the Religious Discrimination Legislative Package. This is a public hearing and a Hansard transcript of the proceedings is being made. The hearing is also being broadcast via the Australian Parliament House website. Before the committee starts taking evidence, I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. The committee generally prefers evidence to be given in public, but under the Senate's resolutions. Witnesses have the right to request to be heard in private session. In order to facilitate the committee in hearing from as many witnesses as possible, the committee has resolved to only receive written opening statements. Witnesses will be asked to introduce themselves, and then the committee will move straight to questions. I thank those who have already provided their opening statements to the committee. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground on which it is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. I remind people in the hearing room to ensure that their mobile phones are switched to silent, and those who have connected remotely to please mute your microphone when you are not speaking. I now welcome representatives of the Independent Education Union via teleconference. Can I confirm that you can hear us, please?
Thank you very much, and good morning.
I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Before we begin, could I ask you each to state your name and the capacity in which you appear for the benefit of the Hansard script?
Good morning. I'm Christine Cooper. I am the Acting Federal Secretary of the Independent Education Union. And with me?
John Spriggs, Senior Industrial Officer of the Independent Education Union, Queensland Northern Territory branch.
Thank you. If you provided a written opening statement, would you like it to be incorporated into the Hansard record?
We would. Thank you very much.
I will now invite members of the committee to ask questions. I'll throw to the Deputy Chair. Thank you.
Thank you, Chair, and good morning, Christine and John. And I just, for the sake of completeness, put on the record that I'm currently a member of the Independent Education Union and used to work with Christine and John for about 5 years. A while ago, Christine and John. So
Definitely, time flies.
Yeah. My first question is, Section 7 of the bill describes situations that are not discrimination by a religious body, including in relation to employment. Section 7.6 provides that a religious body must have a publicly available policy, and 7 gives power to the minister to determine the requirements of that policy. your submission says that there is, and I quote, no basis for believing that the Minister will be able to confine the content of employer policies to matters directly relevant to an employee's conduct. Can you explain to the committee how the IEU have come to that view?
We've provided in our submission some examples of employer policies. And I think what a point is making here is that the level of complexity that happens within these policies only complicates the employment relationships when a conflict arises. I think it would be very difficult for those that are outside of the school arrangements to be interpreting, particularly for the Minister in this situation. I could refer you to those attachments at the end of the submission.
A very good submission. And Ms Cooper, it also goes on to say in your submission that after the 2019 bills, some IEU members were directed by their employer schools, to contact the union to ask that your criticism of the bills be removed, and some were threatened with disciplinary action by their employer school if they did not comply. How widespread was that behaviour by employer schools?
Overall, the non-government sector is a fairly broad sector, and the majority of employers do not try to use legislation to discriminate. But we do have, as you've identified, cases where this is happening. And it becomes amplified when there is public debate like this bill or previous bills or the marriage equality bills, where employers feel they need to force public comments or commitments of staff on comments. Yes, the submission puts forward to you examples where our branch journals have made commentary on religious discrimination, and members have been directed to contact us to say, take it out of our journal. That's quite difficult. The element of fear that exists in our schools can't be ignored in these schools where employers seek to use discriminatory practices. And that is what really gets highlighted in Attachment 1 and Attachment 2 of the submission.
Okay. And I guess your submission goes to the heart of the matter, that it's actually the employer makes statements, but it will actually come down to the principal and the attitude of the school community. And in my experience, it might even be a particular member of a board of the school in terms of making decisions about an employee's lifestyle being inconsistent with the faith basis of the school. So in terms of that, employer policies and then individual principal decisions or individual board members' decisions. Mr. Spriggs, perhaps as the industrial officer, could you make comment on that? Would a publicly available policy be of any value, or could you make comment on that?
Well, in our opinion, probably not. Having represented a number of people who found themselves in a particular situation, as you correctly identify, sometimes there is someone on the board that has, to use the colloquial, to be in the bonnet about something, and they go off on a tangent of their own, and the staff member often has to wear the consequences of that person's crusade, even though the crusade may not be something that the whole school community would support.
I think, too, when we have a look at those examples that are in attachment 1, some of them are they're all pretty much general living, just the normal everyday living. Their marriage, their relationship, pregnancy, sex, gender identity. If you have a go to page 12, number 7, itemises a member who has utilised IVF to become pregnant after many years of trying.
So not exactly a radical decision in 2021.
Exactly. And yet she's informed that the form of IVF that she uses is contrary to the doctrine. Now, I challenge anyone to find a school policy that actually outlines this. And so we are finding our members are tripping over doctrine that can't actually be outlined specifically in one policy. And so to go back to your question, can the minister interpret this? We're having difficulty interpreting to support our members. Our members are having difficulty understanding. So no, I don't believe an outsider and a minister could.
And you're at the coalface with people, working in these religious and other independent schools.
That's right, Graham.
Just further to that, Ms. Cooper, the IEU criticises Section 12 of the bill that relates to statements of belief, and the IEU has suggested that limitations are not sufficient and objects to overriding state legislation. Could Section 12 be amended to cure the concerns that the Independent Education Union has about that clause, the Section 12?
To be frank, Graham, we would prefer that the bill be removed rather than start to repair. So that's our front position. I think the existence of a third legislation in this complex area is only going to complicate matters even further.
Okay. And my final question, your submission, which was quite surprising, it suggests that the religious discrimination bill will actually prevent some of your members from enjoying religious freedom. For instance, in schools where not one teaching employee is a member of the religion running the school, could you explain how this bill might impact on those members and give general examples where possible?
Where, as I started with, the schools that we have in our sector are very broad. There are schools where there are teachers who are working in the school that do not hold their faith, are not required to have the same faith. There are parents who send their kids along to schools that don't have similar faith. We have schools where, we have schools where in part of the doctrine, higher education is not encouraged, but you just have teachers working in those schools.
Okay, so would that be like the closed brethren, or what sort of schools where that might be the case? Islamic schools, or?
And it would be the closed brethren that we're referring to with regards to higher education.
So they encourage people, women in particular, not to go to higher education, but they need registered teachers to teach in those schools.
That's correct, Graham. Yes. So those teachers will bring their own faith to the school. A religious freedom bill should provide freedom of expression for those teachers rather than to dampen and restrict. I think there's been a lot of discussion about the organisational rights, but what we're focusing here in our submission is what protects and supports those individuals who are working in the school.
Okay.
And I take you back to attachment 1 and 2. What is actually diminishing the fear of being discovered, the fear of working in these schools? How can we help these members? And this religious discrimination bill does nothing to do that.
Okay. All right. Thank you very much for a very thorough submission. Thanks, Chair.
Thank you. I might move on with a question as well. You claim that the legislation would allow religious bodies, schools, hospitals, aged care facilities and accommodation providers to hire, fire or promote any worker based on their religion, regardless of their attributes for the job. A reading of the legislation, I'd query that. Subclauses 7, 2 and 4 provide that a religious body does not discriminate against another person by engaging in good faith in conduct that a person of the same religion as the religious body could reasonably consider to be in accordance with the doctrines, tenets, beliefs or teachings of that religion, or to avoid injury to the religious susceptibilities of adherents of the same religion as the religious body. This may include giving preference to persons of the same religion. If the religious body is an educational institution, the conduct must be in accordance with a publicly available policy. The provisions do not affect the operation of other Commonwealth anti-discrimination law and do not provide a basis for discrimination on the grounds of a protected attribute. Can you explain why you believe that the legislation would allow religious bodies to hire or fire staff regardless of their attributes for the job?
Thank you. The first thing is that it's prefaced by a test, is it in good faith? So there will be, in practice, an argument about whether it is in good faith or not. Then it goes to the specific words that say they can give preference. An employer would simply say, I am giving preference to a member of our congregation as opposed to somebody else. And the aggrieved person would then have to make a choice as to whether it was worth attempting to challenge the employer's decision or not.
Thank you. You raised concerns that the bill would override other state and territory protections consistent with existing Commonwealth anti-discrimination laws and subject to a number of exceptions described. The Religious Discrimination Bill does not override or interfere with state or territory legislation. Clause 68 explicitly provides that this bill is not intended to exclude or limit the operation of a state or territory law to the extent that the law is capable of operating concurrently with the bill. Can you explain why you still hold such concerns?
There is, and I would need to just take a moment to find it, a provision in the legislation that specifically gives the minister the power to make a regulation that it does override.
We're looking at section 11, isn't it? Section 11?
Yes, thank you, Christine.
Section 11.
So you're saying that the minister can override the state and territory legislation?
The legislation, the bill, gives the minister the power to make a regulation such that this would override the state legislation. And it's section 11, subsection 3.
I believe Senator Pratt may have a question.
You muted.
I do think, yeah. Just to follow up, please, on your question, if I may ask the Independent Education, it's your understanding that it is, in fact, an intention of the bill that the bill does have the power to override state acts. Is it not?
That's correct.
In reading section 11, yes, we think there's potential for that to occur, yes, and therefore taking away any protections our members may have on the state level.
Thank you. And in relation to, sorry, I'm losing my voice. In relation to the question that Mr. Graham Perrott asked, in terms of clause 7, that overrides the rights and protections that the bill might provide to employees of the school. Can you clarify that for me in the context of the employment contracts and awards, etc., that your members have? So I'm trying to get my head around this idea that the government's argued that the bill will in fact lift some of the protections for teachers when in effect, and by that I take that there are some exemptions that exist that might therefore support a school having an explicit policy, but you're saying Section 7 still individualises the notion of a particular part of a belief about a teacher's conduct that might extend beyond what the written policies are. It seems that the bill goes off in some 3 directions. It has the exemptions in the Sex Discrimination Act, it has the extension of the overrides in Section 7, and yet somehow it also purports to say schools must have written policies. I'm somewhat perplexed about all the different directions that this goes in terms of what that means for the very real experiences of discrimination that you have disclosed. Thank you.
Support some of those statements, Senator. The bill does take us into very complicated avenues, and the matter itself, you know, the existing legislation is complicated enough to navigate. To rely on, I think I've said this before, employer policies doesn't actually simplify the issues. It won't support when an issue comes to the foreground in trying to settle it, because there's so many other underlying beliefs that get used when a member is discriminated against by an employer. So,
and can I ask in that context, in the contract that you and are there aspects of those contracts that go beyond the normal attributes of the anti-discrimination provisions that might also have implications for the conduct of a teacher? So I guess in this case, a religious belief itself, or perhaps even a political belief about unionism that could be seen to be contrary to a school's religious belief, so that this bill will privilege the religious belief over and above the other protections that someone might expect in employment?
You're absolutely correct. Not only does it appear in some contracts of employment, but we have seen it appear in statements in enterprise agreements, for example, where a particular interpretation of a Christian belief is reflected in the enterprise agreement, and there's an explicit statement that employees covered by the enterprise agreement are expected to endorse that particular interpretation of Christian belief.
if I can take you to page 5 of the submission, we've put in an extract of such an enterprise bargaining agreement. Now, these words there pretty much direct every aspect of an employee's life from work is relevant to their away from work is relevant to their continued employment. So it's not just what's happening in a school in terms of employment arrangement. It's how you're living your life outside of that school. And that's what these contract employments can have. This is what their policies can dictate, and this is also what their enterprise bargaining clauses do.
Okay, and of course this bill might support that, but what challenges does that create in the context of what parents would want in terms of enrolling their students in these schools, which might be not just not just a consistent religious education, but also to the quality of the education standards in that school?
I think we take a step back and have a look at the sector again. There are so many varieties of schools, and not all teachers in all faith-based schools are holding the same faith of the school. There are schools in rural areas that are run by Catholic schools, that they are providing the only education in those areas. We're talking about Wada and Bangalow Hills, areas like that. The parents majority of those parents would not be Catholic, the children may not be baptised, the teachers may not be holding religion. But that does not diffuse the Catholic ethos of that school or the work
Okay, so you're saying that these teachers are still held to account for the manner of life type policies or other religious-based conduct policies, even though they're not a subscriber to that faith and they have been employed on that basis.
That's correct.
Thank you, Chair. I should give someone else a turn, I believe.
Thank you. I'll go to Mr. Ian Goodenough. I believe you've got some questions.
Yes, thank you, Madam Chair. There have been a number of changes to the bill since the second exposure draft was released. A number of these changes would have addressed some of the concerns that were raised in your initial submission. What are the main concerns that you still hold with the bill in its current form?
Senator, to be frank, I think we have a promise of a review of existing legislation. And I think the actual way forward for all of us is to review that, to not complicate the matter with a further bill. So that would give us three levels of legislation that we need to navigate. So I guess in the broad picture, we're saying take us right back to first torts. Fix what we've got, review what we have, amend what we have. Do not actually create a third level to now we have to go and look at this legislation and that legislation and how it interacts. So rather than go to the details of the amendments of the bill, which I'll have to take on note, I think really that's what we're asking, is to provide individuals with clarity within the legislations that already exist. And that's what we don't have.
Just to build on that, our preference would be that the Australian Law Reform Commission, their inquiry should be able to look at all anti-discrimination legislation and provide a holistic set of recommendations which would provide consistency and commonality. That is not an outcome that would appear to be achieved if this bill were to become legislation.
This bill provides a piecemeal approach, is what we're saying here. And it does not actually address the issues of supporting human rights of individuals that are in our membership.
Okay. Yes. Do you believe that educational institutions should be able to preference staff that adhere to the same doctrines and beliefs of the school? and how many of your members would adhere to a particular religion?
The membership, the religious beliefs of a membership we've not actually surveyed, but if I take you to the Victorian Tasmanian data, the survey that we had from the Victorian Tasmanian branch, now that's in schedule, that's at 6, you will see the relative support that staff have and belief in their schools, in these data. I think what I believe, Senator, is really here, not there. What is existing in our schools is that staff support the community, their principal, their parents, and their ethos. To actually then say that maybe those teachers who do not hold the same faith may not have the same level of commitment to the school actually demeans the work of what that school is performing, because there are so many schools that do not have staff of the same faith. And I think that we need to recognise that they are doing great things in these schools, in supporting their parents, in supporting their children, in providing quality education. And we are actually going to miss the big picture by just picking up, oh, you all need to be of a particular faith, because you actually do need teachers who are qualified to deliver quality education. They need to be skilled in their subject areas. And I think that's what parents want too. They want their children to be taught by professionals.
Do you have any indication of what percentage of your membership might be religious or hold to a religion?
No, I wouldn't be able to go that way, and nor would be recommending our branches even seek that. I think really it comes down to their beliefs of support in the community of the school, rather than their faith doctrine. And if we take another step back and have a look at the Australian census, the latest results show that there is a diminishing number of faith holders in Australia. So I really don't know if that's a way forward for us to analyse our membership.
All right. Thank you very much.
Thank you, Mr Goodenough. I'm going to go to Senator Rice.
Thanks, Chair.
You've just got 5 minutes.
Thanks. And thanks, Ms Cooper and Mr Spriggs, for your really terrific submission, which outlines what the reality is for teachers now in independent schools. Can I just ask, you outline how teachers are being discriminated against on the basis of sexual orientation, gender identity, marital status, IVF. Could I just summarise that this bill isn't going to improve that situation at all? In fact, would you say it's going to make it worse?
Yes. There's nothing in the bill that actually provides some sort of safety net for our members. When our members have these issues, and as I've pointed out in attachment 1 and 2, they are just working realities. It's just general living condition life. It's marriage, it's divorce, it's somebody trying to escape a family domestic violence situation and seeking a divorce, and then coming up against the doctrines of marriage. There is nothing for us, there's very limited help that we can give these members. And in many, even though we've documented these cases, there are going to be many cases where members are not going to tell us what's going on. They're too afraid to raise the issue with us, to challenge what's been said to them. So what we're asking for is legislation to support our members and their individual human rights. And I don't believe that this bill does that.
Thank you. In the examples in attachment 6 and 7 in particular, where you go through a range of staff who have been sacked for various things, including their gender identity and sexual orientation, including teachers at Catholic schools, in the submission that was given to us by the Australian Catholic bishops, they say on page 2 of that submission that Catholic schools do not expel students or staff simply on the grounds of sexual orientation, gender identity or any other protected status. Suggestions that they do have gravely misrepresented and undermined the good work of Catholic schools and unnecessarily caused anxiety in the community. Where there is a discipline issue or a disagreement, principals or other senior members of staff will work to try and resolve the issue pastorally. Would you like to comment on that with regards to the lived experience of what some teachers have experienced in some Catholic schools?
I think the lived experiences of our members are well outlined in our attachments. It is our reality that when members trip over the doctrine and conflict arises, we do try to settle that, sort that at the lowest level with the principal, with the diocesan director. But it is evident that they are asked to leave schools. They've moved on. And that becomes even more difficult for an individual's life to actually have to leave a community that if you have their children at the school, then find a new job. There's a lot of disruption. So dismissal may be one thing, but actual negotiations out of the school might be seen as the I'm being cynical, sorry,
Right.
pastoral caring way forward. It's the reality that that's what happens.
So that's what resolving the issue pastorally means.
Unfortunately, our experience is that on some occasions, yes, it is a negotiated separation.
Look, just in the 1 minute that...
I've got to
Okay.
have another question on notice. So if you could just ask this question on notice, please.
Okay, I was basically just wanting to say, what do you think the way forward should be?
They've
Yeah.
already said this.
Okay.
Senator O'Neill, please. On notice.
Oh, sadly, it would be helpful because it's an area that hasn't been traversed at all. I note that you cover, is it about 150,000 teachers across all of the different sectors? Is that correct?
In broad terms, that would be about the size of the sector, yes.
Yeah. Our membership is 75,000. Yep.
And that's roughly 55% of the population. So you've got incredible insights into all of the different sectors. I note that you indicated there are crusaders and systemic differences. My question really was, and I would appreciate it, Chair, if we could just hear about the Islamic and the Jewish schools, because I note in the submission from the Australian Catholic bishops that they talk about roughly 1 in 20 Australian children experiencing discrimination based on religion, which is higher than the rates of discrimination based on disability, mental health and sexual identity. And there are comments here about anti-Semitic incidents in Australia, 188 attacks, 143 threats in a 2-year period, and similarly data about 72% of victims of anti-Muslim attacks being women, 349 incidents of discrimination, harassment and violence. So my question was, what is the situation in terms of the IEU's support for the principle of a federal anti-discrimination element to cover off religious discrimination, given the sort of workplace tensions you've talked about, and the reality for those particular minority religions, and I think Sikhs also, because they have such a prominent physical manifestation of their faith. Do you have any insight that you can provide to us briefly and then more fully on
We'll
notice?
take it on notice. Thank you, Senator. So if you could provide that information on notice, please.
Thank you, Michelle.
Thank you for appearing before the committee and for giving your time today. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business on the 20th of January.
Thank you.
I now welcome representatives of the Australian Association of Heads of Independent Schools. I understand that information on parliamentary, well, I'm assuming they're online. They're here. Excellent. Would you like to come forward? Thank you. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Before we begin, could I ask you each to state your name and the capacity in which you appear for the benefit of the Hansard's transcript?
Beth Blackwood, and I'm CEO for the Association of Heads of Independent Schools of Australia.
Chris Ivey, I'm the chair of the board of AHESA and also principal of St Andrews Anglican College in Queensland.
If you've provided a written opening statement, would you like it to be incorporated into the Hansard transcript?
Yes, please.
I'll now invite members of the committee to ask questions, and I will go straight to Senator O'Neill, seeing as how I cut her off.
Thank you very much, Chair. Could I just thank you for your submission and for the work that you do in the community and for supporting people of faith who seek that opportunity as a basic human right in terms of the determination of their children's education. It's important for so many of us. But putting aside your concerns around the controversy around this legislation, which I think many of us would understand and share, do you support the bill in its current form? And I'll just ask you to put that on the record straight up.
Well, we fully support a move to protect religious freedoms in Australia, but no, we do not fully support the bill in its current form.
Mr Ivey, did you want to make a comment?
No, I would agree that our belief around protecting the individual's capacity to make those choices, yes, but the bill in its current form, I think we believe needs some further thought.
One at the same time as the amendments to the Federal Sex Discrimination Act. Yep.
That's correct.
Yep.
So you were here for much of the evidence of the previous witnesses who described recent activities where there have been an increase in conflict perhaps in schools, and articulation for more vivid expressions of faith in the context of this bill and the two previous bills and the marriage equality. This must be very damaging in the context of the schools that you represent, this ongoing uncertainty of promise and not actually getting anything. So where are you right now with this bill? Do you think that this is going to settle things in a way that will be advantageous for the provision of faith and faith education for your sector, at the same time as balancing that off against other important human rights?
One thing I would say as an opening statement, I think given that AHESA actually represents such a broad spectrum of schools, I think the bill in its current form won't necessarily alleviate some of those concerns, particularly for some of our schools who perhaps sit on the more extreme side of Christian schools. But Beth, you might want to...
Well, I think that's an important point, that we have a diverse range of schools that we represent from, that's inclusive of Islamic and Jewish schools as well as different denominations of Christianity. So for many of our schools, this bill would sit comfortably with them. But for some, no, it won't sit comfortably. And we are concerned, primarily we're concerned about social cohesion and social cohesion more broadly of Australia. But this particular act has proved itself to be very divisive. If you read through the various submissions that are made, you have diametrically opposed views. So one of our primary concerns is around social cohesion. So we feel the bill has already been 3 years in the making. Rather than have the interpretation of it enacted out in courts of law and perhaps even amended in the light of the review of the Sexual Discrimination Act, we would rather defer the passing of this bill until those matters have been resolved, the matters of concern have been resolved. But more importantly, we think that there should be an opportunity for more dialogue, for those who have concerns to be heard, for such scenarios to be perhaps included in the Memorandum of Understanding of the bill. However, we also recommend that an important symbolic act to show the importance of religious freedom and diversity in Australia would be to uncouple the appointment of a religious discrimination commissioner from this Act, create another Act that would set up that office, and that office could, as I said, symbolically show the importance of this Act, but it could also be working towards resolving some of the concerns and issues that bodies have with regards to the legislation.
So, in essence, despite the many promises and delays of this bill, your core view is that it's still underprepared and likely to be more problematic rather than resolve the issues that you're aware of in the sector that you represent.
Yeah. That's true. We think it'll be piecemeal.
It's piecemeal, okay. Could I go to one of the controversial things that you have alluded to in terms of very different views? Because we'll receive evidence very shortly, I expect, saying that there's great support for the state and territory anti-discrimination laws to be overridden. Do you have any concerns about that? And do your members hold a uniform view on that issue?
I don't think our members hold a uniform view on that position, no, at all.
No, we're aware that it's an arena for conflict, but we've not got legal minds to put to those issues. But the fact that it is an area for conflict encourages our perspective about delay, so those issues can be resolved ahead of the legislation.
So, given the precarious challenges to the education sector across the entire world right now with the COVID reality, schools are facing all sorts of uncertainty. It's been put that in order to prescribe a state or territory law by regulation, the Attorney-General has to be satisfied the law prohibits discrimination on the ground of religious belief or activity and prevents religious schools from giving preference to persons who hold or engage a particular religious belief or an activity on employment ground. If the Attorney-General does that and prescribes a state or territory law by regulation, does it concern you that a state or territory parliament then might simply circumvent Section 11 by enacting a new law, further adding to what you've described as a sort of a parlous state of discontent that's brewing in this space? I appreciate your comments rather than my words there.
Yes, it does concern us. And it continues to politicise the issue of religious freedom, in that the issues are then determined through the courts and through the media. So our concern is such that we'd rather see those issues are resolved prior to legislation rather than tested in either the media arena or the courts.
You've alluded a couple of times now to the courts, and I think a lot of parents who'll be, sending, hopefully get their kids vaccinated and then sending their little ones off to, the school that they've chosen that aligns with their faith view, whether they are people of faith or not. They'll be ready, getting their shoes and getting ready for big school, as we talk about. They'll all be ready to start that journey. Does it concern you that parents who have this sense of order and certainty for their children and hope for that could end up in a situation that's been described as procedurally unworkable, with schools being caught up in litigation for a period of time until this novel model of lawmaking is actually tested in the courts? And what would the impact of such sort of lawyerly activity be?
I'm not sure. I can't speak, Beth. The impact, as we said at the beginning, I think given the diverse nature of our schools, I think the impact, if it got to the point where situations found themselves in court, we are probably talking, from our membership, around a relatively small percentage of our members. For the majority of our schools, the reality is that we don't believe that necessarily those things would be tested with the majority of our schools. We're probably talking about, as we've said, some of those schools where for their particularly Christian or Sikh schools where that might be tested. So for most of our parents entering our schools, sadly, the reality is I don't think they're choosing. We know they're not choosing our schools necessarily because of the faith. They're choosing them because of the values, because of the expectations, which are underpinned by faith, obviously, but they don't necessarily put those two together.
Thank you, Senator.
Thank
Might
you.
move on.
Yeah, if I can ask one more question, because you just alluded recently to the fact that you cover Islamic and Sikh and Jewish schools as well. You heard my question on notice, I'm assuming, which is really, identifying that young people, particularly of those more minority faiths, are subject to discrimination, up to 20%, as recorded in the longitudinal study of Australian children. 1 in 20 Australian children experiencing discrimination on the basis of their religion. Do you have a perspective to enlighten the committee about the risk to students if protections for religious identity are not provided by the legislation? Is there some embedded risk for those schools and those students?
Look, I think it's always a concern, intimidation of any kind or discrimination. Some of our research shows that within our schools we also have students who are intimidated on with regards to LGBTQI plus status. So our schools are really concerned about all those issues where there's discrimination against students, be it religious or be it based on other characteristics.
Age.
And, the majority of our schools are concerned to create caring, inclusive environments and work very hard towards achieving that.
And that's supported by the IEU data that they reported in their submission. Thank you very much, Chair.
Thank you, Senator. Senator Small, I believe you've got some questions.
Yep, thanks very much, Chair. Just checking you can hear me.
Yes, we can. Thank you.
Yeah, perfect. Good morning, folks. I just wanted to explore the issue of delay in consultation on the bill. Obviously, we've been through a number of iterations, and in your testimony just then, you mentioned, we've had more than 3 years of development. And yet, I guess, from the perspective of your member schools, I'm sure that they see the glaring gap in federal discrimination law, which currently protects attributes like sex, race and age, but doesn't protect discrimination against holding or not holding religious belief. Fundamentally, and at the essence of it, does your membership want to see a religious discrimination bill passed?
Yes, we do.
Yeah.
We fully support the notion of a religious freedom bill.
Yeah, and I caution it is a religious discrimination bill rather than a religious freedom bill. I think that is, I know it's, it's words, but words are very important in this context. In terms of calling for the explanatory memorandum to be expanded or in some way more comprehensive, can you explain specifically what areas you think need to be more detailed?
Well, it would seem in the submissions that have been made, and was at the there was a reference just previously to claims of teachers losing their positions within schools based on divorce or such circumstances. It would seem that many of those areas that schools have been accused of being discriminatory towards, those groups that have been discriminated towards, have not been fully covered in that memorandum. So we would be recommending that you take some of those scenarios that have actually been included in the submissions and tease them out with regards what it would mean, this bill would mean in those situations.
There does seem to be a concerted effort to undermine the bill by conflating issues that are rightly dealt with other discrimination legislation with this particular proposed legislation. So let me ask this, because I think this is a really important point. Does your organisation believe that educational institutions such as independent schools should be able to preference staff that adhere to the same doctrines and beliefs and values of the school community?
Yes, we do. We think that's an important part of ensuring the culture, the ethos, the beliefs and the values of that school.
Absolutely, and I think that's what needs to come out clearly, because that is certainly the intent of the legislation, is that it provides the ability for schools to uphold the ethos and values of the school community, and that's certainly, I think, important to call out clearly. Can you provide any insight on how many or what proportion of independent schools would align with a particular faith?
Around 80%, I think.
80%.
The schools themselves would be affiliated, not the staff, but 80% of our schools would align themselves with some form of faith-based faith.
But not staff.
Not staff,
Schools,
with
not
a school
staff.
entity. Yeah.
Thank you.
Yep. No, that's well understood. And just for clarity, then, how many schools does your organisation cover? Just to give that number some meaning.
455.
450 approximately schools, and that represents around 440,000 students.
Righto. Okay. Thank you very much. That's useful. Now, there's obviously been, and I know this question was put to the previous witnesses as well, some concern over the override provisions as they relate to state and territory legislation. So I guess the bill that's proposed does not provide that the bill can override or exclude or limit the operation of a state or territory law to the extent that it is capable of operating concurrently with this bill. And I emphasise the point that I made earlier, that others are seeking to undermine the whole premise of the religious discrimination bill for their own agenda. So can you explain why it's of concern to your organisation that the federal override, limited only to the extent that state and territory legislation conflicts with this legislation, why is that of concern to your organisation?
I'm not sure.
Well, one of the reasons for concern is that education is a state jurisdiction, and so our schools report directly to the bodies within each state, and in fact their registration is dependent on whatever the processes might be in that particular state. It's not federal legislation. So that creates a possible area for conflict that makes us believe that those issues need to be resolved ahead of this bill, not after the fact.
So I get that, but I guess this is an important point I'd like to point out. Noting that this is limited only to any conflict with the religious discrimination bill and the protections that it affords, for instance, schools of faith, some 80% of your members, to uphold their values and their ethos. That protection is obviously fundamental to the existence of your schools as you would want them to be. So are you effectively putting to us that you're worried about adverse action from or some sort of intimidation from state governments who have a different agenda and would seek to undermine that religious faith, values, the beliefs, the tenets and whatever that you uphold in your school community?
We believe that's the potential for that is there, yes.
Is your concern about school registration?
Well, that's...
Sorry, Senator Small, could you hear Senator O'Neill?
Sorry, I was just clarifying, Senator Small, is your concern about school registration? And the answer?
It's around clarity.
Okay.
It doesn't... Impacts of faith and discrimination don't impact on registration of schools per se from a state point of view. So no, it's not so much about registration. It was.
Over to you, Senator Small. Last question.
Thank you.
Yeah, thanks. Well, maybe just to finish off on this point, because I think, I'll leave that. So I guess what, with the other review processes that are already underway and have been discussed to some extent here, what value do you see in delaying the passage of this bill when it's of obvious importance to not only the, some 80% of the schools in your membership, but also those Australians who choose not to practice a particular religious belief and should therefore be protected against discrimination for that choice equally. I just don't see why we could call for delays on any legislation because someone of the 26 million odd Australians isn't happy. But this was a clear promise from the Prime Minister that we owed it to people of faith and people not of faith to give them a shield against discrimination. So I guess why should we delay?
I guess our concern, Senator, is as Beth has explained, is just in what that would look like in terms of some of the scenarios that we think may happen, and the union earlier mentioned some of those scenarios that have experienced in the past, just to see what that would look like. So it's really to ensure that there is some sort of cohesion and in that process of ensuring that we have some clarity about what those situations might look like at the end. Do you want to?
And if I can quote the Prime Minister in correspondence to us, he states that, like us, it's his strong preference not to see this become a divisive issue in our country. And our concern is that there's a potential for it to be divisive, as demonstrated by the submissions that have been received. So we would rather, as we've stated, delay the bill to address the issues of concern that are there, to open dialogue and to hopefully move towards a more cohesive approach to religious freedom, discrimination and diversity within Australia.
Thank you.
And the union just clearly stated they would seek that this bill never be passage into law in any version. So, yeah, that's a great optimism. But thank you for your evidence. Thank you, Chair.
Thank you, Senator. Mr Graham Perrott, Deputy Chair.
Thanks, Chair, and thank you for your submission. And Reverend Ivy, can I particularly thank you for giving up time on the Sunshine Coast to come to Canberra? So,
it's raining up there.
well, I'm sure Peregian, even on a rainy day, would be a very nice place to be. But further to Senator Small's question about your concerns about the bill and that fear of litigation flowing from it, as it is currently drafted, and you suggest expanding the scenarios in the explanatory memorandum to avoid unnecessary litigation. Could you give the committee some examples of the scenarios that you think should be included? And I take on board your concerns about delaying it until the Federal Sex Discrimination Act amendments are dealt with. But could you give me a couple of the scenarios?
Let's say our lived experience is that it is very unusual for a school to discriminate against either a staff or a student on either religious or sexual grounds. It is very rare. In fact, the only cases...
Could I just clarify, you don't cover the Christian schools?
Yes.
So the Christian Schools Association of Queensland, are they under... I think they're in the same building as you?
Many of them are our members as well.
So they might be in both of those organisations.
So we are representing some of those.
But not many Catholics as a rule?
No.
Standalone Catholics, not systemic.
No systemic Catholics. So the Marist colleges and the grammar schools so the secular schools as well. Sorry, I just wanted to get the flavour. Thank you.
So it's our lived experience that very rarely occurs, and in fact our experience of it is more through the media than through our own experience. But it would seem from the submissions that have been provided for this review that there are lived experiences of discrimination, and so we would look to those examples as
I'm not sure if you heard,
examples for the memorandum.
I'm not sure if you heard my question to the Independent Education Union, but it was about the principal setting the tenor of the school, and I guess you guys would sign off on that, as I say, looking at a principal in the eye. But perhaps a vocal board member can really set the tone of what they believe the tenets of that faith are. Okay.
And that is probably stronger in some of those Christian schools, where the board is predominantly made up of those of a faith, whereas not all of our schools would have boards that are controlled by necessarily people of faith.
Yeah. Okay. So I want to take you to the Statement of Belief provision, section 12, and your submission said that clause could be amended to cure your current concerns. Would you like to respond to that? Sorry, the Independent Education Union has suggested that it be amended, not you haven't suggested that. So.
But putting words in their mouth.
I beg your pardon.
If I could assist, Mr. Perrott,
Yeah.
I think it's in your submission on page 5. You state that it's not appropriate with regard to statements of belief. It's not appropriate that magistrates or judges are left to interpret what constitutes a religion. You also make a point about the shift of focus to an individual's genuineness in regard to a statement of belief. So perhaps you might want to comment on that part of your submission.
I think that's where we're seeking clarity, and that we feel that statement of genuineness adds a measure of ambiguity to the bill and could be challenged. That's and so it may be that if it is challenged, that it's the courts that are determining what the definition of religious belief or activity is, rather than this bill.
Which is going to be fun times for constitutional lawyers and the like.
Indeed. Lawyers will win.
And my final question, your submission agrees that a publicly available employment policy is important. Does the association have a view on the power given to the minister in section 7, subsection 7, to determine the requirements of that policy?
Again, we would prefer clarity within the bill as to what that policy should be, rather than it be at the whim or the wish of whoever may be minister at the time to interpret that.
Are you saying you don't have complete faith in the abilities of the ministers of the Crown? I find that very hard to believe.
I have enormous respect, but you may get differences of opinion between one and another.
Better legislation and less regulation. Yes.
Okay. Sorry, my final question. And I'm more familiar with the Office of Non-State Schools in Queensland, so I don't know the other states and territories, Ms Blackwood, in terms of going to Senator Small's question about how registration might be impacted on. I thought they were a light touch in terms of administration of schools in the independent sector?
Look, they are. I guess I refer to that just in terms of those tensions between state and federal, and particularly when it comes to education, that states tend to jealously guard their responsibility for education. So if you're setting up conflict between a state law and a federal law with regards to education, it may not affect registration, but it may impact on...
I'm just trying to tease it out a bit more, and it's just you and I here talking, but, so federal money, some state discrimination laws, some, federal curriculum, mainly, with some supervision from states, shall I say? So, would you like to make comment on that as someone at the coalface, Reverend Ivey?
Yeah, that goes to Beth's point. I think that ambiguity around, in answer to your first question in relation to registration, it is becoming less of a light touch, particularly around child protection. So that's just as an aside.
Very good example.
And I have seen some schools where registration has been removed for lack of clarity on curriculum. So they are actually making greater inroads.
Okay.
But there will be...
That's a perfect example.
They don't touch on employment or faith at this stage, but that who's to say that won't come as part of their remit.
Exactly.
So in terms of compulsory reporting child abuse, that wasn't a case 5 years ago in Queensland?
10.
10 years ago in Queensland. So that's a change. That's
Absolutely.
where the state has intervened, I guess.
Yep.
Okay. All right. Thank you, Chair.
Thank you. Senator Rice, did you have any questions?
Thanks, Ms Blackwood and Reverend Ivy. Mentioned before that for some, basically you're saying this should be delayed, there needs to be more work, and for some that this legislation, this bill won't sit comfortably. Could you expand on, what the concerns are and so just summarising what the risks would be if this bill was passed in its current form?
I think one of the risks is the review that the Law Commission is undertaking with regards to the Sex Discrimination Act, and that review, the two need to be consistent with each other. So one of the concerns is that they may not be consistent with each other. So the delay that we're recommending is in part to wait and see how that unfolds and what the intersect of each different form of discrimination in Australia and the laws that cover it might mean for this particular bill. So that's one delay. The other concern, as we say, is that seeking greater clarity around some of the definitions and some of the conflicts with state legislation. So it's deferring it to resolve that. But our primary point is around social cohesiveness and giving an opportunity for dialogue and to seek some. Sometimes it's about being heard. There may not be any resolution of these issues because we've got people on different ends of the spectrum. But being able to be heard, to know and to understand what all the issues are and work towards resolving those. And that's why we think making that appointment for a religious discrimination commissioner would play an important role in enabling that dialogue.
So in terms of having that sort of, a coherent framework so that we're looking at the issues of sex discrimination at the same time as we're looking at the religious discrimination, do you think that it's the conflict, I'm just interested in your views of, if the school has in their statement of, their statement of policy as outlined in this bill that, that it's incompatible with a teacher, even if they are of that religion, to be in a same-sex relationship or to be divorced or anything. Do you think that it should be appropriate for people to, for schools in those circumstances still to be able to sack staff or to expel students who say, transition their gender identity?
To date, I'm not aware of any school that has ever expelled a student in our schools for transgender issues.
I think they've been, as we discussed earlier, resolved pastorally in that they've been very much encouraged to move on.
Staff or students?
Students, absolutely. In previous hearings, we've had plenty of evidence of that occurring.
And it's that maybe the schools that we represent, I'm not sure. My comment to that, Senator, is I think there are some in our organisation. There are some in our organisation who would value that capacity to respond to staff who are unable to uphold the particular religious beliefs of their faith. But I don't think, and Beth can correct me on this, I don't think that's necessarily the majority of our member schools. The majority of our member schools are fairly tolerant or liberal in a sense of who they employ and the grounds on which they employ them. I think it'd be a fairly small. So do I believe that a small minority should be able to do that? Yes, I do.
We do believe the school should be able to employ members of staff that are willing to accept the ethos, values and faiths of that school. And I think the policy goes a long way towards resolving that issue. If you know at the time that you are employed, these are the expectations of your employer, then that goes a long way to resolving those issues. And by and large, people are not comfortable working with an organisation that does not accord with their own values and their own beliefs. So I think By and large, that's what we see unfold in our schools, that there is that cohesiveness, and that it is, as Chris says, very rare that there are conflicts with regards to faith. Where you have a staff member who is undermining the values and the ethos and the faith of that school, then I think, given that the policy clearly states what those values, beliefs and faith expectations are, then they should have the right to resolve that issue with a staff member.
That you received at employment.
Absolutely.
Yeah, that you signed up.
What you signed up to.
Absolutely, yes.
But I think a lot of the issues are that there is a statement of policy that they feel they've signed up to, and they are of the same faith at that school, and then they find that there is sort of the fine print or the footnotes or the things that actually aren't explicit that are then brought to bear.
That's, Senator, exactly, because as Beth said, what would need to be clear is that policy that sits behind that, and that goes back to our concern about the minister's sort of. We would think there needs to be some clarity around what that policy looked like to protect both staff and staff and employers.
But of course, we live in a very complex world.
May I ask supplementary to that what the association makes of the changes in Tasmania in relation to providing laws that say you've got to be, you can recruit on the basis of that, of your religious ethos, but not discriminate based on other attributes post that recruitment?
We're not legal experts, and so we don't have a full understanding of the Tasmanian legislation, so we'd take that on notice.
If you could, please, that would be terrific. Thank you.
Thank you.
Thank you.
Thank you very much. Thank you for appearing before the committee and for giving your time today. And there is one more question on notice.
Thank you very much. So on the 1st of December, a number of Liberal backbenchers, including Katie Allen, Dave Sharma, Angie Bell and Fiona Martin, announced that the Prime Minister had done a deal to repeal Section 38.3 of the Sex Discrimination Act in exchange for their support for the Religious Discrimination Bill. But there have more recently, been suggestions that the Prime Minister has backflipped on that deal, or perhaps he hasn't. It's a little difficult to be clear about exactly what's going on in that space. What's your current understanding of the government's position with regard to Section 38.3 of the Sex Discrimination Act, and do you support that section in its current form, or would you like to see it repealed or amended on notice? And the Secretary will send that to you, but
we'll take that on
we are
notice.
Really interested to find out where the truth lies in the middle of all of the reportage.
Thank you.
Thank you.
The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business on the 20th of January, not long. And thank you. The committee will now suspend hearings for morning tea and phone calls and all those things that we do. Thank you.
And thank you for the
Thank you.
opportunity.
Very well. Appreciate it. Thank you.
So we will resume the hearing. I now welcome representatives from the Australian Catholic Bishops' Conference. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Yes. For the Hansard record, could each of you please state your full name and capacity in which you appear today?
Peter Andrew Comensoli. I'm the Catholic Archbishop of Melbourne, appearing here as a delegate of the Australian Catholic Bishops' Conference on matters of public engagement.
Thank you.
Jeremy Stuprich, Deputy General Secretary, Australian Catholic Bishops' Conference.
Thank you.
And Rock Reynolds, I'm a Professor of Law at AC, Australian Catholic University.
Lovely, thank you. If you've provided a written opening statement, would you like it to be incorporated into the Hansard record?
Yes.
Thank you. I now invite members of the committee to ask questions, and I'm going to start off with you. Can you explain your position and why you believe the bill is compatible with Australia's international human rights obligations?
This particular bill, in a sense, completes a suite of the various acts of discrimination that already exist. So the original ones around race, around disability, sex and ageing. I think ageing is the most recent one. And this, in a sense, completes that suite of the obligations that Australia holds under the International Covenant on Human Rights. And therefore, in a sense, this is bringing us up to speed with all of the various human rights elements.
How many Catholic schools are there in Australia?
Oh, in Australia specifically, 1,755.
And approximately how many students is that?
Oh, well over nearly 770,000.
770,000.
And
teachers?
about 100,000 teachers.
100,000. Thank you.
Thanks for those.
Do you believe they have the freedom to make decisions in line with their ethos currently?
We're talking students, staff, schools.
The schools.
Schools. At the moment, in part, not fully, in the sense that each of the jurisdictions within their various states which govern the registration of schools, and has come up already in conversation I heard earlier on, there is the requirements that are for each of those states that need to be for registration of a school. We have had, in my experience in the Victorian context, very good relations with VRQA, and that is an ongoing and productive process. Where there are areas of improvement, I think, are in allowing always for our schools to be able to function according to mission and values. This helps in that regard.
The bill, yes. In your submission, you draw on parents' rights to send their children to the school of their choice. Can you explain how parents' rights could be affected if the bill is not passed?
More about how other bills might influence that. We have situations in the Victorian context where certain bills are already limiting the way in which parents might choose for the values of a Catholic school. I'll talk specifically about that. I leave that for other denominations or other religions to talk about their circumstances. In the Catholic school context, parents are certainly wishing to be able to receive a good education within the context of the Catholic faith and its tenets and its beliefs, and also in terms of its culture, that a school might develop a good Catholic educational culture. And so parents are looking for that. If there are impositions from perhaps state regulation or even federally, not that it exists at the moment that I'm aware of, but if that was to occur, then those desires of parents, and I would argue a right in terms of being the first and primary educators of their children, parents, that they would be able to exercise those as best as possible.
Thank you. Can you provide examples where a Catholic school has been unfairly treated because of the ethos they hold? So you alluded to some of the Victorian potentially.
There might be situations where certain pieces of legislation come into play, and if they then require schools to act in a certain way, that might be contrary to their tenets and beliefs, and that would be problematic.
Have you got any specific examples that you could give?
There is a new bill that was passed in Victoria at the end of last year. I'm a little hesitant about talking in detail about this because we haven't yet done the legal examination of it, and that needs to happen. But that Equal Opportunities bill that came in at the end of last year is an example where an inherent requirement for faith is required for the employment of certain people and their ongoing employment as well. So that needs to be examined quite thoroughly.
My final question, do you believe educational institutions should be able to preference staff that adhere to the same doctrines and beliefs of the school?
we have always sought to employ those that will follow the mission and identity and values of our schools. That has always been the case, and we will continue to do that.
Thank you. Deputy Chair.
Business, isn't it, really?
Sorry?
It's the case in every business, isn't it, really?
Indeed, or any political party.
There's a values
may I say.
alignment, yeah. Thank you.
Thanks, Chair, and thanks for your submission, Your Grace. So my question is, the Australian Catholic Bishops' Conference submission favours the Commonwealth Bill prevailing over inconsistent state or territory laws, and you touched on the Victorian legislation, but you note that the bill, and I quote, does not displace the operation of other Commonwealth anti-discrimination laws. Can I just draw your attention to section 12, the statement of belief part?
Yep.
And do you agree that that section does displace existing Commonwealth anti-discrimination laws, such as the Age Discrimination Act, the Disability Discrimination Act, the Racial Discrimination Act and the Sex Discrimination Act? I'm not sure whether Professor Reynolds wants to take that one.
Yes, as a legal statement, that might be
Yes,
best
in
if...
terms of the statement of belief, we understand that.
So,
in relation to the statement of belief, yes,
oh,
this
okay,
does
okay.
specifically displace those.
So, just want to thank you very much, Professor Reynolds, for clarifying that. And your submission expresses concern about the minister having power to make requirements about a religious institution's public policy. Could you explain why you're concerned about a minister being granted that power?
This comes down to a matter of a religion or an institution with religious values having a better sense of its own policies and understanding and values than...
Are you putting the Pope before the Minister of the Crown, Your Grace?
I'm not Thomas More. Okay. Or in that case, St Fisher. But I think there is a serious question around when a commissioner, whoever is likely to be a political appointment, is making judgments in areas that may not be their areas of expertise.
Is your concern about the commissioner or the minister? Because I would suggest that our commissioners, on the whole, have not been embedded in the politics of the party that they might have had connections with. And I know that many...
Yes, and that's been something of the pattern. You're asking, Mr Perrott, a rather broader question, I think, here, because we have, as part of our history now, commissioners. A commissioners in particular areas. So that's become the way in which these sort of things would be dealt with. We could have a broader discussion around whether there is a need for commissions and commissioners, but I think that's not necessarily the point that you're wanting to get at.
But, just to be clear, you support a religious commissioner? We
are open to having one.
Yeah, okay.
I think the discussion would be about who.
To complete the... okay. The Australian Catholic Bishops' Conference submission also raises a question about how the law, once it is passed, will apply to existing employees in terms of the necessity to have a publicly available policy.
Yes.
Can you explain why that might be a concern for Catholic institutions?
You would have any number of people perhaps employed at different, under different categories then. So someone who's coming in now would be employed under this particular stated policy and mission and so on.
And would have signed on for that at the principal's
different
desk
people would be signing off to different things. And just for employment cases, as you can imagine, that makes things somewhat challenging.
Okay. And the cleaner at the hospital is maybe different to the Catholic education teacher in the school?
Well, as you know, the legislation as it currently is being phrased treats things around hospitals, aged care, residential care differently from the education question.
Okay. All right. Thank you very much, Chair.
Okay. Thank you. I believe Mr Ms Hammond, Celia Hammond, is ready for some questions.
Thank you, Chair. Thank you, Archbishop and members of the ACBC. I've got a first question. A number of our witnesses this morning referred to pastoral discussions being held, and I interpreted them, it may not have been intended that way, but the phrase was used in a sort of dismissive way. You know, pastoral discussions with staff, you know, they referred to it as, you know, matters don't get aired because there are pastoral discussions held. Do Catholic organisations engage in, what would be your understanding of a pastoral discussion in relation to, say, an employment matter?
Thanks, Ms Hammond. I'm not sure of the particularities you heard earlier on. I didn't hear those, so I'm not quite sure what the debate was on. If I can just try and touch on the point about what are pastoral discussions might be important. I would say that any good HR operation is going to be pastorally attentive in the way in which they go about having conversations with staff around their employment. The word pastoral, I'm a little bit hesitant about using because it's interpreted in so many different ways. But what might be a naming of something that is pastoral is that if you're dealing with matters just by, say, for instance, curt emails, that is not a pastoral way of handling matters of perhaps of dispute. So a pastoral way would be dealing with it in ways that are inviting of contribution, of hearing the various perspectives, and of then dealing with those things in that sort of way. So if you're talking of pastoral in that sense, then it ought to be happening everywhere,
yeah. And
in every situation.
Yeah, in any sort of dispute. If it's conflict between two staff members over, you know, as happens in all workplaces, if there's conflicts, that it should be dealt with. So your reference to pastoral, thank you very much for giving that broader overview. I think in your submission you say that having a religious discrimination bill and giving Catholic organisations or any religious organisations the ability to employ according to the ethos of their organisation is important. Can you explain why it is important to be able to employ people in accordance with the ethos of an organisation, from your point of view, from the Catholic point of view?
Yeah. So we approach whether it's within sort of welfare services or health services or direct faith services or educational services, we approach that from the perspective of what our understanding of the human person is. That's informed by our beliefs, it's informed by our teachings, it's informed by our culture and practices. So to bring that, in a sense, it's a proposal. We propose, we're not imposing, but propose, and people can be a part of that if they wish to or not. So that sort of sense in which to develop an ethos that is something that people can understand and accept or not, then becomes something that is available for them. Some of an area which I just mentioned is in terms of some services that we provide, which would be provided differently by other organisations in a similar sort of area. But if people are knowing that this is where we're coming from and this is our perspective on, and we carry with it a certain sense of the positivity of the human person, then there's an openness then to them understanding what they're involved in.
Right, thank you. Do you believe that this bill will enable a school to discriminate against potential candidates to maintain its ethos?
Candidates, are we talking employment? Are we talking students?
Employment.
Employment, so staffing. Well, in any organisation, you're going to be employing according to, is this person going to uphold the values and standards and mission of this particular organisation, whether it's religious or not religious, whether it's political or private, whether it's corporate or educational, whatever. That's what you would expect, generally. And you would employ accordingly. We do the same.
Okay. Yes. Okay. Do you have examples of... Oh, sorry. Do you think that this bill allows religious organisations to discriminate on the basis of attributes other than religious belief or activity in accordance with their religious beliefs?
Can you just flesh that one out a little?
This is an example.
Well, I guess religious beliefs and values, all religions, you know, there's similarity between a lot of religions on a lot of matters, but often on questions of morality or personal morality or personal actions, there can be differences. And so let's take, and I've used this previously, the question of divorce. If somebody who is Catholic who is divorced, do you think that this bill enables, that distinction, the distinction between somebody who supports the ethos but may not actually adhere to all of the teachings of a particular religion?
So more generally, if I can answer this more generally, because I think we're starting to getting into categories of people's is not a good way of thinking about employment, I think.
No.
You're employing an individual, a person, according to what skills and capacities and commitments they might have. They're the things that matter, I think. So conduct more than attributes. Character more than characteristics. These are the things that matter, I think, when you're considering the employing of someone and the ongoing employing of someone. By way of their conduct, by way of their character, will show their capacity to be able to undertake the work, or whether they're working within the context of the mission of the particular organisation. Less so, those rather than attributes and characteristics, which then define people into categories, which is not a good thing.
Yeah, okay. Someone once put to me that in a scathing sort of way, that sort of approach, and not in a challenging sort of way, does that approach lead to a don't ask, don't tell mentality? And is that actually healthy or good?
Again, that's a kind of, if I could be so bold as to say, it's somewhat of a generalisation.
Yes, it is.
What is the situation? What is the situation? So I keep coming back to what is the situation in regards to this particular individual in this circumstances in their particular employment. To then take that into and making it a generalisation over a particular tag or attribute or so on is, I think, problematic.
Could I add one little thing? Sorry, it's Rock. I think the policy is designed specifically to get away from that. So if we're acting in accordance with a public and transparent policy, it does overcome this don't ask, don't tell mentality. And you're right, it probably is not healthy. And this bill, I think, addresses that in a really positive way.
Okay. And so, Archbishop, I think your main message here is that this bill actually, the way it should be interpreted and applied is that it's at an individual level. So this bill will actually enable Catholic organisations, particularly Catholic schools, for example, to have that look at the individual and be able to take that all into account. Is that the point that you're making?
I'm making that point in terms of your last question. The bill itself is much broader, obviously, and the bill, if I come back to an initial point, it brings parity around, all the other discrimination bills. So I think that's important, and it brings a possibility of a protection rather than as distinct from exemptions and exceptions, which is the way in which these sorts of things are handled at the moment. So they're handled in a moment in a rather negative way. This provides a positive footing.
Okay, and so just to clarify that point, at the moment, protection of religion is by way of exemption to other discrimination laws. Yes. Is actually saying effectively that religion is a right just as the other rights are.
Well, the holding and the living by and the organising according to faith is the right that needs to be protected.
Okay. May I ask a supplementary question here, please?
Where's that coming from? Sorry.
Senator Pratt.
Senator.
Oh, there. Hello, Senator.
Also from Perth.
I understand the point you're making in terms of the new protections in this bill, but what does that do, therefore, to the existing exemptions? Could one of the amendments we consider be the removal of those exemptions so that we can focus on that positive footing, so that we're not trying to deal with both legislative intentions, if you like, because it seems difficult on one point to be able to say, well, these are the these are the proactive points that we would like to consider in the merit of someone's performance or their candidacy for something, and then have a kind of catch-all that pushes in the opposite direction, if you like.
I think the challenge there would be that if it's just simply removing exemptions and what have you, you're not actually then providing something that recognises this right that needs to be protected, as it is done in the. Sorry, I missed that last bit.
I thought you had just argued that the bill does do that in a positive way.
Yeah, but I took your point as that. Why not just deal with the negatives? Wasn't that your point?
No. My point was, if you have the substantive parts of the bill, could we not therefore take the exceptions out of the Sex Discrimination Act?
Could I answer that? The Sex Discrimination Act gives exemptions on the basis of discriminating in relation to sex, sexual orientation, etc., whilst the Religious Discrimination Act is protecting on the basis of religion, and that's where you need the positive statement. It wouldn't help, otherwise you'd have to put positive statements about protection of religion. So this protects religious belief, not sexual orientation.
No, Archbishop Comensoli said that they would prefer the proactive nature of this bill that's before us in terms of religious protection, rather than the protection of those attributes by exception currently. So why do you still need the exceptions if you've got that proactive protection, is my question.
Because the exceptions relate to race, disability, gender, etc., whilst the positive protection is in relation to a particular positive protection of religious belief and behaviour. And obviously you wouldn't want to suddenly remove protections for other forms of discrimination.
No, of course I'm not arguing that. What I'm asking is in relation to exceptions in the Sex Discrimination Act.
Senator, I might invite Jeremy Stuparich to offer.
Senator, I think I understand your point, and you're saying that if the Religious Discrimination Bill is passed by the Parliament, why can't you also remove, which I imagine is Section 38 of the Sex Discrimination Act that you're referring to, at the same time? And I guess, given it's a complex area of law, the proposal is that goes before the Australian Law Reform Commission to examine the full implications of removing that, to make sure that there aren't any unintended consequences from that, and to have a considered process. And I guess the frustration so far has been that the Law Reform Commission has had to be sitting on its hands for the past couple of years waiting for this work to start. But okay, I guess there's a level of caution.
To clarify Archbishop Comensoli's statement about this bill being a better way of doing it when we still haven't dealt with that other legacy.
Okay, I understand better your point now. The legacy point does need to be dealt with. I would say that. There's the question about when that is going to happen, and I think that needs to be dealt with at the parliamentary level.
Okay, Ms Hammond, had you completed your questions?
Yes, I have. Thank you, Chair.
No worries. Senator Rice, did you have any questions?
I do, thank you, Chair. Thanks, Archbishop and Mrs Duprich and Professor Reynolds. Look, in your evidence just now, you re-emphasised, as in your submission, that you feel that religious organisations should have the ability to employ people according to the ethos of their organisation. And what I understand you to be saying is that as long as that's outlined in whether it's a policy statement or for a school or an organisation, that should be absolute?
Absolute.
That they should be able to, employ or not employ people according to the ethos of the organisation. So in terms of where that impacts upon people's other rights, that religious ethos should override all of those other rights.
In any organisation, whether it's a religious one or not, they're going to be wanting to employ according to and be able to do so. Not only wanting, but being able, free to do so. So this is, in a sense, just acknowledging that in this religious context, I think.
But I think the issue is where that religious ethos then impacts upon people's other rights to not be discriminated against, say, on the basis of their marital status or disability or gender identity.
Yeah.
So
and all those other parts of acts still apply.
Yes. But no, are you saying they still apply, or are
all the acts still apply? Yeah. Yes.
But in terms of the religious organisation saying, no, we're not going to employ you because you're an unmarried parent, for example. Are you saying that
we don't actually do that in our Catholic context, so I'm not quite sure the point in this context.
Well, my point is, if the ethos, say of a school and their statement of belief is that they don't support, having children out of marriage, that they are then able to say, well, we're not going to employ you because you've got children and you're unmarried.
And if that is their stated policy,
yes,
just as a political party would have stated policies that their staff would have to uphold. Then yes.
And so you're saying, and yes, so that is, as long as it's their stated policy, that's absolute. So if their stated policy is that we don't employ people who are disabled, which may be the case for some.
But that would then go against, and I think you'd be able to answer this for us better, that would then go against other legislation.
The anti-discrimination legislation still applies. This Act protects religious belief and action.
But if that's their religious belief?
The religious belief is probably not that we don't support, that we won't employ divorced people. The religious belief would be more likely to be around your statements about the sanctity of marriage, for example. And so certainly within the Catholic, that is why within the Catholic tradition we don't actually have examples, as I understand it, of not employing people on the basis of their divorce status, etc.
But other religions and other organisations may. I mean, can I take you to the example that was in the media a week ago, and I'm happy to table this. Oh, you've got copies of it? Great. About somebody who was sacked by the Church of Ubuntu because they were vaccinated. And so they were basically... A letter from the church's vice president said getting a vaccination was inconsistent with its religious teachings. It's the position of the Church of Ubuntu that to receive the COVID injection consciously and deliberately with intent is in contradiction with our constitution and contrary to our position on what is required of us by our Lord God and Creator. So you would support the position of the Church of Ubuntu to sack someone on the basis of being vaccinated, if that's their statement of belief?
I don't know what it is, so I'm only just seeing this now. So it's a kind of a thing that we can't comment on because we haven't actually seen this.
But no, point of order, Chair. I just think We have such limited time, and I think the Catholic Church represents so many people in
I'm-
Australia. Questions about the Catholic tradition would probably be helpful at this point.
I am
Senator
wanting
Rice.
to get the position of the Catholic Church because it
On
has
the-
implications. If this is the position if the position of the Catholic Church is, yes, we accept that if it's outlined in a statement of beliefs, well, that this is inconsistent with that statement of belief, therefore we can hire and fire you. Well, then that has got implications for the Church of
They can only answer
Ubuntu.
for their own faith tradition, not for another church.
No, but by supporting that, it has implications for all the other churches and faiths. And so I'm wanting to know whether the Catholic Church, by having that position with regards to your teachings of the Catholic faith, and whether because you feel that needs to extend across other faiths, that you would actually support the position of the Church of Ubuntu to not employ somebody who was vaccinated, to fire somebody who was vaccinated.
I think
If the,
Mr. Perrott
minister
was going to say
if the minister signed off on that
Yes.
being...
yes, if
Yeah.
the minister signed back, it's
Yes,
back
if
to
the minister signed off on that.
and the other provisions within
No, but it's
the
not if
other-
the minister signed off on it. It's if it's basically this legislation says if it's in the policy position of the organisation, it's a published policy, well then anything goes.
No, it doesn't. Sorry.
No.
It has to be related to a religious
The
belief.
tenets of that
And the
religion.
tenets and principles of that belief. The High Court has been very careful about examining what is a tenet and belief, and
Yeah.
it doesn't go to just personal whims or just any
It's not
sort of
personal
statement.
whims.
And
It's-
in
it's
fact,
a
the
tenets-
vaccination issue is probably not covered by any of the anti-discrimination acts at the moment. Maybe disability, but probably not.
Certainly the Old
And
Testament's a bit vague on
And I think it would be
vaccinations.
very hard to imagine that this is going to survive a court challenge.
But if you have got a statement that is, you've got a belief, and there can be some pretty interesting, belief systems and religions that if it's, as long as it's stated, saying here are the tenets of our belief, the position of the Catholic Church is that then it is acceptable to hire and fire on the basis of all of those statements of belief. Even if, they do include positions on vaccination status or that other discriminatory things.
I take it that's a statement from you.
Well,
we've kind of somewhat answered your question, I think.
Thank you, Senator Rice. We'll move to Senator O'Neill.
Thank you. Just before we move off the Sex Discrimination Act, we had the National Catholic Education Commission here, and Ms Collins expressed sympathy with the concern that the issues around students being discriminated against haven't been dealt with by the government, and that it's taken so long to get to this part of the legislation. And if suggestions for how they could be canvassed and progress swiftly, the Commission would be open to considering them as part of the current process. Is that the position of the Australian Catholic Bishops Conference?
If things can be progressed, yes, definitely.
And do you have any particular model or amendment in mind for how to address the concerns if relating to 38.3 of the Sex Discrimination Act?
Not specifically at the moment.
Yeah, okay, so if you want to take that on notice.
There are certainly some matters that we could take on notice in that regard.
So,
and to also note that these sorts of questions most particularly sit within the authority and the work of something like the National Catholic Education Commission or Catholic Health Australia, the various major bodies in that regard.
I guess we are focusing on the religious discrimination, but there is considerable interest in the intersectionality of the religious discrimination legislation with the Sex Discrimination Act. And you would be here when I asked my question about on notice with regard to the stated position of Liberal Party backbenchers who announced that the Prime Minister had done a deal to repeal 38.3 in exchange for their support for the Religious Discrimination Bill, but then it's been subsequently reported that that is not the case. Do you have any clarity about whether there is a deal that's been done regarding 38.3 with the Liberal backbench or not? Have you had any updates on that from the Prime Minister? Because the committee would be interested in the truth with regard to that, because it's contrasting reports.
Be able to take that one on notice, I think, to see what we can find out.
Thank you. Can I just return to the government's failure...
May I just, Senator, I'll just say one thing on that, so it's on record that from our perspective, we've been working very hard to try and find a bipartisan way through in all of this. Both leaders of the major parties are aware of the conversations that we've had to try and bring something around that. I think that's important to be noted, such that this does not become a political football, and that this can be truly seen as something that the Parliament of Australia might want to come towards.
Thank you. And I think the Shadow Attorney General, Mr Dreyfus, has put on the record very much how much the Labor Party has sought bipartisanship in the development of legislation, but it's landed with us, and we're doing what we can with it to try and find a pathway forward. So I want to come to some suggested amendments if you have any. Before we do, can I just go to the reality of the response to the Ruddock review? Mr Morrison appeared to rule out including a statement of belief provision, and committed to consulting with the states and the territories on any legislation. That really hasn't happened, and I think that this also interacts with the override dimensions of what's happening now in Victoria. So do you think the government's initial instinct to work through the issue of protecting statement of belief cooperatively with the state and territory governments is preferable to where we are, because it would avoid that procedural issue of the Law Council that they've raised with regard to Section 12? What's your view about Section 12?
Well, I've got other views around Section 12. In terms of the specifics of your question, I think we'd need to give that specific sense of how this might be handled by way of conversations with the other states. I think that needs to be thought through, and how we might want to offer a thought on that. In terms of Section 12 itself, I would want to say that having a statement of belief of faith is important, that might be a protection, but noting most particularly that that's not a free-for-all reality. It's being couched in language of condition, such that statements that are reasonable, and there's the question of the test of reasonableness in this regard, and I might invite Rock to say a little bit more about that in a moment, but there is also that these statements cannot be vilifying or threatening or and so on. So it's not as if a statement can be made willy-nilly or inappropriately or so on. It's a reasoned statement. And I might ask Rock if you might say something about the reasonableness test.
I think the reasonableness test is about codes of conduct and what an employer could do. So, as you know, the statement of belief is couched at a level where you can't harass, intimidate, etc. We think that's a good balance. It does, as you know, get rid of the provision about things being offensive, and that's because religions can have hard truths, and non-religious statements against religion can be hard truths for people, and people might find them offensive, but they're not intimidatory or threatening, etc. And we think the
or if they are, they should be treated as such.
Yeah, and we think the bill has found a good balance.
So the protection of a range of worldviews embedded adequately within this, provided this statement of belief comes through, is your view. You think that this is okay as it's drafted, doesn't require further amendment.
So we are now into questions on notice only, please.
Could you give consideration to concerns that have been raised about the Attorney-General's capacity to prescribe Section 18C of the Racial Discrimination Act if this were to come into play? There have been some concerns about 18C, if you could take that on notice. And also the question that I've been asking everybody is if there are further amendments you think that need to be considered by this committee, please bring them forward. Particularly, do you have a view about the override you expressed some initial views, but one of the concerns that I have is that in this contested space, which is now being sort of amplified, that there is tension between the federal government, which could prescribe a particular override, and then a state government respond in a tit-for-tat model of, well, you've made that change, well, we're going to make this change, you can make another change. And the impact of that in terms of the social cohesion of the country, the impact on a large institution that represents so many people of faith in the country, I'd be interested in your responses to the challenge that's embedded there in that.
Thank you.
Thank you, Senator. Thank you.
As well, please.
Yes.
Yes, and that was with relation to what's a hard truth versus what is a damaging or offensive and malicious statement. There are examples that have been put before the committee, and I'd like to get your response as to whether you think they are the sort of in the category of hard truths or the others. The patient with HIV who's told that AIDS is a punishment from God. A case in Queensland where a woman's employer wrote statements condemning her same-sex relationship in a book she was reading, and a taxi driver telling a person with a visual impairment that their guide dog was unclean.
Thank you. Thank you for appearing before the committee today and for giving your time. The committee requests that answers to questions taken on notice are provided to the committee secretariat by the close of business on January the 20th, 2022. Thank you.
May I just note that I will not personally be able to respond, but I'll ask others. I'll be overseas in that period.
No worries at all. Thank you very much.
Thank you.
The Secretary will provide the questions to you.
Thank you, everyone.
Yes, the Secretariat will provide the questions to you.
Thanks for the
Thank
time.
you.
Thank you very much.
Yes. Yeah, I was going to say, stay safe.
Safe travels,
Oh, yes. Oh, dear.
I believe that Pastor Michael Worker is on the line. Thank you. I now welcome representatives from the Seventh-day Adventist Church via video conference. Can I confirm that you can hear us?
Yes, good morning. I can hear you.
I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you.
Yes, it has.
Before we begin, could I ask you to state your name and the capacity in which you appear for the benefit of the Hansard transcript?
My name is Michael Andrew Worker. I'm representing the Seventh-day Adventist Church, and I serve as the Church's National General Secretary and Director of Public Affairs and Religious Liberty.
If you've provided a written opening statement, would you like it to be incorporated into the Hansard record?
Yes, I would.
I'll now invite members of the committee to ask questions, and I'll go straight to the Deputy Chair, Mr Graham Perrott.
Thanks, Chair, and thank you for your submission. The Seventh-day Adventist Church submission says that you would prefer amendments to the Fair Work Act to, and I quote, establish a nationally consistent principle with that contained in Clause 7 of this bill, to the effect that religious faith-based organisations may prefer to select staff who adhere to its faith and mission. Rather than the inclusion of Section 11 in this bill, could you explain why amendments to the Fair Work Act would be preferable?
The preference would be around ensuring that each of the relevant pieces of legislation speak to the relevant issues. And so employment as a faith-based organisation, we work within the context of the Fair Work Act, and it would be good to have clear statements included there that make it very clear that when the Fair Work Commission is assessing any claims, that it could be looked at in that context. And when it comes to statements of faith, when it comes to belief and ethos and values, that the Religious Discrimination Act, or we hope it will be so, is able to respond accordingly.
Okay, thank you. And you, the Seventh-day Church, your submission says in relation to Section 12, the statements of belief, that it is not clear that the provision changes very much. Can you explain why? And if it doesn't change very much, is the clause necessary at all?
Yes, I think Section 12 is very helpful in providing a basis for statements of belief, that they are fair and reasonable, that they are not malicious, they don't threaten, intimidate or harass. But I guess it provides limited provisions or limited increased scope and capacity to some of the provisions that already exist. But it is good to see it included within the framework of protecting against religious discrimination.
Okay, my last one, I just ask if you could clarify with regard to section 14. I think you suggest that the onus of proving a condition is not reasonable should be with the person who did the act and not the aggrieved person. Is that my understanding? Could you just tease that out for me?
Yes, as Seventh-day Adventists, we observe the Sabbath much in the way the Jewish faith does, where we refrain from secular activities from sunset Friday through to sunset Saturday. And one of the things that we often come across, and I often find myself providing advice and support to members, is where they feel discriminated against when it comes to Sabbath observance. For example, work functions, work events, other employment-based responsibilities. And trying to balance those provisions, our members would generally, in good faith, advise their employee, I'm not available to attend work functions and work events during the Sabbath hours because this is a holy day to me. And at the moment, should really be, it's an area where many of our members come under significant duress and pressure in being able to defend their right to honour and observe the Sabbath day. And really, the employer should have the onus to say, well, that's unreasonable, rather than the Seventh-day Adventist member continually having to defend their right to observe the Sabbath day. We find it occurs in employment relationships. We've certainly defended or assisted in the defence of a number of members whose employment has been threatened because of their observance of Sabbath. We also find it tends to happen quite a lot in the higher education sphere, particularly when students are undertaking advanced study, postgraduate study, and certain practical examinations are often scheduled on a Saturday. And some of those cases can take 6 to 9 months to resolve, cause a lot of emotional stress to our members, and requires a lot of dialogue, a lot of backward and forwarding. And we would like to see those positive protections built into the legislation.
So practically, if I'm running should they make that clear at the interview, or is that the sort of thing that would come up later? I mean, if the job is to work every Saturday, well, that's going to be problematic for Seventh-day Adventists, obviously. So would they?
Right.
Are you saying the onus should be on the employer to accommodate the faith of their Seventh-day Adventist employee, or?
And in many cases, it does happen that way. I guess another pressure point is often young people, they're senior high school students, university students who are wanting to work at McDonald's or Coles or Woolworths. I'm not trying to cast any organisation into aspersion, where shifts can be rostered. And our young people will come into the interview and just say toward the end of it, look, I'm a Seventh-day Adventist. I observe the Sabbath from sunset Friday to sunset Saturday. And, if I'm successful, I would like consideration to rostering that does not require me to work within the Sabbath hours. And generally, most employers, most of the time, are very good about that. But from time to time, complaints are escalated through to us where undue pressure is placed on our young people to take a shift because they're short-staffed, or a particular manager is not willing to respect their personal convictions and faith. And so they're the kind of areas where it does place a lot of pressure on particularly our young people.
Okay. All right. Thanks very much, Chair. Thank you.
Thank you. I believe Senator McLaughlin, you have some questions. He's on teleconference.
Yeah, thank you, Chair. I'm interested in how you see the bill, if enacted, how you would operate your schools any differently. or would it assist you? How do you view it from a organisation that has investment in schooling?
I think the enactment of the bill would just give greater clarity around the way we operate our educational institutions. We operate systemic schools. We operate within a global belief system, and as what we're wanting to do is to ensure that our schools are able to live out in practice and in reality our belief system. In addition to having state and territory-based accreditation for our schools, all of our schools are accredited by the denomination to ensure their alignment with and their upholding of the values, beliefs and teachings of the Seventh-day Adventist Church. And so having a Religious Discrimination Act in place that does provide those protections to ensure that our schools can practice in reality, in the real world, the beliefs and teachings of the Seventh-day Adventist Church is important to ensure that we have both the denominational accreditation as well as the state and territory accreditation. So I think it just affords that additional layer of protection and comfort that we can do this.
And could you set out for the committee what problems, if any, you're having at the moment running your schools and maintaining your ethos?
Thank you. And as has been alluded to both today and in the previous hearing, our attention has been very closely on the changes to the Equal Opportunity Act in Victoria, and we are concerned that provisions within this will limit our ability to recruit and to retain in our employment people, staff who do align with our values and teachings, both in theory and in practice. And and we're not sure what other provisions might be introduced in other states and territories, but that is certainly concerning to us.
Do you have any specific examples of members of your community where they've been discriminated against, in addition to the ones that you've set out to previous questioning?
Discriminated against on which basis?
The basis of the practice of their faith. I've gone broader than schooling now,
yes.
So I'm sorry I didn't make that clear.
Of course. Look, I think primarily the most pressing discrimination we face is around the observance of the Sabbath and challenges when it comes to the expectations of employers about what conduct and activity will be undertaken on that basis. Generally speaking, there might be other outliers, but not of such a volume that they escalate to me at a national office to need to step in and intervene. Most of other matters that arise tend to be able to be addressed at a fairly local church or local regional office kind of level.
Right, thank you. I have no further questions, Chair.
Thank you. Senator Pratt, you've got your face on, so I'm assuming you wanted to ask a question.
Thank you. Thank you very much, Chair. If there is time, I'm happy to accede to my colleagues in the room if they want to jump in.
Thank you.
Instead.
A couple of questions, if I may.
Senator
Thank you. Thank you for your submission and the way in which you constructed it. I found it particularly helpful when you got to the implementation of the bill section and the areas where the bill could be improved. So could I just take you to the amendments that you would recommend that are required to this bill to make it meet the problems that you've described?
Yes.
Do you want to do that on the fly or do you want to take that on notice?
Did you have questions around the submission there?
Yeah, so areas where the bill could be improved, we've had some general discussions around that. Have you considered any amendments to fix those matters with regard to the bill?
When it comes to the drafting of amendments, I come from an ecclesiastical background. My training's in theology, and I would accede to the legal experts to frame the wording for amendments, and organisations such as Freedom for Faith and the Institute for Civil Society, the writers of those submissions are well able to articulate wording, and we have found ourselves resonating strongly with the wording and the proposed changes that they have put in their submissions. I'm happy to take it on notice and to review that wording and send through any submissions. But I don't represent myself as a legal expert or a writer of bills and legislation.
So you raise a point that's raised by quite a number of the submissions around 42C, around section 5.1, with regard to the statements of belief, etc. So yeah, anything that you could provide further information to the committee about would be helpful. Could I take you to the override of the state and territory laws and just ask the question I've been asking most of the witnesses? Well, do you support the override laws?
One of the tensions I think we face is as a nation, we've given assent to the incorporation of ICCPR Article 18 into our legislative framework, and have done for a very long time, but we actually haven't practically implemented it in tangible ways. And what I would see as the role of the Commonwealth has been stated in other submissions and in other committee interviews is to ensure that the Commonwealth does fulfil its responsibility to ensure that we are aligned with those international covenants. If one of the mechanisms in order to ensure that we are discharging our responsibilities with those covenants is to include some override provisions, if that's the best way to do it, then we'd be happy to see those provisions included, understanding that has the potential to create some challenges, as I've heard you outline to previous speakers.
Thank you. That's a very, very clear answer. I think generally we can say pretty well all submitters accept that there needs to be the completion of those ICCPR responsibilities and filling out the suite, I think, as Archbishop Comensoli indicated, to fulfil that responsibility as well. But the mechanism by which we do it needs to actually achieve that outcome without continuing contest. And if you could just turn your mind to does the Seventh-day Adventist Church have concerns about a tit-for-tat legislative action with regard to the meeting of those international obligations at a federal level and a determination to interpret those responsibilities in a different way at the state level? Could I take you to your submission, because I think one of the things that's at the heart of the issues that have been discussed are well articulated by you on page 5 of your submission. In the 4th paragraph, you say, the view is often put with regard to these changes, the override provisions, that's the paragraph that precedes it, that while they accept the legitimacy of requiring a school principal of a Christian school to be a Christian, they see no reason why the maths teacher should be. This assumes that maths teachers do no more than teach maths, but in fact teachers transmit principles, attitudes to life, worldviews and beliefs, so students of all kinds, in all kinds of ways outside the classroom, for example, in leading pastoral care groups or extracurricular activities. Many Christian schools are faith communities of staff seeking to provide a holistic witness to students. So that understanding of faith in education, I think, has not been articulated so clearly quite anywhere else. How does that view interact with the legislation as it stands? Do you feel that that view of faith as a pervasive part of a school, as opposed to an identifiable subset of a skill for a teacher, is well attended to by the current legislation, or does that need further protection or explanation in the explanatory memorandum? Could I ask you just to speak to that part of your submission more fully?
I think it goes to the desire to ensure that as a faith-based organisation, whether it's through education, whether it's through healthcare or aged care, has the right to preference the employment of people who are of our faith. I think, as we all know, values are often more caught than taught, and ensuring that there is those protections in place so that we can recruit people who will be able to not just deliver curriculum with excellence, but also to model values and beliefs and teachings in their interactions with students and with their families is important. I think what we have indicated in the submission is that there has been that protection built into the bill when it comes to education, but it has not been provided when it comes to other ministries, other areas of operations within our organisation. So we would like to see it broadened out to ensure that all of our faith-based entities, the different aspects of what we do to add value to the community, to provide a service to the Australian community, are afforded the same rights.
I know, perhaps I haven't read everything clearly, but I think that you were the first submission that I noted where you made a comment about childcare centres in light of the comments you've just been making. Can I ask you to speak to that? Because I know there was a period of funding where childcare centres were attached to schools and they operate under the same sort of ethos model, but has that been given adequate consultation and consideration? Does it need an amendment to the legislation to cover off that particular aspect?
Correct, yes, we believe there's some further clarity required in the legislation in that regard. We run childcare, generally speaking, attached to our schools so that we provide, in some cases, from 3-year-olds right through to year 12, and in other cases, from babies right through to year 12, and it provides that continuity of education. And to be able to uphold the ethos, the values and the teachings of the church through that whole continuity of education, rather than seeing it segregated off or treated differently, is really important. And so and happy to take on notice the request for some clarity around amendments to ensure that whole continuity of education is provided for in the bill.
Thank you.
Thank you. And I'll go to Senator Rice.
Thanks, Chair. Thanks, Pastor Worker. Look, you're just talking about being able to employ people who model the values, beliefs and teachings of your church, and your description in the implementation of the bill and your submission, you're in support of Section 7, ensuring that a body engages in good faith in conduct which a person of the same religion as the religious body could reasonably consider to be in accordance with the doctrines, tenets, beliefs or teachings of that religion. Could I just ask you to step through for us in terms of the Seventh-day Adventist schools and other organisations, what people then you wouldn't want to employ, or in fact, if you're teachers at your schools, what sort of behaviour would you feel was inconsistent with that?
As a worldwide church, we have a statement of fundamental beliefs that is consistent right around the globe. And those statements of beliefs can only be amended through a world meeting that happens once every 5 years, where representatives of every part of the world come together to give consideration to those fundamental beliefs. And we endeavour to have a holistic set of beliefs where we talk about health, where we talk about lifestyle, where we talk about all the biblical principles that apply to humanity. And when we're recruiting staff, we are seeking to have people on staff who will choose to align themselves with those beliefs and teachings of the church, and they're very readily available.
So you wouldn't support somebody who was a same-sex attracted person who was married to their same-sex partner, for example?
So one of the fundamental beliefs of the Seventh-day Adventist Church is that we believe that marriage is to be between a man and a woman. And so that is incorporated in our global belief statement. Now, we respect that not everyone is going to agree with our beliefs and teachings, and that's okay. We live in a modern pluralistic society where we uphold what we believe the Bible to be teaching, and we seek to align our institutions as far as possible with those teachings.
So you wouldn't employ somebody who was in a married same-sex relationship then?
that would be contrary to our beliefs.
And if you had a teacher who underwent gender transition, would that be grounds to no longer employ them?
It's an interesting question that you have there, and I guess we'd have to look again at each of the situations and circumstances. We have, again, global position statements that have been issued by our World Office in that regard, and we would have to look at each individual situation and circumstance in the context of those official position statements of the Church.
And people who have children out of wedlock?
Again, what we're doing is we're looking at our staffing, and you're talking particularly about staffing.
Yeah, I'm just wanting to get clarity for,
yes.
in terms of Seventh-day Adventist churches and organisations, what people you would feel it was inappropriate to employ, and if in fact it was revealed during their employment with you that they did have children out of wedlock, for example, under your tenets and beliefs, that you would feel that was grounds to no longer employ them.
As I've indicated, we would look at every situation, understand the circumstances around that. And,
but what's the position of the Church in that position? You said you've got your values. I'm sure you know what the position of the Church is for people who have had children out of wedlock.
Yes, correct. As I said, our fundamental belief is that marriage is between a man and a woman, and that's.
So that would be grounds to not employ those staff.
The right, though you might disagree with the witness, actually allows the witness to answer the question.
I think we can move on. Thank you,
Okay.
Senator.
So can I then have we still got...
Yes, he's still here.
He's still there. Can I then take you... So that's the position that you're supportive for the Seventh-day Adventist Church, and I presume that you would want to see that expanded to all faiths and all religions, regardless of their standing in community. And I just wanted to take you to the example that I put to the Catholic Church of the position of the Church of Ubuntu that said that they couldn't employ somebody that wasn't vaccinated, and whether you would support under the same grounds of that's their tenets and doctrines of their belief of firing somebody because they were vaccinated.
Again, I can't comment on the Church of Ubuntu. I don't know of the Church of Ubuntu, and I wouldn't want to speak on their beliefs and teachings and whether they're reasonable.
But I'm not asking you to do that, and that's not what the legislation doesn't ask, whether the teachings are reasonable. The legislation says if this is in accordance with the tenets, doctrines of the organisation, well, then they are free to hire and fire according with those tenets and doctrines.
Senator, if I might interrupt you, the bill actually talks about the tenets and beliefs of the religion, and it's not about COVID policies or any other something that is not to do with a religious belief.
No, but the Church of Ubuntu say that to receive the COVID injection consciously and deliberately with intent is in contradiction with our Constitution and contrary to our position on what is required of us by our Lord God and Creator.
Yep.
So they see that as a religious belief. And so under this, supporting that a body's engaging in good faith in conduct, which a person of the same religion as the religious body could reasonably consider to be in accordance with the doctrines, tenets, beliefs or teachings of that religion, then it would be the right, I'm seeing whether Pastor Worker agrees, it would be within the right of the
Senator,
Church of Ubuntu to then fire somebody on that basis.
The witness has already stated that he doesn't have a comment to make. Can we move on to the next question?
No, he said he didn't have a comment. Excuse me, Chair. He said he didn't have a comment to make on whether their beliefs were, acceptable or valid or anything. What I want to know is not we aren't being asked to make judgment on the beliefs of other religions. What we're being asked is to whether, because it is the tenets, doctrines and faiths of a religion, therefore that a religious organisation is able to hire and fire in accordance with those beliefs, even if it is like the Church of Ubuntu with their religious belief being regarding vaccination.
Chair, if I might make the point that I would understand that our witness has given the example of the right to be able to take leave on a Saturday, there are a range of beliefs that might be either in what's publicly acceptable or those that are outside. And I think the point that Senator Rice is making is that those beliefs are not necessarily about other people's attributes within the broad range of discrimination acts. They're not views about other people. They might be other types of religious views. And therefore, the point that Senator Rice is making is legitimate as a question, and perhaps our witness might come back to those kinds of examples of navigating this question. I can't tell you, of course, how to answer the question.
Pastor Worker, do you have any further comments to make?
Not on this particular point.
Yes, you can take it on notice as well.
Happy to do that.
Thank you.
Thanks, Chair.
Has anyone else got any further questions?
I have one. One of the matters that I think has exercised the minds of many is has there been a deal done about the Sex Discrimination Act element and its intersectionality? Because the timing of all of that you'd be well aware of. So there's been the delay and there's been no response, etc. And now there's wait till this is done and then we're going to do it a little bit later. On the 1st of December, there was an article that indicated members of the government's backbench, including Ms Katie Allen, Mr Dave Sharma, Ms Angie Bell and Ms Fiona Martin, had got the agreement from the Prime Minister to make changes to section 38.3, and that was sort of well publicised. There's been subsequent information that that is not the case, and in fact that Mr Morrison has been giving assurances to communities of faith that there is no deal. Just in the interest of trying to get to the truth, because it's such a significant issue and it's been much discussed in the course of these inquiries, have you been informed by the Prime Minister, his office or his representatives that such a deal exists or it doesn't exist?
I have no additional information to share on that. I couldn't comment with any certainty on those reports. I'm not connected in those networks closely enough to know what is happening within the Prime Minister's office in that regard.
So you're like us, just aware of the political commentary in the newspapers that puts two points of view with regard to the position within the Liberal Party on the 1st of December.
Correct.
Thank you. Thank you, Chair.
Thank you for appearing before the committee and for giving your time today. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business January 20th, 2022.
Thank you.
Thank you. Yes. And we will suspend the hearing for 5 minutes. Thank you.
Thank you.
And yes, I can hear you as well.
I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Before we begin, could I ask each of you to state your name and the capacity in which you appear for the benefit of the Hansard transcript?
Yes, Stephen Smith, Head of National Workplace Relations Policy of the Australian Industry Group.
And Catherine Brown, I am the Director of Communications and Advocacy at Diversity Council Australia, and my colleague will be joining shortly. Just having a technical issue, sorry about that.
I'll now invite members of the committee to ask questions, and I might start off for the AI group. Mr Smith, in your submission you argue that there are sufficient anti-discrimination laws to protect persons against the discrimination on the basis of religion. Currently, under Australian anti-discrimination law, gender, age, sexuality, race, ethnicity, or our level of physical or intellectual ability are known as protected attributes. You are rightly protected against discrimination in relation to any of these attributes. However, religion is not a protected attribute under our Commonwealth law, but according to the international treaties, like the ICCPR, which we are signatories to, it should be. What's your position on this?
One of the problems in this area of anti-discrimination law is the web of inconsistent Commonwealth and state and territory legislation. Now we, as we pointed out in our submission on the first exposure draft, have identified that religious belief and activity is protected in every state and territory other than New South Wales and South Australia. And South Australia, religious dress is protected. So our preference, if we had our preference, would be to fill those gaps in the state and territory legislation rather than putting another piece of Commonwealth legislation on top. But we do accept that the government has had a policy position over recent years of having Commonwealth legislation in this area. So we're not opposed to legislation that deals with anti-discrimination at the Commonwealth level, as long as that is appropriate. But we have some significant concerns about this particular bill.
So your submission is quite critical of the definition of religious belief. What definition would you believe is appropriate?
It is a very difficult concept to define, of course, but we're not proposing a particular definition. All we've done in our submission is to highlight some problems that will arise in workplaces because of, amongst other reasons, the very wide breadth of the concept of a religious belief.
And I will go to Ms. Catherine Brown. In your most recent submission, you expressed disappointment in the inadequate consultation period. Variations of this bill were initially introduced 3 years ago, and there has been a high level of scrutiny and consultations across many diverse groups. Can you elaborate on what additional level of consultation you would have preferred?
Yes, thank you, Chair. So in relation to that, what we were concerned about was that this bill came before the Parliament towards the end of last year, and this particular iteration, there was a very short time frame in which organisations were able to respond to the committee. As a membership-based organisation, where possible, it's always our preference to consult with our members, and obviously with that time frame, that wasn't possible for us. So in relation to that comment, that's specifically what we were talking about there.
Thank you. I'll hand to the Deputy Chair.
Thank you, Chair, and thank you for your submission, the AI Group. Your submission raises concerns about the wide variety of statements of belief that could be made by employees that may have a clear detrimental impact on the workplace or employer's business. The submission says the bill removes the restrictions around the application of employer conduct rules, which were included in the earlier drafts. Could you explain how this would work in practice if an employee made a statement of belief in a workplace with employer conduct rules, where they might say something religious every day, perhaps? I'm not sure who to throw to, Ms. Brown, perhaps? Is that you're the lucky winner?
I think you were reading from the AI submission there. So I think...
Oh, I beg your pardon, Mr. Smith.
Yes, thank you. I'm happy to address that. In section 12, subsection 2, there is, of course, a defence there for statements of belief that are malicious or which threaten, intimidate or vilify a person or group of persons.
Accept
but
that.
In our view, that is a very high bar, and there may well be a whole host of other statements which are defined broadly, which are highly offensive and inappropriate, that wouldn't meet those definitions in those 4 concepts that I just mentioned. So What we would like to see in this legislation is an express provision which gives employers the right to take reasonable management action in a reasonable way to address offensive behaviour or other clearly inappropriate behaviour. We see that exclusion in subsection 12.2 as far too narrow.
So you said inoffensive or inappropriate, like they were the same thing, but do you mean that? Because inappropriate, if I say every time I hand you a coffee, you know, Buddha is best or Jesus Christ is best or Allah Akbar, whatever it is, that wouldn't be offensive, would it? But it might be inappropriate if every time I hand a coffee over or, you know, whatever it is.
Yes, we don't see the two concepts as being the same, but in our submission we highlight a couple of examples. One is of an employee who may put literature on someone's desk every day, even though the person makes it clear that that literature is unwelcome. And there are a whole raft of other possible examples, and we would see that as inappropriate conduct that an employer should be able to deal with. And there are also all sorts of things that could be highly offensive that might be said or written that would be inconsistent with an employer's codes of conduct in the workplace. We're worried that this legislation as drafted will do nothing for harmony in the workplace and will cut across very important employer policies around diversity, inclusion, anti-bullying, anti-harassment, etc.
And keeping a safe workplace for everybody, if that's the employer's responsibility. Harmonious and safe.
Yes, and safety, of course, has a mental health aspect as well as a safe aspect in a physical sense.
Chair, could I?
Just ask a question with regard to that?
Yep, and I'll come back to me. So.
Using your excellent example, I think, of putting a piece of documentation on somebody's desk every day, if that were to occur currently and it was, for example, a political statement, which is not covered under any particular discrimination act, how would you deal with that?
Freedom of association in certain...
How would you deal with that? I mean, because it strikes me as putting a document about religious belief and a document about political belief at the same time, are quite similar in the way that they might operate. So how do you deal with the political statements of that kind?
Senator, it would depend on the nature of the statement, but it could be equally inappropriate if someone was putting a piece of political literature on someone's desk every day. Then that would be potentially harassing the person or engaging in conduct that is inconsistent with an employer's code of conduct. And what typically an employer would do about that would be to advise the employee that that is not acceptable, and then if the employee didn't comply with the reasonable conduct, then there may be an escalation, and probably would be an escalation of disciplinary action. But it's not just a piece of religious literature that will fall into this category, but this legislation, of course, protects statements of belief defined very, very broadly. So that's what we're concerned about.
Thank you.
Thanks, Mr. Smith. And now to Ms. Brown and Ms. Anise, who I think I can see. And it's to that Clause 12 statement of belief. And your submission, the Diversity Council submission says, and I quote, "It will mean that Australians will lose discrimination protections in the workplace to accommodate the religious beliefs of people who may make discriminatory statements against them." Can you explain to the committee how that might occur in the workplace if this bill is passed?
Thank you, committee. Our view very strongly is that there is a need, and we do support the idea that someone should be protected against discrimination because of having a religious belief or faith.
consistent with the way other forms of anti-discrimination legislation are written. We feel the problem with this particular draft is that it privileges one particular right, that is the right to a religious belief, over other human rights. And so our concern is that it would become, not only do we have problems with it in itself in terms of what the implications might mean for people from other identity groups potentially, but there's also a practical element here as well, in the sense of what that might mean for an employer in terms of their objective, which is to create harmonious and safe working environments so that they can have business environments that are productive and allow them to achieve their business strategic objectives. So from that perspective, anything that privileges one human right over any other is problematic.
So, continuing on, thank you, Ms. Anise. You also say that Clause 12 could have a significant impact on businesses. So you've heard Mr. Smith's concerns, and you also raise concerns about the cost of bringing a discrimination claim, and that could have significant impacts on businesses. So does the Diversity Council consider that your concerns about Clause 12, do you think it could be cured through an amendment to the current bill?
I mean, our view is that the resolution to this is to design a piece of legislation that protects religion without privileging religion over other human rights. I think that trying to pull back in other areas is not ideal, although it's better than having the bill pass in its current form. Businesses will face all kinds of complexities in trying to navigate this. It's likely to create a body of common law that is equally confusing for employers, because it will be a case of, which act do you uphold? And so, I mean, it can potentially become an impossible situation, and could really roll back hard-fought and hard-won rights for individuals to come to work and exist in the workplace authentically as who they are, without fear of being harassed and discriminated against or bullied.
And the example for places like Queensland, that the Labor government brought that religious discrimination legislation in 1991, but they didn't have this statement of belief complication. So that Clause 12 is the one you think is going to be putting landmines out there for people in the future, as well as costs for businesses and the like.
I think also there's a lot of problems with having a statement of belief, in that because it's so subjective, it's really difficult for employers to navigate, even if it was, so what you're doing is creating a situation where, how do you know that you could potentially have two pieces of behaviour, one which becomes unlawful because it's not on the grounds of someone's religious belief, and one which is lawful because it's consistent with someone's statement of belief.
May I ask a supplementary question in that context to
Thanks, Ms. Anise. Yep.
Graham Perrett's questions? Clearly, in some jurisdictions, religion is a protected attribute. With that might come some expression of belief, because when you have an attribute, it can be visible either in the way you talk about your life, for example, if you're gay, or in the way you might talk about what you did on the weekend and how you went to church. And equally, if in the workplace, someone might say, I'm going to go to Mardi Gras, do you want to come? And someone of a religion might say, I'm going to church this weekend, are you interested in coming with me? And there are a range of things that people might say about their belief or their identity or their... How do you interpret the current protections in terms of how, whether that be on sexuality or gender or religion, where it is in some jurisdictions in Australia already protected, in the way that it gives licence to an expression of an identity, and how this particular bill goes further than that?
The expression of an identity, as is currently protected with existing legislation, has limits. And like with all human rights law, the right to the expression of one identity stops when it has negative consequences for somebody else's identity. So in the example, Senator Pratt, that you raised, which is someone saying, come to Mardi Gras, if you were to harass someone who doesn't want to go to Mardi Gras, then the employer would rightly be concerned about that being inappropriate and would ask an individual who's trying to engage someone to go to Mardi Gras to stop, and potentially that could be escalated. So I think that's
equally you would want to do that in the case of someone persistently saying, please come to church.
Absolutely. Yeah, definitely. So the concern that we have is the privileging of religious expression over other human rights.
And so you think, quite in a very technical sense, that someone will be able to use, when an employer does find someone's conduct interfering in the workplace, say, does persistently ask someone to come to church with them when they've already made their position clear, this will very clearly create a limitation on an employer's ability to manage a situation like that.
Yes, I believe so.
Can I just ask, isn't harassment in any context? Like whatever mode, and there are current mechanisms to deal with harassment. I mean, I would hate to be harassed by anybody demanding that I attend their particular version of worship. So what would change to prevent protection against harassment?
Good question, Senator O'Neill.
Because I can't see that bit in the bill. I've got concerns about the bill, but I don't have that particular concern. So could you make it clear to me where the override actually kicks in? Because I'm not clear. I can't see that in my reading of the bill, and clearly you see it somewhere.
I think that what the bill does is create the environment for that to be more likely to happen, because it's essentially creating a hierarchy of rights. And in a hierarchy of rights, as those things could be played out in the workplace, it's likely that the scenario of someone feeling as though they are able to suggest to someone regularly that they attend their church, for example, is more likely to happen than if you didn't have that hierarchy.
So can I ask, in that context, when if we were to amend the bill to say, well, everyone can make these statements of beliefs, but it can't be harassment, does that put us back at the status quo of employment law where we are now, or would that in some way also be tangibly different?
The DCA position is that we design a bill that protects religion from discrimination and doesn't privilege religion in any way over other rights.
And the industry, Australian Industry Group?
Yes, if I could just make a couple of comments about a few of those last couple of questions. With that issue of harassment, as I mentioned earlier, in subsection 12.2, there are 4 concepts mentioned there: malicious, and also the concepts of threaten, intimidate, or vilify. All of those concepts have, case law around them, and they are quite a high bar. So there is a whole host of harassing type conduct that wouldn't meet the definitions of those 4 concepts. And you're going to Senator Neal's question. We think that's the answer there. On the issue of the overlap between...
Mr Smith, can I just ask you a question before you go on? Is your argument then, do you hold a different view from Ms Anise with regard to what the legislation does or doesn't do in terms of privileging religion over? Because Ms Anise hasn't actually yet, and perhaps I notice she might be able to point me to the part of the bill that does that. I want to see that. Do you hold the same view as Ms Anise, or do you hold a different view, Mr Smith?
The same view, because in subsection 12.1, a statement of belief overrides a whole list of Commonwealth and state legislation. And therefore, that's the starting point. And then there's a defence in subsection 12.2 for behaviour that meets that very high bar. Now, the example that I gave of the pamphlet, or the other examples that we discussed of, inviting people to go to Mardi Gras constantly or to church, whatever the behaviour might be, that even if the concept of harassment was added to the other 4 concepts, there may still be all sorts of other conduct that would be inappropriate, that still would not meet the 4 or the 5 concepts in the defence. Now, we accept that there is a significant amount of overlap between the concept of a statement of belief and religious activity. So if that is correct, and we can't see why it wouldn't be, why do you need section 12 at all? Because you get rid of section 12, the legislation becomes a more a traditional form of anti-discrimination bill that protects direct and indirect discrimination. It protects religious belief, protects religious activity. We still think it shouldn't oust the operation of other laws and give preference to religion over other protected attributes. But the bill could be fairly readily modified to address our concerns in those various ways, particularly and also by including that provision that we proposed in section 39 about reasonable management action, which comes out of the anti-bullying provisions in the Fair Work.
Thank you very much. It's very helpful.
For example, that sexuality and gender as a protected attribute in the Sex Discrimination Act comes with it a capacity to make some statements of belief about that, and that would have the same thing in the context of religion, but that there are overall limitations on that when it causes harm to another party or causes dysfunction in the workplace.
Yes, agreed.
Thank you.
Thank you.
Ms Hammond, I believe you have some questions.
Thank you, Chair. Thank you very much. I've got questions for both of you. Thank you very much for your submission, Mr Smith, from AI. Can I just clarify then your position? So AI and part of your advocacy and involvement in prior process helped to lead to the removal of the employer conduct rule restrictions, and you're supportive of that, aren't you, the removal of those?
Yes, we are.
Yeah, so that one's gone. Secondly, the proposed defence, additional defence, and the way that you've outlined it, both in your submission and today, I think it's very commonsensical. And I think we often take this or look at it from the perspective and the examples given of somebody putting religious pamphlets on somebody else's desk every day, in terms of keeping a harmonious workplace. Yes, some reasonable management action might be needed there. It could also be the reverse, that an employee, a fellow employee, sees somebody who follows a particular faith and puts material on their desk every day saying your religion is corrupt, your religion is this, your faith is whatever. We should always realise that this is protecting two sides of the coin here. It's not always one perspective. So I think you have canvassed. I was going to go through the defence you proposed, but I think you have canvassed it with other questions, and it is based on bullying legislation, isn't it?
Yes, it comes out of the anti-bullying provisions that were implemented several years ago into the Fair Work Act. And if I recall correctly, Mr. Shorten was the Workplace Relations Minister at the time, and there was a significant debate that we were involved in about this issue of how do you deal with bullying conduct and the concept of reasonable management action. And what came out of that debate was what ended up in the Fair Work Act, which is that reasonable management action carried out in a reasonable manner is not bullying for the purposes of the legislation. And that's been a very important provision that has worked very well in the anti-bullying jurisdiction in the Fair Work Act.
Yeah. A lot of witnesses who appear before us have raised concerns about the usage of the word genuineness. How do you actually test that? And or, people from non-legal backgrounds or from other backgrounds also say when you use the word reasonableness, what does that actually mean? The reality is so many of our laws already use those phrases, don't they? As you've just pointed out, bullying. And none of us want things to end up having to go to court. And I think Diversity Council makes a really good submission there about harmonious workplaces. Having to resort to court is everybody's last resort. But the reality is in a legal system, you do have to use words like genuineness, reasonableness. And there is a body of law, particularly in the workplace area, isn't there, that could help guide the interpretation of, for example, the clause that you put in about what is reasonable management action.
Yes, and that's why we favour adopting that phrase, because it is an existing phrase that comes with a body of case law around it. And the concept of the reasonable person, and, reasonable is used extensively in so much legislation and under common law that it is a useful phrase. I note that a number of other parties have suggested having more detail in the explanatory memorandum, which is always useful, but we have been caught out on many occasions with provisions in explanatory memoranda which have been held to be inconsistent with the plain words in the statute. So the statute should be clear. EMs are useful, but not in the context that they remedy unclear words in a statute.
Yeah, you're right there. It's also true, though, that, it's why we have a court system as well. Legislation, there's no perfect piece of legislation. I don't think there's ever been a perfectly drafted piece of legislation, and lawyers make money over disputes about usage of words and how words are applied in different circumstances. So I think if we were aiming on any piece of legislation to get perfection, I think we're destined to fail and never pass anything, which might actually be some people's preference. Just for the record then, Mr. Smith, you would prefer, I think I heard you say this before, regardless of all of that discussion, you would prefer a bill that actually mimics other anti-discrimination laws. Did I get that takeaway right?
With the four main pieces of Commonwealth anti-discrimination legislation, they all differ somewhat, but they have some central concepts. They outlaw direct discrimination, they outlaw indirect discrimination, and contain various other supporting provisions around those concepts. We would prefer the legislation to be like that rather than going further to have this concept of a statement of belief. And we would also prefer that the legislation doesn't override other anti-discrimination legislation, but rather sits alongside it, so that the rights of one group are not potentially overridden by another group.
Yeah, the reality is that there are times, aren't there, that and this is for the Diversity Council as well, because this would be your experience, that rights do my right to do something will come into conflict with somebody else's right to do something. I mean, that's a fact of living in a society such as ours. It's always been the case. And we do have mechanisms, and we need to retain mechanisms for actually resolving those. That would be right, wouldn't it?
Yes, and those issues have been coming up for many, many years, of course. We don't need necessarily to have a piece of legislation that expressly in the legislation puts one person's rights ahead of someone else's. The legislation can sit alongside each other. All of the state and territory legislation are broad and deal with a list of protected attributes, and one attribute is not given priority over another. So, that issue has been worked through for many, many years, and there haven't been that many problems that have arisen.
To the Diversity Council, I really appreciated your submission, particularly with the survey work at the end about harmonious workplaces and the impact of discrimination, harassment, on well-being and various things like that. I did note in your own, so this was on page 24 of my pack. I'm not sure if it's page 24 of your submission, I'm sorry. But you did note that you made the comment that it's largely minorities that have experienced discrimination or harassment, and you state workers from a non-Christian religious background at 48%, workers with disability and LGBTIQ plus workers, 45%, reported significantly higher levels of experienced discrimination and harassment compared to Christian workers, workers with no religion, workers without disability and non-LGBTIQ workers. Given that the highest percentage there were people from non-Christian religious backgrounds, that does lead to, I would think, the conclusion that we do need to do something to protect religion. Is that, is that diversity?
Yes, we really are in favour of an act that protects people's right to their religion in the workplace, and that it should look similar to the other Commonwealth anti-discrimination laws. So it protects the right to religion, and inherent in that there are limits on the expression of that religion in a workplace context, because that could impinge on the rights of others to be authentically safe if they are. And the areas that we have identified in our submission, people who identify as LGBTIQ+, women and girls, and potentially people with disabilities are the more vulnerable groups, we feel, with this particular draft. It's interesting that reflecting on the research that we do, we're an evidence-based organisation. We deal with workplace. Our members are workplaces, and they cover about 20% of the labour market, and we do research, and so our views are informed by our research and the evidence. And yes, I can confirm that when you look at people who experience discrimination on the grounds of their religion in workplaces, it is people who are from minority religious groups, and not majority faith groups.
Yeah, okay. Thank you both for your submissions, and thank you, Chair, I've finished now.
Thank you. Senator Rice.
Thank you. Thank you, both of you, for your submissions, and basically where both of your submissions sort of cover the ground of your concerns with this legislation, is how it privileges sort of religious and faith over other attributes that people shouldn't be able to be discriminated against. Could you just for clarity, just sort of perhaps starting with the AI group, just outline for us in summary the areas where that privilege occurs and where it needs to be rectified?
Senator, our submissions on this bill just deal with the workplace issues. So my answer would just relate to that issue, but it's particularly this problem in section 12 that we're most concerned about. The idea of a statement of belief that would override potentially the rights in other anti-discrimination legislation, and that is very expressly set out in subsection 12.1. There are a host of other provisions in the bill going to all sorts of other areas of public life that others have a more direct interest in. So, but on the workplace issues, that's our biggest concern.
Thank you. And the Diversity Council, could you just sort of summarise where this legislation privileges religious belief over other protected attributes?
Well, similar to what Mr. Smith has said, it is in the statement of belief, which then provides protection for someone because of a belief, to be able to act or make comments or have behaviour that could have a negative impact or consequences for other groups. Kathy, is there something you want to add to that?
No, just to reiterate what you said and what Mr. Smith said, it's the override of the other forms of anti-discrimination law, and also to the point that Mr. Smith was making earlier about how the test for behaviour, the test for the defence for such behaviour is at such a high threshold compared to, even other types of anti-discrimination legislation.
Thank you. And then my other question then is, and perhaps probably directed to the Diversity Council because your submission goes into it in some detail, is what the cost of this would be in terms of disrupting and not supporting a sort of a harmonious workplace. Could you sort of give us a bit of a summary of sort of what the cost of that is going to be if this indeed is how it ends up?
Well, we do a biennial index on workplace inclusion, which determines what kinds of behaviours lead to harmonious workplaces. And when we say harmonious, we mean that workplaces that are respectful, where there's human connection and where people have opportunities for progress and where their jobs are designed in a way that helps them add value in terms of their talents. And what that index shows, and it's consistent with all our other research, that organisations that are focused on inclusion are organisations that are more innovative, they're organisations which are more productive, people are more likely to give discretionary effort, and they are also organisations with lower risk. So they're much less likely to have complaints about harassment and discrimination. And that's unequivocally, quantitatively measurable in our index every 2 years.
And so your concern in summary is this legislation would be undermining that harmonious workplace, and so therefore leading to organisations that aren't as positive in those areas as other organisations. Yes, or as they could be.
Exactly. And we recognise that human rights clash sometimes. And we produced some guidelines on how to manage a multi-faith workplace and used examples of when faith and religion can clash with other human rights and the process that employers could go through as part of normal management in order to retain that inclusive workplace culture. And because we're operating within a legislative framework that hasn't privileged one right, although you could say at the moment the absence of protection on the grounds of religion means that it doesn't have the same rights, and so we support that there is a legislative framework that protects religion, but then without the additional privileging of religion over other rights, the guidelines that we provide employers would be able to manage any potential clashes in a way that is significant in the workplace but relevant in the workplace. And relevance is really important.
Thank you. And look, my final question then is, we're looking at this legislation now. We have to report by the 4th of February. The government wants to introduce it. Do you think that this legislation is salvageable by amendment, or should we actually be going back and sort of having another go that does put religion in the context of all the other attributes?
I think it's... Oh, look, I'm not a legal scholar, so I can't...
It probably is a difficult question to put to you. It's a question for us.
Yeah, but I think from my point of view, if a piece of legislation is presented that would protect the rights of people to their religion and to their faith without fear of discrimination, either direct or indirect, we would be very supportive of that, and so would our members.
Thank you.
Thank you, Senator. Senator O'Neill has a final question.
Yeah, if I may. Thank you for your response to Senator Rice's question there, particularly at the end. You argue on page 7 of your submission that the government's actually provided inadequate consultation period for these bills because of the complexity that we've sort of been trying to flesh out today. Are there any aspects of the bill that you haven't really had an opportunity to consider carefully, and would you appreciate the opportunity to provide further amendments or ideas to this committee in the coming days?
I don't think that days would resolve our desire to be able to consult with our members, especially during
this period
the middle
of time.
Of January. Yeah. So what we have done with other pieces of legislation is we consult with our members using a survey, and we've held briefing sessions with them as well to flesh out concerns, and then we're able to roll up and do a summary of that in any submission. We haven't been able to do it with this iteration.
So in trying to deal with the facts, I appreciate the evidence that you've provided, and that sort of matches with the evidence from the Catholic Church too about crime that's related to discrimination against people of faith, particularly the minority faiths, where they have, obvious signs of their faith expressed outwardly. But the other part that I really would like to get your comments on is section 38.3 of the Discrimination Act is intimately entwined with this legislation, although it's delayed, and that's problematic. On the 1st of December, there were a number of Liberal Party backbenchers, including Katie Allen, Dave Sharma, Angie Bell and Fiona Martin, who claimed that they had struck a deal with Mr Morrison to make immediate changes to protect gay students from discrimination in religious schools. The Prime Minister has said that there's no such deal, yet this is a matter of public record. Was put forward by 4 of these Liberal members who represent their communities. Do you have any clarity about whether that deal exists or it doesn't exist, given that both of your organisations would be interacting, I'd say, on a pretty high level with the government in the midst of the COVID crisis? You might have some clarity around this. Do you have any information that can help the committee discern whether that deal is a reality or not?
No, for DCA we do not.
Mr Smith?
And Senator, we haven't had any involvement in that matter and don't have any information on it.
Okay. Perhaps you might be able to find out. We're trying to get to the bottom of it. Thank you.
Thank you very much. Thank you for appearing before the committee and for giving your time today. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business on the 20th of January 2022. The committee will now adjourn and recommence at 1:30 p.m. Thank you. I think we will resume hearings. Thank you. open the hearing again. I now welcome representatives of the Presbyterian Church of Australia via video conference. Can I quickly confirm that you can hear us online, Reverend Duke? Yes, good.
Yes.
Thank you. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you.
Mm-hmm. Yes.
For the Hansard record, could you please state your full name and capacity in which you appear today?
John McLean. I'm convener of the Church and Nation Committee of the Presbyterian Church of Australia.
Lovely.
Christopher Duke, and I'm a member of the Church and Nation Committee, Presbyterian Church of Australia, and also convene the Victorian equivalent of the PCB.
Thank you. If you provided a written opening statement, would you like it to be incorporated into the Hansard record?
Yes, thank you.
I'll now invite members of the committee to ask questions, and I'll hand to the Deputy Chair.
Thank you, Chair, and thank you for appearing and for your submission, Reverend Duke and Dr McLean. Your submission refers to the Statement of Belief clause and your church's experience of the Tasmanian legislation, which Clause 12 will specifically override. It says that the Tasmanian process was time-consuming, stressful and expensive. Some submitters have raised concerns about the potential for Clause 12 to cause discrimination claims to become more expensive due to the involvement of different jurisdictions, competing jurisdictions and courts. Do you have any cost about the cost implication for discrimination complaints if Clause 12 is implemented?
I think we will resume hearing.
Certainly nothing in specifics, except to say, as we'd already said, it was already expensive for the congregations in Tasmania that were...
Excuse me, could I ask whoever's online, please, to mute their phones and their computers? Thank you.
Thanks. Yeah, so it was already an expensive exercise for the minister and pastoral worker and their congregations, even though it didn't finally go to a full hearing of the Commission.
It was resolved beforehand.
Well, the complaint was finally withdrawn after... It perhaps wasn't entirely 12 months, but 9 months or something of waiting to see what would happen, in which time they were certainly seeking legal advice and support. Yep.
But decided not to go ahead after a consultation.
No, the complaint was withdrawn by the complainant.
So you've turned your mind to the federal court process, and
I don't have anything in detail to comment about. I mean, how it would, whether it would increase the cost. I think that.
Okay.
Yeah.
All right. One of the concerns raised, if you'd like to give us any additional information in response to that, because you haven't really...
Sure, yeah, I hadn't given that any particular thought.
Send
Thanks.
through to the committee. One of the concerns raised by the Presbyterian Church in their submission is that the minister should not be granted power to make requirements about employment policies of religious institutions. Could you explain why that is a concern?
I'll say something, and Chris may want to add something. It seems to open the door for arbitrary or unexpected and unreviewed requirements, which don't go through the scrutiny of the Parliament.
So you like the parliamentary scrutiny, and you're wary of ministerial power.
Yeah,
yeah.
It's better to. It's easier to support a bill where you know what it's going to contain than these possibilities.
Trust me,
I'm not sure how it could be used.
Trust me, I'm a politician. Won't cut it for you, Dr. McLean. So. Reverend Duke, would you like to add to that?
Well, it appears to us that that's a lot of power in the hands of one person, and we would probably prefer that power to be spread widely. That's all, and so, to place it in the minister's hand is a tremendous responsibility, and also, could be used poorly or good. It's an unknown.
You also, I think, made the point that a court should not be required to determine the content of religious belief. The Presbyterian Church has been around for a while. I'm not sure if you've heard other evidence from other religious institutions that maybe quite don't have the background or the resources or the processes that come with long-term institutions. Would you like to make comment on them in terms of courts determining the content of their religious beliefs?
Sure. So I think, as you're indicating, that would really not be a problem for the Presbyterian Church. We've got very well documented beliefs. We've got a heritage of documenting them very precisely and arguing about the details.
Pinning them on church walls, in fact.
That's right. But that's, not every religious body is like that. And religious bodies should have the capacity to determine what are their beliefs. And it should be simply a matter of them having to demonstrate that these are their beliefs, rather than having a test of, what would be reasonably expected by another member of the same religion. It's phrased in those terms. But of course, religions can have a whole range of different schools.
And I just wanted to sort of note that you suggest the exemption should be extended to disability services where they provide a home for people with disabilities. Would you like to unpack that for us? And I was going to say the PMSA, but you're not the PMSA, that's a school group, is that in
Right,
Queensland?
the PCA, if you want to use an acronym.
Okay, the PCA does run disability homes, or?
At present, in New South Wales, we run a disability hospital.
Got it, okay.
Which probably wouldn't fall under these, and wouldn't want to exercise this, the power that's allowed under this, those provisions anyway, because that power is about allowing a religious institution to run accommodation for people who just want to live with people from their own religious background.
Got it, yeah.
And that's allowed for aged care. But it seems appropriate that if there's religious bodies where that's needed for people with disabilities, that should be a right. I could give you a practical example.
Thank you.
I have some friends who have a son with a serious intellectual disability, and he's a young adult now. They're at the process of setting up a group home, and they want him to be living in a Christian community.
Yeah, got it.
Now, I think probably as a private arrangement, it wouldn't be touched by this bill anyway. But if a religious institution wanted to provide for that sort of need, it seems reasonable. If there are families who want their children to be in that sort of an environment, they should be able to do that and not risk having
part of the pastoral care of the church,
not risk
that
having
it would
a
extend it.
discrimination complaint brought against them.
All right. Thanks very much, Dr. McLean, and thanks for your submission. Thanks, Chair.
Thank you. Can you explain your position and why you believe the bill is compatible with Australia's international human rights obligations?
Sure. I guess being in the room has given me an advantage. Did you want to say something, Chris? I'm happy to take it if you...
Well, at the moment, let me just say that we don't have anything positive at this point in time in our law that allows for religious freedom. We only have the mechanisms of exemptions under discrimination laws that positively give some sort of religious protection. The international covenant probably at this point in time, we would argue that our current law is probably a bit short, and therefore, the bill does this particular bill does bring some relief in that area, albeit in the guise of religious discrimination rather than a positive statement on religious freedom.
Did you want to add to that? Sorry.
I think it's other groups testifying earlier had already identified there is a gap, and the expert panel had said there is a gap in the federal law. Of course, most states recognise religious belief as a protected attribute, but it's not recognised in federal law. And given how foundational freedom of religion is amongst a bundle of important human rights, it seems very appropriate that should be recognised in federal law as well.
Do you believe currently that Presbyterian schools have the freedom to make decisions in line with their ethos?
So Chris may want to speak to this particularly about Victoria, because he's in Victoria, and I think the situation is different there, or potentially different. But generally around the other states, it has been the case that, yes, schools have been able to do that in terms of selecting staff and having policies that reflect the kind of ethos and mission that the church has. Yep.
And Reverend Duke?
Yeah. Well, as you'd be aware, in Victoria, there's been changes to the equal opportunity legislation in relation to employment, and this legislation will put some restriction on the employment of staff. We strongly believe that it's vital for us to be able to employ staff that not only agree with the tenets of belief and doctrine of our religion, our denomination, but also live it out as well. And that's why we wouldn't want to differentiate between the different subject methods. Some people, well, the recent legislation argues that maybe you just need your board of management and your principal and maybe your chaplain that holds to the tenets of belief, and it's not important for your maths teacher or your science teacher or your sports teacher to hold to our tenets. Well, we argue that all the staff should not only believe and agree with our tenets, but also live it out in their conduct. And so that's vitally important for our mission. Because we want to present a Christian worldview in our education environments, and so the recent legislation in Victoria probably is going to put pressure on us, sadly, and that's our position here.
So we've heard repeatedly that faith is generally caught, not taught. I'm assuming that you hold the same view.
Yes, I mean, students, no matter what their age, they're very quick to point out or to observe the sincerity of Christian belief and faith. It's sometimes it's not important how much you know, but it's how much you actually care and you live it out. And they're the first ones to point out any errors, and they will too. But yeah, look, our mission is for us to achieve our mission goals in our education institutions. It's important that we have some right over how we preference those who work in our institutions, and it's not just in our secondary institutions, but also in our tertiary ones as well, in our seminaries. And we have 3 seminaries in Australia, in each of the 3 eastern states, that provide our missionary and ministerial training, and it's important that we have a right to oversee that.
Sure.
I just wonder if the witnesses might have an observation about the Tasmanian legislation as well, because it's been in place in that jurisdiction for a lot longer than the Victorian one, as the Catholic bishop indicated, is still trying to come to terms with exactly what it's going to do. So Tasmania, have you got any insights?
Right. I'm mainly aware of the Tasmanian legislation in terms of the offence and complaints about offensive speech, not how it impacts on schools.
Okay.
Are you asking about schools?
Well, yes.
Oh, and the Presbyterian Church doesn't have any schools in Tasmania, so
okay, thank you.
We wouldn't have any sort of specific denominational experience, although lots of our members would be involved in Christian schooling in Tasmania. I'd certainly be happy to chase up if there's any awareness of the impact.
Thank you, Chief.
Do you see that a school with this bill, should it be enacted, that a Presbyterian school would be able to discriminate against potential candidates to maintain its ethos, and what is required of the school? both currently and if the legislation is passed?
Well, I suppose currently what's required is whatever's required under state legislation, which will vary from state to state. Under this bill, if it becomes the Act, particularly you need to have a clear public policy, which I think is extremely appropriate. I think it's a good balance of religious schools, religious institutions should be able to pursue their ethos and mission. But if there are people who want to apply for employment, then it should be very clear to them up front what is expected of them in terms of belief and behaviour.
Mm-hmm. Reverend Duke, did you have anything to add?
Yeah, look, I think that I don't think it's I think there's a possibility that there's still a sting in the legislation that isn't necessarily going to be a complete what's the word? That's going to give us complete satisfaction. Whilst we would have very clear policy and statements and all that sort of thing, I think that there's still some areas to be tested in this area, and I don't think that the passing of this bill is actually going to give a clear exemption from the Victorian legislation. From what I've been doing, it's as far as research goes. I think that there is the fear on both sides of the argument that it could. But from our point of view, I'm not convinced that it will. So we'll have to wait and see.
So your concern is, sorry.
Go on, you ask.
I was going to say, so your concern is that potentially the federal legislation may not override the state legislation, and others, of course, we've heard are worried that it will.
Well, yes, that's right.
Senator Rice.
Yes, thank you. And thanks, Dr. McLean. And Reverend Duke, yes. Look, I would just start with where that conversation was at in terms of the clear, as long as the church or the school has got a clear public policy, that you feel that then you should be able to hire and fire and in fact have students that are pursuing in that are aligned with your ethos and beliefs.
I think the question was about employment, or that's what I understood the question was about. Yep.
Yep. And so be able to hire and fire in line with your beliefs as long as it's with a clear public policy. And I know that the Presbyterian Church, as you say, has got that clear public policy, and so that there are various staff that you wouldn't wish to hire and fire. Could you take us through what concerns you might have about people that you wouldn't want to hire or fire, you wouldn't want to have employed?
Sure. Obviously, in employment discussion, there's going to be all sorts of factors that people are going to be taking into account, but most of our schools will certainly want staff who are supportive of the Christian ethos. The various schools that the Presbyterian Church runs would vary in their in the sort of parameters in which they worked. So we'd have some smaller congregational-based schools that were more concerned to be clear that all staff members were professing Christians and active in the local congregation. The well-known sort of private schools would probably have a broader set of parameters, but they'd be still concerned about that the staff were consistent with their religious ethos and ready to support what was taught in the school.
So would this extend to not employing staff, for example, that are married in a same-sex relationship?
I probably would, yes.
Yep. And how about staff who undergo gender transition while they're working at the school?
That may be the case, although I think if it's a matter of while they're working at the school, I think the schools would handle that very carefully and want to have a long pastoral conversation and know, work with that person.
But quite possibly it could be felt that that's not in alignment with the Christian values and that they would be asked to leave.
Yep.
Yeah. And so your position is that this is appropriate for the Presbyterian Church and presumably more broadly across all religions and all faiths, as long as it's outlined clearly what their beliefs are.
Right, and that various religious bodies, as they run these kind of institutions, should be able to determine what's the appropriate parameters for their institution. And as I was saying, even I think within the Presbyterian Church itself, there'd be a range of approaches taken by the different schools.
How about for more fringe religions? Because presumably by supporting this, you're supporting the right of all religions, of all faiths, regardless. And I don't know if you heard my questioning of witnesses this morning about the Newcastle-based Church of Ubuntu that fired someone because they'd been vaccinated. And they said that that was in contradiction with our constitution and contrary to our position on what's required of us by our Lord God and Creator.
Right.
So as long as that's in their statement of policy, that this is what they believe, that would be okay? You'd support that as well?
On the face of it, yes. I don't know a lot about that case. I certainly had seen it got some media coverage. I wonder whether, if that was to be tested, say, under this bill, whether that church would be found to be genuinely a religious body. But, that's open to being tested.
Well,
and who knows
what's
what
a
would happen.
religious body, exactly.
But, yeah. Sorry, Chris, do you want to say something?
Could I just add something here? Sorry to interrupt. Well, first of all, I think the Church of Ubuntu would need to show that it met the High Court's well-established test for legitimate religion, and that the action was determined to be done in good faith, and that the action was determined to meet the test in Section 7.2 as reasonably considered to be in accordance with the doctrines, etc., of that religion, or the test in Section 7.3 around avoiding injury to adherents of the religion. Obviously, the legislation is predicated on protecting genuine religious belief, and you could not speculate on the purported beliefs of others. And we don't know anything about really Ubuntu, only that I've looked at their website, and it doesn't really tell me much. But anyway, I think that there are some regulations there that would need to be adhered to. That's all.
But can I just add, within those regulations, I mean, if a piece of legislation is actually going to protect religious freedom, I think the nature of the case is it's going to protect some things on the margins that probably most of us are not all that enthusiastic about. Otherwise, it becomes very bland and doesn't really protect anything.
Yeah, so it's basically, as long as it's a genuine religion and has sort of met the criteria of being a religion and that it's clearly stated that this is what they believe, that then that's an absolute. So that organisation is then able to discriminate against employees on the basis they don't support or aren't acting consistently with their religious
And I think
beliefs.
we have to face the fact that various religions hold views that lots of the rest of us will find quite bizarre. That's the character of religion, especially in a multi-faith community.
In your submission,
all
though,
those different practices.
that you say that that you are grateful that thankful that the bill aims to implement recommendation 3 of the Religious Freedom Review, that Australian legislation should reflect the equal status in international law of all human rights, including freedom of religion. Isn't that actually privileging religious belief over other attributes, other protected attributes?
I don't believe so. I'd heard that question asked a few times and seen it in the transcripts. I'm not quite sure what the basis of the premise of the question is.
If we move to the other aspect of where it seems to be privileging religious belief, it's in the statements of belief clause, and where we have had many submissions say that their view that by allowing statements of belief, it's actually privileging religious belief over and allowing people to be discriminated against. It's not actually creating inequality, it's actually privileging it. And in fact, we're about to hear from the Public Affairs Commission of the Anglican Church, who say that this provision gives an immunity to religious believers to make statements that may be totally racist, sexist, or which may ridicule people with disabilities and the like. It inappropriately privileges religious or anti-religious statements of belief over other people's rights to be free of discrimination, and gives religious-based statements a licence to be discriminatory in a way that would be unlawful for other kind of statements. So, can I ask you to why you believe that's actually not privileging religious belief, given that kind of statement?
So the bill does have restrictions about vilifying and malicious language, so there are certainly some limitations.
Pretty high bar, though, compared with other legislation, other anti-discrimination.
I think it also goes to the character of religion, that by its nature, religion requires statements and expression, and so it's appropriate that that be protected, particularly in the area of religion, whereas obviously in disability discrimination, the concerns are about access to services, access to buildings. So to realistically protect freedom of religion, expression, both expression in action and expression in statement, is inherent and intrinsic to the character of what religion is.
So in fact you're saying that in order to be able to practice that religion in some ways, it may require discrimination in other areas.
Well, it certainly, it requires some protection of expression, including verbal expression.
But wouldn't it be fairer just to have them at equal weighting? I mean, you actually say in your submission that the bill does not give religious believers the right to discriminate against others in the community. But it appears to me that it does. And you're saying that, in fact, in some circumstances it needs to.
Well, it depends whether we're talking about discrimination under the definition of the bill. As defined in the bill, it doesn't give.
I'm talking in particular about the statements of belief clause. At the moment, without that statements of belief clause, under state anti-discrimination law, there are various actions and statements which would be considered discriminatory. I mean, ones that we have discussed in the previous hearings are a patient with HIV who's told that AIDS is a punishment from God. A case in Queensland where a woman's employer wrote statements condemning her same-sex relationship in a book she was reading. A taxi driver telling a person with a visual impairment that their guide dog is unclean. And at the moment, under state legislation, those statements are discriminatory. But if the statements of belief clause goes through here, none of those statements would meet the high bar of being, vilifying, malicious, whatever. They would be permitted.
So I'm happy to say I'm not a lawyer, and I may not have this right, but I would have thought patients being told that HIV is a judgment by God from someone who's a medical professional would go against what would be a very reasonable code of conduct. And if that...
Their duty as a servant. Yeah, like
So if that has occurred, then I would have thought there is already provisions under which someone could be disciplined for doing that, and that wouldn't be protected by this bill.
Well, we need to look at those provisions because, in fact, this bill actually overrides a lot of those other provisions, those anti-discrimination provisions.
But it doesn't override requirements by an employer or by a service under a professional code of conduct where that's reasonably part of their service. And if we're talking about a medical professional making a statement like that...
We're talking to the Australian Medical Association later in this hearing. We can ask that question of them. So, but, I mean, it stands that those sorts of statements which are currently considered discrimination under state law will be overridden and would be allowed under this law, and you think that that's okay?
No, I said at least one of the examples you gave me, I don't think it would be overridden.
Okay. Well, I mean, so the woman's employer who writing statements condemning her same-sex relationship in a book she was reading.
May I ask if the supplementary to your question, Senator Ross, if our witnesses review the Australian Industry Group's evidence about their concerns about how certain workplace behaviours that some attached to religion would be treated differently to behaviours that might be related to sexuality, gender or political expression?
I'm not quite sure who that was a question to.
It was to you, and basically it goes to the point of privileging religious belief over other, against other areas that people should have the right to not be discriminated against.
Sure. So if that was a question, were we willing to review that submission and make a comment? I'm sure we'd be happy to do that.
But and in terms of the Australian Industry Group, their concern was that if a statement made on the basis of religious belief, it gets protection. If it's made on some other grounds, it doesn't get protection, and quite rightly, in my view, then has to be considered as to whether it's discriminatory against our other religious discrimination, our other anti-discrimination legislation. But is your view that it is appropriate, if it's made on the ground of belief, that it should actually override those other anti-discrimination provisions?
So I certainly think it's appropriate that a religious discrimination bill gives some protections to religious expression, including spoken. Once we go to particular cases, it really does depend on the particularities and whether it will be overridden or not.
I'll just conclude by, the Australian Human Rights Commission saying that they're concerned that Clause 12 will permit discriminatory statements of belief to be made, whether they amount to racial discrimination, sex discrimination, discrimination on the ground of disability, or any other ground prohibited by law. So it's pretty clear, according to some pretty senior experts, and we've had other discrimination experts give evidence to it, that in fact Clause 12 will allow discrimination that's currently not allowed.
I'll take that as a statement. I'm moving on to Senator Ben Small, please.
Sorry, Chair, just had to come off mute there. Can you hear me?
Yes, thank you.
Yeah, perfect. Folks, just a couple of questions, I think, that go to the need for this legislation. What experience can you relay, or what examples can you provide where members of your community have actually been discriminated against on the basis of their faith?
So in the states and territories without the legislation, I assume you mean Senator Small?
Yep.
Yes, that's correct.
Yeah.
Did you want to speak to that, Chris?
Well, at this stage, the area of concern that we've listed in our submission has to do with the experience in Tasmania, where offence was taken by statements were either made on social media or public. And when we consider that prior to the same-sex marriage plebiscite, that the Archbishop Claudius just published what the Catholic position was on marriage, and the Tasmanian Human Rights Commission took the Archbishop to task, just making a church statement on marriage, and that seems to be discriminatory.
Sorry, was that a Catholic church?
That was a Catholic.
Yes. Well, that's just an example. I'm just giving you an example.
Do they control the Presbyterian Church in Tasmania, or am I?
No. But we had two of our members that were taken to task by the same commission. Later, those charges were dropped, but in the process, it certainly presents problems when you end up going to court. You see, one of the things
it's not a court. It's not a court, and commissions are duty-bound to take complaints when given to them. Make sure you get the facts right there.
You've got to pay for lawyers. You've got to pay for lawyers to help represent you. So there's costs involved, and one of the things which, when we go back to the Human Rights Charter, is that there's not meant to be a hierarchy between all the human rights. And one of the things that we're dealing with at the moment is a clash of human rights. How do you actually how do you actually come to a situation where you allow people to have human rights and not have clashes? Well, that's for you guys to determine as parliamentarians, give us good laws. But the last thing that we want, and I think the last thing that any religious institution wants, is to be clashing over differences in the courts. And we want to be able to get on with our lives peacefully and to promote what our thoughts are in our religion. Our families want to raise their children according to their religious convictions, and that's not just for Presbyterians; it's for all those who have a religious background, and whether it be Christian or non-Christian, and for those who and those who have no religion at all. They also want to be able to express their beliefs, and so in the process of freedom of speech, we also need freedom of association, and that means that those people who are like-minded need to be able to express their views together in like-minded.
Can I just explore that point just in some, just to clarify, I guess. Effectively, do you see a need for this legislation to provide a shield against discrimination for religious belief or non-belief in the same way that Commonwealth legislation currently provides a shield for discrimination on the basis of sexuality, which seems to be a particular focus of discussion by some committee members here today?
Yes, I do.
And do you think that people of faith or people who choose not to have a faith are therefore unfairly compromised in having their human rights upheld because they aren't recognised by Commonwealth legislation as it exists now?
Yes.
And do you think that the presence of state and territory legislation that doesn't recognise the validity of religiosity, or indeed the choice not to have religious faith, unfairly impacts on the human rights of Australians today?
Well, yes.
Thank you very much. That's all from me.
Thank you, Senator. Senator O'Neill has one last question, and we're about to finish up.
Thank you. I think I'll have to put some on notice. But if I can go to the Sexual Discrimination Act, you make a claim in your submission representing how many schools and how many aged care facilities?
I guess there'd be 20 odd schools around Australia, something like that. In terms of aged care facilities, I think that they're mainly in New South Wales now, maybe a few in Victoria.
There's one in Victoria.
The Queensland Church just sold all their,
Okay.
or in the process of divesting
So
themselves
just
of.
on the scale that you
Yes,
can
I
respond
know
to.
that. One of them's in my electorate.
Right.
We can talk about it later. But
There is a lot of interest in the intersectionality of these religious discrimination bills and the attendant bills that are associated with it, and where it intersects with the Sexual Discrimination Act, particularly 38.3. My question really goes to the government has put out two different messages on the 1st of December. There were statements from Ms Angie Bell, Mr Sharma, Fiona Martin, and who was the fourth one?
they quote Mr Wrench as well. So.
Look, I don't think he was part of this team. The other one was Dr Katie Allen, said that they had done a deal with the Prime Minister to give their support to his legislation in that last week with the adjustment of that 38.3, the SDA dimension of it. I'm trying to get to the bottom of if that's the truth or not, because since then Mr Morrison's been telling faith-based groups that there is no deal, yet that's a matter of public record. That intersects with a part of your document. Right. So you say...
I hope you're not asking me to help you get to the bottom of that.
Well, keep your ears peeled and let us know what you find out. You say that the bill, as it stands, will not affect the operation of other anti-discrimination legislation, such as the Sexual Discrimination Act. Do you continue to hold that view?
I think the quote you read said the bill as it stands.
Yeah.
So, yep, the bill as it stands wouldn't affect the function of those other acts.
So if you could provide any amendments that you think are necessary to address the concerns that you have raised with us today, because everybody thinks that they can improve on what the government has provided. I'm sure that you might have a few views. I'd be happy to hear from you with regard to that. And can I just ask you, as men of faith, in the light of the outcome of the plebiscite, where we had a 63%, I think, voted for the change to the marriage equality laws, but there was, the remainder voted in a different way. How difficult do you think it is for people, particularly first generation people of faith, to actually continue to make a claim in the public place that they still believe that marriage is between a man and a woman, and to be able to move alongside their fellow Australians who hold a very different view about marriage equality? You're doing it as men of faith. How easy or difficult is that? Because you're interacting with this all the time.
Thank you. I think that a lot of our members, church members, do find that difficult in the workplace, especially, where workplaces, ask or expect at some level some affirmation of same-sex marriage. And I think we're talking about a lot of believing Christians who aren't eager to make a fuss about it. They don't want to make a fight about it. It's not that they want to go out and be critical of people, but they have in good conscience, they hold that marriage should be between a man and a woman for life. And being asked to endorse and celebrate something else does put them in a difficult situation, and they're not quite sure how to navigate that. Yeah, I think they're genuine difficulties. I don't think it makes sort of news a lot, because probably the general response that people have is to try and just not make a fuss and just try and ignore it and hope it goes away, or that they don't get pushed too hard about not putting the right email flyer on their email or whatever it is. But yeah, I think there are a significant group of people in our churches in large corporations and public services that find that difficult. Yeah.
Thank you.
Reverend Duke, have you got anything to add quickly to that?
Yeah, look, I think most of our people probably still adhere to our belief statements. We do have a belief statement on marriage, sex and gender. And it takes the traditional biblical view in these areas. But we're not out there trying to promote that particular aspect of our belief system. The church is about the gospel of the Lord Jesus Christ and promoting that. And therefore, we're in the business of conversion, but we don't convert anybody. God does it. It changes the heart of a person. And that's what we're on about. And some of these other areas are important to some people, and that's important. We want to be compassionate with all people. But at the same time, we also are a denomination, a church that has a particular belief system, interpretation of the scriptures, and we adhere to that, and our people adhere to it. But that's part of life, and as a person who's been a Christian for most of my adult life, there's always tensions. There's always been tensions in the workplace as to how you live your faith in work and with other people who have different opinions, and that's one of the things you do in as you mature in your personality and in your faith, that you endeavour to still have your strong convictions, but you also endeavour to also act Christianly towards people with love and compassion and insight.
Thank you. Thank you very much for that. Thank you for appearing before the committee today and for giving of your time. The committee requests that any answers to questions taken on notice, which the Secretariat will provide you, are provided to the Committee Secretariat by the close of business on the 20th of January 2022. Thank you, gentlemen.
Okay, thanks for your time.
Thank you.
Thank you. Thank you.
I now welcome representatives of the Public Affairs Commission of the Anglican Church and representatives of the Anglican Diocese of Sydney, both via video conference. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. You can just nod. Yeah, thanks. For the Hansard record, could each of you please state your full name and capacity in which you appear today?
So my name is, can you hear me? My name is Carolyn Tan and I appear as the Chair of the Public Affairs Commission of the Anglican Church of Australia.
Thank you.
My name is Michael Stead. I'm the Bishop of South Sydney and I'm appearing on behalf of the Anglican Church in the Diocese of Sydney.
Thank you. I now invite members of the committee to ask questions, and I believe the Deputy Chair is raring to go.
Thank you, Chair. You're getting used to me. Thank you very much for taking the time to appear for our inquiry. And so my first question is to you, Dr. Carolyn Tan. So my understanding is broadly don't support the bill in its current form, particular concerns about the statement of belief and the extent of exceptions for religious bodies to discriminate. And my understanding your submission is that, it says, and I quote, at the heart of your objection to the bill is that section 12, the statement of belief clause, should be removed. Your submission goes on to say that the provision gives an immunity to religious believers to make statements that may be totally racist, sexist, or which may ridicule people with disabilities and the like, end quote. Is it your view that section 12 would cause harm if it remains in the bill and the bill is passed?
Yes, I do. It is my view because there is no reason why you need to give that immunity or the ability to override other discrimination legislation. People are still free to make statements of belief, providing they don't do it in a way that discriminates. And if you look at where the harm lies, well, obviously there's greater harm lies with the person who is being discriminated against, whereas for the person who wants to make a statement, they can do it in a way that is not discriminatory.
Okay, that's a good way of saying it in terms of where the harm lies. Your submission raises concerns about other laws which might be prescribed to be overridden by section 12 in the future. And are there any particular laws you would be concerned that might be prescribed by section 12, subsection 1C?
Well, I suppose there's always the fear of the section 18C of the Racial Discrimination Act has been under threat for a long time.
Okay.
That's one possibility.
All right. Okay, thank you. And the test for determining whether something is within the doctrines, tenets, beliefs or teaching of a religion is whether a person of the same religion as the first person or religious body could reasonably consider it to be in accordance with the doctrines, tenets, beliefs or teachings of that religion. Your submission raises some concerns about this test. Could you explain why you're concerned about this test and what you consider the test should be?
Yes, the concern is simply that it's the one other person in the religion test. Whereas, we had suggested that it should be something that is either a more objective test or that it's at least something that relates to what the leaders or the people in authority within a religion think the other doctrines and tenets. And that's usually the way it works with it. When there is a more objective test, a fair bit of deference is given by courts and tribunals to what the leaders say the doctrines are.
So, yeah.
I suppose the concern that there might be a small minority of people who have a particular misguided interpretation of religion.
And
the test
so
should be
if,
something more higher than that. So
if it's the Pope in Rome or the Archbishop of Canterbury, is it? The you'd have more faith is not the right. You'd have more confidence in that test rather than the man on the Clapton omnibus, so to speak.
In a sense, but obviously, For instance, in the Anglican Church, there's a wide variety of views by different leaders, and you're probably going to hear two different views today.
I think my next question to your colleague might draw some of those out. So
Yes.
Yes, but so we're not saying it's got to be, the unanimous view, but as long as it's a substantial view amongst the leadership,
okay,
and not something just a minority bizarre view.
all right. Thank you very much. I now going to Dr. Tan. I'm now going to ask some questions of Dr. Steed, from the chair of the Religious Freedom Reference Group, and your submission from the Anglican Diocese of Sydney says that, and I quote, "People of faith are facing increasing hostility in Australia," end quote. And it refers to examples on a website. Could you provide the committee with examples from your own faith community, the Anglican community, where people are facing increasing hostility? And what have Anglicans in the Diocese of Sydney told you they are actually experiencing, Dr. Steed?
Thank you for the question. The point that we make in the earlier in our submission is that we are arguing for protection of religious belief for all religions, not just for Anglicans in Sydney. The reality is that Anglicans in Sydney, we're not a persecuted minority, but we're speaking up for Jews and for Muslims who experience much more persecution than we do. So no, there is not a lot of direct discrimination for individual Anglican Christians in the Diocese of Sydney, but we want to protect people of all religions, not just our own.
So you're relying on the information on that webpage rather than the actual reporting of people in your parish? Is that the right term? Sorry, I should know. I am married to an Anglican, but...
No, that's fine. Your question was specifically about discrimination. So people in Sydney do report that they're experiencing adverse treatment on the basis of their religion, but it doesn't amount to discrimination. We have been called bigots and homophobes and all kinds of to me, offensive things, but I fully concede that doesn't rise to the level of discrimination.
Okay.
This bill won't make any difference to that. So yes, people in the pews are worried about the rising tide of hostility directed towards people of faith, but it doesn't amount to discrimination.
Okay, and all right, can I take you to paragraph 34 of the Anglican Diocese of Sydney submission, where you say that, and I quote, "Clause 12, subsection 1A, should be understood as nothing more than a provision for the avoidance of doubt, not as a provision that takes away existing anti-discrimination protections. Can I ask you to consider whether a statement of belief as defined in the bill could constitute discrimination under Section 18C of the Racial Discrimination Act? If so, and if Section 18C was prescribed under Section 12(1)C of the bill, would that protection remain?" And I think you heard Dr. May's earlier answer.
Yeah.
Dr. Tan's earlier answer, sorry.
There is a political question about whether that's ever going to happen or not. So part of the discussion that went into the drafting of those... So I would preface that by saying you should ask that question to representatives of the Islamic and Jewish communities, because we had long discussions with the government on that very issue. They were content that the current form of this bill, without prescribing, does not override the Racial Discrimination Act. And then it's a political question about whether the government would ever seek to override 18C by prescribing that.
There's been clear expression from members of the government that that's still their preference.
That the government intends to override 18C?
No, I'm not saying that's the government position. I'm saying that there are people, members of the coalition, have made that very clear. Including senators, have made that very clear that they would like to override Section 18C.
Yes, but I don't believe that anybody has suggested that using the Clause 12 is going to be the mechanism to do that.
Okay. All right.
And I just don't think that it's politically likely at all.
All right, thanks very much, Dr. Steed. Good submission.
Thank you.
Thanks, Chair.
I'm going to Ms Hammond. Thank you.
Thank you. Thank you very much. Thank you both for your submissions and for appearing today. Can I ask, somewhat perhaps naively, what's the relationship between the PAC? In what capacity and who do you represent, the two of you? Because you do have diverse views, which I think is also really interesting for this. It's really good for this particular committee and this hearing that two members of the same faith are representing two different views, because that is the reality of most faiths, that of people, how they live out their faith can be very vastly different. So can I just get a better understanding of that? Dr. Tan, perhaps first.
Yes. Well, the Public Affairs Commission is a commission that is set up under the canons of the Anglican Church of Australia, which is at the national level. And that is a commission that's appointed by the Primate of the Anglican Church on the recommendation of the Standing Committee of the Anglican Church. So it's we have members from all around Australia, but we are only able to speak for the Public Affairs Commission. In fact, no one can speak on behalf of the Anglican Church as a whole, because there are such diverse views across the church, which I suppose the Anglican Church at a national level operates a bit like a federation of different dioceses and 23 dioceses. So yes, our authority is only to speak on behalf of the Commission, even though we've got that role of speaking on public affairs.
Great, thank you, Dr. Tan. And so, Dr. Stead, are you representing the Primate?
No, so I'm representing the Diocese of Sydney. So the Diocese of Sydney is the largest of the 23 dioceses of the Australian Church. I'm also speaking on behalf of Anglicare in Sydney, which is one of the Anglicares in the Anglican network. It's the largest of the Anglicares, but again, it's only one of a number of bodies that make up Anglicare. And on behalf of 40 Anglican schools in the Diocese of Sydney, which again is the largest grouping of Anglican schools. So again, I'm only speaking on behalf of the Diocese of Sydney, but I am speaking representatively in that capacity, certainly not for the Primate and certainly not for any other diocese in Australia.
Right, thank you. I think the differences between the two submissions and representations from the two of you do actually represent, quite a bit of the diversity of the views on this particular bill and this particular issue. Can I just understand, Dr. Tan, from the PAC's point of view, do you think that there is a need to protect religious beliefs?
There is a need to protect against religious discrimination, yes. And we support the principle of a religious discrimination bill, even though we said our first preference would have been to see it as part of a Charter of Rights or a consolidated piece of discrimination legislation. But in the absence of that, given the piecemeal nature of it, yes, we do certainly support it. Not, as Bishop Stead has indicated, not so much for ourselves, because Anglicans tend to be in the majority, or at least not discriminated against and are not that obvious in our religious dress or otherwise. But certainly for the other minority religions and who have difficulties with things like religious dress, with days of that they need to have as a Sabbath rest, and those sorts of groups. They certainly need protection, and we've heard the statistics about discrimination against Muslims, Jews, Sikhs, and the like.
Yeah. Picking up on a comment you made earlier, Bishop, you mentioned that people, there's been no Anglicans, the people that you're representing or speaking on behalf of, are not reporting discrimination, but certainly concerns. You're hearing concerns from the pews about comments made and names being called. Do you have concerns that could lead into discrimination?
Yes, I do, and that's the reason why we're supporting this bill, is because I think it establishes a line in the sand to say, no, we believe that people of faith deserve to have their beliefs, that they're able to hold them and to articulate them without fear of ridicule, of adverse treatment. The more the bill can establish that at a higher level, the more that it will have the trickle-down effect and hopefully will help us to become a more diverse country where we can actually tolerate difference of the belief without having to shut down beliefs that we find offensive.
Yeah, yeah. Now, you mentioned 40 schools in the Diocese of Sydney. How many students would be in them?
40-something thousand, 45,000 students.
Wow. And how many teachers, do you know?
Oh, it's something like
All
3.5.
staff.
Yeah, it's something like 3.5 or 4,000.
Okay. Now, do you, and then Anglicare, how many people would Anglicare, I know you support huge amounts, Anglicare is a phenomenal organisation. How many people would you employ in Anglicare?
Oh, it's well in the thousands. I don't have the number in front of me, but the last time I looked, I think it was 3,500. And then there's volunteers, which would be another, probably that number again, 2,500, 3,000 volunteers, people who voluntarily come into aged care facilities or other Anglicare properties. They're not employees in a technical sense, but we consider them as people who are engaged in the work at Anglicare.
And it would be, correct me if my understanding is correct, the work that you do through Anglicare and the services you provide, they're not done on there's no religious test to the services you provide, is there?
No. So we're not arguing for the right to discriminate on the basis of service provision, but Anglicare does want to be able to reference the employment of Christian staff in certain key roles, and for Anglicare to be able to work out what those roles are rather than having some court or tribunal or some other body determine when and where they can't employ Christians.
And why is that important? Is that important to the ethos of Anglicare? Or I presume you have the same position when it comes to schools. Why is that important?
Because we believe that the people who work in these organisations actually shape the ethos. It's not just good enough to have a doctrine of belief, a statement of belief plastered on the wall, to actually have it embodied. And so we believe that Anglicare does what it tries to do, which is to love people in the name of Jesus. It does that by having people who believe in Jesus doing that work. Very hard to do that with people who don't have a faith commitment as Christians. Now, lots of people who are not Christians, lots of people of very different religions work for Anglicare, but they understand that they're working for an organisation with a strong Christian ethos, and they embrace that.
Yeah. And so that doesn't tend to cause tensions or problems, or if it does, they're random and, in the size in the population size of across the schools and Anglicare, you'd always anticipate that there'd be some personnel problems because that's the nature of life, regardless of what it is. But in the whole, it doesn't cause a problem.
No, it doesn't. So the current arrangement works very well from our point of view, and we believe from the point of view of employees. We don't have people complaining that they've been discriminated against on the basis of religion. In our schools in Sydney, and it's probably true across most Christian schools, the Christian teachers would actually be in the minority. Probably only about 25% of the teachers would be professing Christians. But we think having 25% of the teachers as Christians is enough to create a Christian ethos to shape the flavour of the school. And so we will preference the employment of Christian staff where we can, but obviously if you're employing a geography teacher, first and foremost you want somebody who can teach geography, so but if you have two equally qualified people and one's a Christian, one's not, we will probably go with the Christian one.
Yeah. And so you'd look at it in the entirety, I guess, of that particular community too. So that particular school or that particular branch of Anglicare. So it's not like a set percentage of, 20% across the board. You look at it.
Absolutely. All of our schools in Sydney, they don't all operate independently, but certainly many of them have quite different approaches to employment. And likewise within Anglicare or the other institutions that we run, there'll be different policies in different parts of the organisation. Not surprisingly, those who are doing chaplaincy-related services, there'll be a higher percentage of professing Christians in that work than in some other parts of Anglicare, for example.
Yeah. Now, some of the concerns that have been raised by others, Bishop, and I think it goes to part of the issues that Dr. Tan raised as well. In my mind, they come down to, is this bill going to be used as a sword instead of a shield? Is it going to be used aggressively by people to vilify, attack, even though they're all banned? But is it going to be... Do you have concerns about that? I mean, obviously, as a Christian, you would be you want to be able to express your faith, but you also don't want to be able to diminish the mean.
Absolutely. The point that we make in our submission is that I don't think that the first part of Clause 12 is actually doing anything new, because I think that any statement that is not malicious, not vilifying, not all those other things is not going to be discrimination. So to the question of whether it's a sword or a shield, my question would be, are there examples of Christians who are currently saying things which have found to be discrimination that this bill is now going to permit? And the answer is no. I've trawled through every judgment I can find, and I can't find any example of somebody having made a genuine good faith statement of belief that has been held to be discrimination under any state or federal act, which would therefore be permitted by Clause 12. Why Clause 12 is important is because of the places where it has been used, where other anti-discrimination law has been used as a sword against statements of belief. And I'm thinking particularly of Section 17 of the Tasmanian anti-discrimination legislation. And so we don't want Clause 12 because it's a shield, a sword for us against others. It's as a shield against the overreach of insult and offend laws in other jurisdictions.
Right. Okay. Thank you. Dr. Tan, did you want to make any comment on that?
Well, I suppose the concern is, I mean, we've heard examples from various organisations of the types of things that might amount to discrimination. I mean, employers might be putting up signs about people requiring gay people to repent or something like that. Now, that might not be enough to amount to harassment, but it might certainly insult and the particular workers. It might be discrimination. My view is if in fact Section 12 doesn't do anything useful, it's better to take it out because it only causes greater division.
To be clear, I'm not saying Section 12 doesn't do anything. I'm saying Section 12(1) doesn't do anything beyond state what I think to be the current law. Section 12(2) and 3 are vital to prevent the kind of overreach that's happened in Tasmania.
May I ask a question? Where have you seen those examples of overreach? I understand the Tasmanian case you refer to was withdrawn, so I'm not very clear as to how it's seen as overreach.
So there are 4 examples in Tasmania of which I'm aware, although they were eventually withdrawn, in each case there was a long and protracted period of mandatory conciliation. And in one case, the first complaint against Dr. McGee was withdrawn. He's now facing a second complaint, which, as far as I know, has still not been resolved. So, and the very fact that people are having to answer for statements that they've made, statements of belief in public, and having been put to the expense and the inconvenience of having to appear before these commissions is examples. So that's 4 that I'm aware of. I'm not aware of any others in any other jurisdiction because Tasmania at this stage is the only one that has an insult and offend law, if I can categorise Section 17 as that.
I might put some questions on notice to you with regard to that because I know we will be short on time. Chair, do I have time to take the call?
Yes, I have now finished, Senator and Chairs.
Thank you, Ms Hammond. And Senator Pratt, over to you.
Thank you very much. I want to ask, please, both of your views in relation to a protected attribute and the extent to which, for all attributes, that should have some capacity for people to have their own statement of belief about that, whether that's in or without a religious context, because I'm still somewhat confused about why a statement of religious belief needs privileging over other statements of belief, noting that a belief about an attribute, for example, might be positive or negative in relation to that attribute, but still have a religious foundation to it. So there's kind of 4 quadrants to that question, if you like, and I'm somewhat confused by the fact that this legislation does not resolve those questions on an equal footing.
Perhaps I could start by saying there's obviously no laws against statements of belief unless they are discriminatory under particular anti-discrimination legislation. And once something is discriminatory under anti-discrimination legislation, I would have thought in most cases that should be unlawful.
Right. And so in that context, why do we need a statement of belief that is able to be discriminatory versus, someone in a secular basis that says, well, my statement of belief about sexuality is not protected when a religious statement about it might be protected. Why do you not have the same view as the public affairs?
To my earlier point, I still maintain that statements of belief, which meet all the other tests in Clause 12, are not discriminatory. So that I'm not arguing for protection for genuinely discriminatory statements of belief.
Okay, so I guess my question then is, why not give all statements of belief rather than just religious statements of belief, or perhaps all statements of belief about personal attributes, or all statements of belief about...
I think the answer is only because
the same protection.
I think the answer is only because we're in a religious discrimination bill. As a matter of principle, I fully support the idea that all Australians ought to be able to make non-vilifying, non-malicious, good faith, reasonable statements of personal views without being subject to Section 17 of the Anti-Discrimination Act in Tasmania or something equivalent to it.
So why do we have a bill, therefore, that's not about protecting religion as an attribute?
Well, it's only because it's actually
rather just not just religion as an attribute, but also these beliefs. And how do you reconcile the idea that employers, for example, it might be all very well for a religion to be able to make that statement, and I'm not necessarily saying that it is okay, but that therefore even in a workplace you get statements of belief that are not on a level playing field, even outside a religious institutional context. And Dr. Tan might also like to comment on that.
I think my answer is the same, which is this is a religious discrimination bill, and the government's been very clear that it's not contemplating something wider than that. It's not trying to protect the full orb of thought, conscience and belief protection. It's not protecting freedom of expression, and it's because of the limited scope of this bill. But to the point, it's because it's addressing a particular harm. There have been examples of people whose religious speech has been shut down, or of people who've attempted to use tribunal processes to shut down religious speech, and therefore that's what's being responded to here. This bill is responding to a particular pressing issue.
I understand the way that's been framed, but I guess the question is in relation to attributes that where a statement of belief about an attribute is protected if it's of religious nature, but not if it is of any other nature, and it's very perplexing in relation to how we can have rights that sit alongside each other. Dr. Tan?
Well, I think my position is the case that there shouldn't be that distinction between religious and other types of statements of belief. But the difficulty we have is, in fact, that this is a religious discrimination bill. That's why our preference had been for some form of consolidated legislation or a Charter of Rights, in which you can sort of look more consistently across a range of different attributes and issues. Could I also just add, I suppose the difficulty with the issue of frivolous claims and tying people up is, unfortunately, in the law, one sees a lot of that. Not necessarily about matters, but everything. And you can't legislate against frivolous claims.
Thank you, Senator Pratt. We're going over to Senator Rice.
Thank you. Thanks, Chair. And thank you both for your submissions. Dr Tan, I just wanted to expand on what you just repeated there, that you'd prefer to see a Charter of Rights rather than this approach, which I think you've described as piecemeal nature of anti-discrimination laws. It's essential that such laws protecting against religious discrimination are designed in a way that's consistent with the operation of other anti-discrimination statutes and do not derogate in any way from these protections. It's essential to protect all human rights of vulnerable people. Could you just expand on why having a Charter of Rights would be a better approach?
Well, because you'd be able to look at all human rights in the same context. I mean, we're talking about human rights as being indivisible. And therefore, there needs to be some form of consistency where you can try to protect all the different types of human rights rather than chopping them up and having to look at different pieces of legislation. I mean, and even with religious freedom, that's an important right, but under Article 18.3, it's subject to the fundamental rights and freedoms of others. So you need to have a system where all of those can be judged together.
And going particularly to the difference that you and Dr Stead have on Section 12 as to whether it's actually going to allow overriding other rights, or Dr Stead saying that no, it's not going to do that. Would that sort of problem be fixed if you actually had more inclusive, integrated legislation?
Probably planned. Consulted with the state.
It might. It might be easier if that section was removed altogether. That's my point of view. But
yes, and essentially you wouldn't need a section like that if you had integrated anti-discrimination legislation.
Well, one would hope not. It depends on how that legislation is drafted.
Senator Rice, can I just ask a clarifying question, perhaps for you? And when you talked about a Bill of Rights, are you also sort of wrapping up in that harmonising of the laws across all the jurisdictions? Are those two things separate or the same in the way you just asked that question?
Well, I think we need to have that discussion as to what a Charter of Rights would look like and whether it would harmonise across state and territory and the federal and federal legislation.
We did try that about 10 years ago,
Yeah,
but
yeah.
you might recall. But we're drifting from.
We are. That's right.
Dr Tan and Dr Stead. Any more
Yeah.
questions, Dr.
And look.
Senator Ross?
Can you just then sort of outline, I mean, we've talked about the problems that you feel that Section 12 needs to be withdrawn, but the risks of legislating in this piecemeal way. I mean, just in summary, what you see the risks of legislating in this piecemeal way are compared with having integrated, coherent anti-discrimination legislation or a Charter of Rights?
So it's, from my point of view, it's not so much, well, I suppose risks may not be so much the issue, but just the inconsistency behind it all. I mean, one of the complaints we made is that really the Australian Law Reform Commission looking into exemptions relating to the Sex Discrimination Act should have included any exemptions or exceptions here as well, because there needs to be consistency across the board. I mean, we talked about the situation of is someone discriminating on the grounds of sex, or are they discriminating on the grounds of religious belief about sex? They tend to be wrapped up together, and it's well, I suppose the risk is, in terms of worrying about cost and factors like that, is that one may be dealing with two completely different processes over the same set of facts.
I mean, you note in your submission in paragraphs 40 and 41 that it may be possible for existing students at a religious school to be expelled or penalised for their religious beliefs if such conduct is in accordance with the doctrines, tenets, beliefs or teaching of the religion, and that the ability to dismiss or penalise teachers for their religious beliefs, which may also change after they're employed, is too severe. So again, if we actually had that integration, you would actually be able to weigh these up more appropriately. Is that what you're saying?
yes.
Yeah. Finally, you also note in your submission that most Anglican bodies, like schools, welfare agencies, aged care facilities and the like, have no intention of discriminating against people on the grounds of religion in provision of services. So, firstly, do you know of some Anglican bodies that do discriminate, given that you said most? But obviously, do you have concerns that the provisions of this bill will obviously apply to all religious organisations, not just Anglican ones?
Yes, I mean, I'm not aware of any that do want to discriminate, but the difficulty with the term discrimination is that that also picks up preferences. So you need to be able to, I suppose, enable preferences without allowing general discrimination. That's and we've talked about the need. The preferences may be based on well, if in terms of services, perhaps be able to preference people from that religion within schools or within aged care homes, because people need to be able to have the facilities of worship and pastoral care, and obviously there's the Section 10 special needs situation, but it's, I suppose, not that clear what is actually a need, and therefore more widely framed clause might be better.
Mm. And are you concerned about the ability of other religious bodies to be able to discriminate in their services under this legislation, even if the Anglican bodies aren't doing that?
Oh, yes, that is a concern.
Right. One last question to Dr. Stead. With the discussion I've just been having with Dr. Tan about support for a Charter of Rights, does the Sydney Diocese have a view as to whether a Charter of Rights would be an appropriate way to go rather than this type of legislation?
We are concerned about the complexity of that exercise should not be underestimated. The fact that it was 11 years ago that the then Labor government attempted to consolidate all federal anti-discrimination acts before there was a religious discrimination bill, and then had to ditch it because it was too hard. It is very complicated. We've been talking about a religious discrimination bill since 2018, since the Ruddock inquiry, and it's taken this long to get where we've got to. My concern is that any attempt to pursue a charter or an integrated anti-discrimination act is going to so delay the protection of religious discrimination that it's just, if I can be blunt, kicking it off into the long grass rather than dealing with the issue as it presents.
Thank you, Senator. Senator O'Neill.
Thank you very much. Just to both of you initially, do you support the passage of the legislation with amendment or without amendment, or do you oppose the passage of the legislation? Perhaps Dr. Tan first.
We support the principle of the legislation, and not particular form. So we would support the passage of a substantially amended piece of legislation.
Thank you. And Bishop Stead.
We would support the passage of the legislation with minor amendments. In our submission, we highlight three very minor changes, which I think are uncontroversial. I think they're actually drafting errors as much as anything else. We'd certainly like to see those things fixed. And we'd make three other suggestions, which are in the nice to have rather than have to have basket. So
go on.
No, that's fine.
Can I thank you both for the very careful submissions that you've put, and like other colleagues, indicate how potentially difficult this might have been for you to appear together, but how powerful it is to see that there's a range of views within the different faith traditions, yet common shared values and beliefs enough to identify under the same banner that has accommodated for centuries, actually. So my second major question is to Section 12(1)(c). You'd be aware that there are concerns in the community that that particular section might be then adopted by a government and used to water down Section 18(c) of the Racial Discrimination Act. To allay those concerns, which are quite strong in the community, would you support an amendment to prohibit the government from prescribing Section 18(c) by regulation?
I wouldn't be opposed to that. I would prefer to see a legislative override in a rewritten 12.2 that actually overrode inconsistent state and territory legislation that makes it an offence that makes the moderately expressed statement of belief an offence, however framed, and therefore you wouldn't have to prescribe Section 17.1 of the Tasmanian Act because you actually enshrine the principle at a federal level, and that would then also protect 18C.
Okay, thank you for that. And Dr. Tan?
We have concerns about Section 12 as a whole, but certainly if it was to remain, we would prefer to see Section 18C protected, so not able to be prescribed. But they're probably, the difficulty with that is you're protecting a particular section, and legislation will change from time to time. So it's difficult to just say that one particular named section is to be not prevented from being prescribed.
Thank you. Finally, I know that in our last hearing we had evidence from the Christian schools that they'd been advised by the Prime Minister that there was actually no deal that had been done between the Prime Minister and members of his backbench, including Dr. Katie Allen, Mr. Dave Sharma, Ms. Angie Bell and Ms. Fiona Martin, with regard to the Sex Discrimination Act, Section 38.3. I've been asking participants in this public conversation, and I know that you do confer with the Attorney-General and other members of the government in helping them consolidate their views around this issue. Do you know the truth? Is there a deal with the Liberal backbench, or is there no deal? And what have you been advised by the Prime Minister? Bishop Stead.
I can't provide any more information to you than what's already on the public record. So we know what you know from reading it in the newspapers. We haven't had any guarantees one way or the other from the Prime Minister or from the Attorney-General about 38.3. Our view is, for the record, that 18.3 can't be...
38.3?
Sorry, thank you. 38.3 shouldn't be repealed in its entirety because it goes too far in seeking to address the presenting problem. So if there needed to be a particular restriction that says that a school can't expel a student on the basis of their sexuality or gender, that's fine. But taking out 18.3
38.3.
Thank you. 38.3 has unintended consequences that go much wider than that.
Okay, so to be clear, you think there could, within this piece of legislation, be a carve-out, particularly for students, to deliver that in a timely way because they've been waiting already for a long time?
Oh, well, not in the Religious Discrimination Bill. Are you saying in the Consequential Amendment Bill?
Yes.
If that has to be, it could be. My preference would be to wait for the ALRC to do that work because it's a bigger question. But yes, if there needed to be a very targeted restriction to 38.3, then having it in the Consequential Amendment Bill would be acceptable.
Thank you, Bishop Stead. That was very clear and helpful. And finally, Dr. Tan, in response to that same question.
Yes, we obviously believe that it's something that should be the subject of an ALRC response. But just in relation to the earlier question, no, we have no knowledge about what the government's deals are. But we certainly would like to see amendments to Section 38. But they need to be done properly, and we would await the Law Reform Commission's response on that.
Thank you.
Thank you for appearing before the committee today and giving your time. The committee requests that answers to questions taken on notice are provided to the committee secretariat by close of business on the 20th January 2022. Thank you.
Thank you.
I now welcome representatives of the Australian Women's Health Network via video conference. Can I confirm that you can hear us? I think you're on mute.
Thank you, I can hear you.
Yes, I can hear you. I can hear you too.
Good, thank you. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Before we begin, could I ask each of you to state your name and the capacity with which you appear for the benefit of the Hansard transcript?
I'm Helen Kelleher. I'm the Deputy Chair of the Australian Women's Health Network, who I represent today.
I'm Emma Winscombe. I'm a board member of the Australian Women's Health Network, who I'm representing today, and I'm also the CEO of Equality Queensland. I'm Diane Hill. I'm also a board member of the Australian Women's Health Network. I'm also the CEO of Women's Health Victoria.
Thank you. I'll now invite members of the committee to ask questions, and we'll start with the Deputy Chair, Mr Graham Perrott.
Thanks, Chair, and thank you for your submission. And my reading of it, you don't support the bill and don't see a need for this legislation, but I will go to some specific questions. Your submission says the bill, and I quote, will affect access to sexually transmitted infection screening and prevention, contraception and abortion, genomic screening to prevent chronic illness, fertility treatments and maternal health care, end quote. Can you give examples of how you anticipate this religious discrimination bill will affect those health services?
Thank you. We know from centuries of evidence that women's bodies are a contested space, particularly in healthcare, and particularly subject to religious beliefs about women's autonomy and independence, and attempts to control all of those things. And we know that women have constantly, over many decades, had to make the case for their rights, only to see them challenged again and again. And this bill, we see, is another way to do that. So we know that the social policy, and we see the bill as a form of social policy that will be intended to become law, needs to reflect the health needs of all women, and that is that healthcare is provided without prejudice and without discrimination. So we have many examples of how women's healthcare is impacted by people, for example, expressing statements of belief, medical and other types of health professionals, and that's not a new concept. That's not a new occurrence. It happens constantly. So, for example, for one of the health lines, a 19-year-old caller who was 9 weeks pregnant from rural Victoria went to a first GP. She was refused service, wasn't referred on, told that she, as a woman, was sinning if she doesn't go ahead with the pregnancy. That is a very, very common situation that we see. Emma, do you want to add to that?
Absolutely. We've also seen cases where we've had women present to general practitioners experiencing domestic violence, and we've had general such as marriage is a sacred institution. You need to return to your partner, to your husband, to work things out. So we've seen cases that are of religious statements of belief that are actually causing real harm to women. We've also had instances of women going to seek healthcare where they're being told that if they're unmarried and they're engaging in sexual intercourse or sexual activities, that they're sinners, that they're not, that they're going against the word of God. So that is impacting on their ability to receive sexual health screening and sexual health and reproductive care.
Okay. Thank you. Going to that in more detail, your submission expresses concern about the impact of this bill on women who are sole parents and or unmarried, as you've touched on. And so do you consider the bill will disproportionately have an adverse impact on women, and if so, why?
We do, and we've used some illustrations of healthcare where we know that discriminatory statements are made about women's, particularly their sexual and reproductive health. It happens in other areas as well. But we're also particularly concerned about community service organisation access. Women are the greatest users of community service organisations. It might be that they're seeking to leave a violent relationship, or it might be just poverty because they're single mothers. As you know, single parent families are primarily headed by women, and the reasons for that are many and varied, which we don't need to go into today. But we also know that community service organisations are primarily led by faith-based organisations, and that they do currently have the power to just decide who gets services and who doesn't. And we fear that this bill will actually strengthen that power. Di, do you want to add to that?
Thanks very much, Helen. Yes, we are very concerned that this bill has enormous potential to both to impact women in terms of both gender equality and their access to reproductive and sexual health services and mental health services, as we've already outlined. We know that the drivers of violence are gender inequality, and we know that beliefs about women, about women's rights to access care, about women's rights to participate in the workforce, and all of those things are impacted by other cultural norms and beliefs. Our big concern is that this bill actually then favours and prejudices religious beliefs that have the capacity to create a new policy norm and a new legislative norm that will actually further undermine all of the work that we've done in relation to improving access to services for women in healthcare, in education, in employment, and also the overriding gender equality.
Thanks very much, Ms Hill. And my final question, the Women's Health Network submission says in relation to statements of belief that, and I quote, "The bill is then effectively a licence for discrimination," end quote. So can I just confirm for the purpose of this inquiry that you impose the entire bill? Are there any amendments that would cure your concerns about this bill?
No, we oppose the bill. We believe that existing discrimination law could be strengthened. It's not perfect. We still see, as we've illustrated, examples of discriminatory statements made to women on the basis of their gender and their help seeking. But we don't see that religious bodies should be given any further privilege over secular bodies. We're also, go on.
So you couldn't send it back to the kitchen to be repaired, you just throw the whole dish out?
We would.
Okay, thank you.
Thank you, Deputy Chair. I'm handing to Senator Small.
Thanks very much, Chair. And if I can just maybe continue on from the Deputy Chair's point there. Currently, Commonwealth legislation prevents discrimination on the basis of sex, age, race, etc., and yet doesn't provide any protection to those Australians of a faith. Are you suggesting that that is an acceptable status quo going forward?
People of faith have the freedom of expression as any other Australian does. What they don't have the right...
I'm asking a very specific question, if I can, Ms Kelleher. Discrimination law affords a shield to Australians against discrimination on those attributes that I mentioned. One of the attributes that cannot be left at the front door when you leave your house, just as you can't leave your sex, your gender identity, your attraction to persons of same or the other sex, your age, you can't leave those attributes behind, just as a person of faith or a person who chooses not to have a faith can't leave that when they leave the front door in the morning. So why is it acceptable that those Australians not be afforded the same shield against those other existing protected attributes?
We would see that a human rights, like having an Australian-wide human rights legislation and anti-discrimination that affords rights equally to all people would be the best solution, rather than having a religious discrimination bill.
So, yeah, that's sure. But at the end of the day, we currently have a Sex Discrimination Act, a Race Discrimination Act, an Age Discrimination Act. We do not have a Religious Discrimination Act. So whilst Nirvana may be a sort of sweeping suite of legislation that does everything, at the moment there's a glaring hole for those Australians of faith or those Australians who choose not to have a faith to be defended against discrimination on that ground. So why is it such an abomination that the government seeks to uphold its promise and commitment to the people at the 2019 election in delivering this?
UN has actually recommended that we harmonise and simplify legislation, and all the advice has been that this will make legislation more complicated.
All right, I'll move on. Effectively, I understood your earlier testimony to suggest that social service organisations would prevent a woman leaving a violent relationship for religious reasons. Is that a correct understanding of your testimony?
We didn't say prevent. We said that they may encourage her to return, and they do encourage women. Faith-based organisations do encourage women to return to a marriage that is violent, and to continue with a pregnancy that may have been conceived in violence. These are very common examples around Australia. So it's not.
On notice, I'd be really interested in what specific evidence you can provide in that respect, noting there'll obviously be confidentiality issues in that. But at the end of the day, this is a suite of proposed legislation that, yes, enables statements of belief to be made, but only where they meet certain preconditions in order to be protected. And those preconditions are that the statement must be in good faith, mustn't be malicious, mustn't harass, threaten, intimidate or vilify a person or group of persons. The statement must be, of course, in accordance with the doctrines and beliefs as we've gone through. So I'm interested in why you think that a conditional shield would subject women in Australia to a significantly worse set of outcomes in that context.
Di?
Can I just talk quickly to the National Anglican Family Research Report that they released in April of 2021? And I'm really happy to...
I'm not familiar with that report.
I'm really happy to read
that may be an issue, but keep going.
Directly from the Anglican Church's report, which states, teachings, it's talking about intimate partner violence, so domestic violence and sexual violence. And it states teachings related to marriage, gender and forgiveness can be a contributing factor in the extension of the cycle of intimate partner violence and can create a situation of harm for people in abusive relationships. Absolutist discourses related to marriage as a lifelong commitment, the submission of the wife to the husband, unconditional forgiveness and suffering for Christ, whether they are taught by church leaders, internalised by victim survivors or co-opted by abusers in this way, are harmful for those who experience abuse.
So, Mrs. Winker, you and I might disagree with those statements, but that doesn't mean that there aren't Australians who legitimately and genuinely believe that. So why should it be possible for us to discriminate against those Australians on the basis of their beliefs, which they sincerely and genuinely hold?
Senator, that report was commissioned by the Anglican Church. It's a research report and it stands on its own.
Yes, and my specific question though, is why is it why should it be that we can discriminate against those Australians who legitimately and genuinely hold a belief that you and I both disagree with, whereas it is not possible for us to discriminate against Australians on the basis of age, sex, race, or those other protected attributes? Just because you disagree with someone doesn't mean it should be unlawful for them to express that.
Those attributes are protected because people have no choice about their age, their race, their disability.
And
People
most
have
people of
choice
faith
about
in
their
Australia
religious-
would contend that this is exactly the same circumstance. As I gave you the example, you can't leave your faith at the front door when you go out to work, when you go into the community, when you go into a sporting association. A person of faith has that faith through every aspect of their life in the same way that a person's race is necessarily present in every aspect of their life. So why should that be an unprotected attribute?
The problem with religion is that it does discriminate against women in many, many ways, as we've said. And it is not acceptable for people to take those beliefs and make their statements about what they think about women's lives and be protected for making those statements.
And the Sex Discrimination Act, as it exists right now, means that those statements are unlawful. And there's nothing, I guess, here that allows, community-wide discrimination against women. What there is a protection for statements that are made in good faith, in accordance with the doctrines, sincerely held, all those sorts of safeguards. And I guess I just can't see why it is that you'd fundamentally disagree with that.
If they're protected by state-based legislation, then why do we need another bill?
May I have some questions? Thank you.
How's my time going, Chair?
You've got one more question, Senator Small.
Okay, thanks. In that case, I'll make my final question on the point of conscientious objection as it relates to the provision of healthcare and other services. Over the iterations of this particular bill, a number of changes have been made, including the removal of the conscientious objection clause relating to health practitioners, and the expression of and that's largely because the expression of a conscientious objection by a health practitioner is already addressed by the relevant professional codes that apply. Are you satisfied at least with those amendments to the bill?
Di?
Thanks very much for the question, Senator. I don't believe we are satisfied by those amendments in the bill in relation to section, I think it's section 15, which would actually make it more challenging for various different bodies to provide oversight on ethical conduct and professional expectations. I think the other concern that we have with the bill is that the bill actually provides provisions to override all of the other discrimination legislation that protects other attributes. Herein lies part of the significant issue that you raised earlier, that the concern for this bill, aside from not thinking that it's necessary, is that it actually will privilege religious beliefs to discriminate against other attributes that are already protected by anti-discrimination legislation.
Conscious of time, thanks, Chair.
Thank you, Senator. Senator Pratt, you have some questions?
Thank you very much, Chair. I wanted to try and ask you about the questions that Senator Small was asking, so I can try and understand this in context a little bit more. You've said very clearly that religion can be used to discriminate against someone, and Senator Small argued that, well, it's an attribute that you can't leave at the door like any other. In the context of the kinds of examples of discrimination that you see, where do we draw the line in terms of legitimate and illegitimate discrimination? For example, a pregnant woman might be discriminated against in employment if it's seen that she might be so close to pregnancy that she can't fly a plane. Like there are, for what would otherwise be a protected attribute. So in that context, can I ask, in the context of religion, you say very clearly that it can be used to discriminate against women. Is that the case with other attributes, and in the context of health, how do we ensure that it's a level playing field in terms of the attributes we seek to protect, but in protecting them, we don't cause harm on the basis of our conduct? Thank you.
That's a multi-layered question. Does
I might have been more complicated than I needed.
Yeah, perhaps.
I guess I just wanted to give you an opportunity to revisit what Senator Small was saying, which is all this is another protected attribute that should be protected in the context that other protected attributes aren't protected in a way that enables them to cause harm to others.
I don't believe that religious belief is an attribute at the same level as other attributes that you are born with or that happens to you through life. We also know that religious beliefs come and go in people's lives, and they're not necessarily a steady attribute of their life. I'm not saying that people don't carry their religious beliefs with them. They do, many do, but that doesn't give them the right to make statements that are prejudicial or discriminatory against people of any characteristic, where they see that the choices that those people are making are somehow a sin, and that it's just wrong. And the UN has made that very clear in its statements. We support, of course, and Australia is a signatory to the Beijing Declaration, the CEDAW documents, which are revisited on a regular basis to ensure that countries are making progress on gender equality. And there are other, of course, protections for people of other characteristics that the UN has oversight of. And Australia is a signatory to all of those documents. And I don't see myself, nor does the network, that this religious discrimination bill has any place against the high order documents of the UN. Di, do you want to add anything to that?
But you don't see any reason not to protect religion as an attribute if you have a particular faith, provided you're not using that attribute to cause harm to others. Is that correct?
I think in a lot of ways, I think that is correct. But just following on from Helen, I think what we're fundamentally saying is that the bill fails to adequately balance the human rights of all of the attributes. So I think no one is saying that someone can't have a religious belief. I wouldn't want to tell someone they could have a religious belief or a belief about anything else. However, I think in a lot of the examples that we've put forward, religious beliefs are used to actually prevent women from exercising their human right as a woman to access healthcare or to access support. And so in that way, how is it reasonable that we are affording the religious belief to actually cause harm to another protected attribute?
And that's why I put the question, I guess, about pregnancy. There are limitations to the protections on all the other attributes that people have, on the basis that having that attribute could cause harm if you are unable to fulfill the responsibilities and duties of your role because of that attribute. So a woman close to giving birth, flying a plane, while pregnancy is protected, you wouldn't want to schedule someone who was past their due date to be responsible for an aircraft, in the same way that you wouldn't want to make a doctor responsible for reproductive health if they had particular views about reproductive health that were outside the scope of practice for what that medical profession would otherwise recommend. What I'm trying to do is point out the level playing field to say this bill does, if you like, not treat attributes equally, as Ms. Hill has highlighted. And I just wanted to unpack that with you.
Sorry, Helen, can I just actually unpack the pregnant woman who might actually be needing to be flying a plane because she's a pilot? I think in actual fact, at the end of the day, if there was a medical determination that there was a risk to her continuing in any workplace setting because of her pregnancy, why would we necessarily say that that's discrimination? So this is because in actual fact, that example is actually about saying that it's actually unsafe to fly. This is not saying you are not allowed to fly because you are pregnant. This is saying there's a medical reason why at a certain point in time, it would be unsafe for you to continue doing this. Now, we could have a whole range of reasons why it's unsafe for people to continue to operate a plane.
That's right. It's not.
So that's not
discrimination to say you can't fly a plane, just as it's not discrimination to say you need to uphold the professional ethics of being a doctor rather than adhere to your religious belief. That's the point that I'm trying to unpack with you.
I think there's something very different about upholding the do no harm and all of the professional ethical obligations that people have to be part of those professions. I think we already do have conscientious objection opportunities and legislation in state legislation that enables people who do not feel comfortable to participate in abortion care, that enables people who don't feel comfortable to participate in assisted dying, that enables people who don't feel comfortable to participate in organ donation. Those things exist, but they exist in a way that says if you wish to do that, you need to make it clear that that's what you're doing, and you need to actually make sure that you are providing referrals to people. It doesn't allow you to just say, I'm not doing that, what you want is wrong, and you can discriminate. So I think we need to recognise that the concern of this bill is that it does actually enable people to just have statements of belief. There is no provision that says if you have a statement of belief and you can't provide the healthcare to a woman that she's requesting, that you have a responsibility under both your professional and your ethical and everything else to refer her on. So there's very big difference.
In that context, this bill, can I ask you to there's a particular, yes, this protects statements of belief, but in effect, what it also protects is not only the statement of belief, but the action that goes along with it.
Yeah.
If you say to someone, I'm not going to refer you, what does that do? I have this particular view. What does that do to whether they do or don't refer someone for example, life-saving treatment or for a referral to a domestic violence refuge or any of those kinds of things in a professional capacity? It's not just a statement. There are, in fact, actions that go with it, are there not?
That cause harm and distress, perhaps earlier death, depending on what the situation is. But the professional standards, the professional requirements of the regulating bodies, APRA, and all the other bodies that they work with, should not be overridden in any way. There should not be any loopholes for those to be overridden.
Thank you.
This bill.
Thank you,
Thank you,
Senator. I'm moving on to Senator Rice.
Thank you. And look, thank you for your submission. Thanks for your evidence today. I think it's been really pertinent. What I wanted to just clarify is the statements that you opened your statement with today of, medical practitioners and other health professionals of saying that things were sinful, denying women abortions, encouraging women to return to violent marriages. Are they legal at the moment?
Under professional standards, no, but we know they happen. Some states, most states, I think, have had to institute legislation, for example, for safe access zones for abortion clinics because of the harassment and intimidation that people of faith were undertaking. The legislation has been quite specific in that regard, and under professional standards, no, those statements should not be legal, as far as I'm aware. Emma, do you want to add anything to that?
You're on mute.
They're happening all the time at the moment, and we've got real concerns that this bill could make them more, that could increase the frequency of them occurring.
Okay, so...
Yep. Could I just add to that? I guess what I would say is, and reinforcing our initial opening statement, that these things are occurring regularly. They're things that we certainly hear about on my phone line in Victoria, and I know my other colleagues across Arwen are dealing with these real case studies. They're not made up case studies all the time. There is some level of protection in state anti-discrimination laws and other provisions. It is still very difficult. And if you could imagine that a woman who's already feeling stigmatised, distressed, has had potentially the impact of a life-changing decision that she wanted to have control of taken away from her because of delays and obfuscation, do you think she really got the time or the energy or the emotional drive to be going to APRA and trying to actually put through something to make a complaint? Probably not. The concern with having the bill is that while we have fought for years and years and years for gender equality and for women to have sexual and reproductive health rights as a human right and bodily autonomy, the new religious discrimination bill, where statements of belief, and it just has to be a statement of belief by a person, becomes protected, reinforces and pushes that trajectory and that advancement backwards, not forwards. It creates a new social, political, cultural norm of what is a reasonable expectation. And I think that is the challenge, not just that we're already dealing with these issues and we are making progress, it's that this actually creates a new social norm that further entrenches those opportunities and that position.
Thank you. So we've got a new social norm, and is your concern also that because the statements of belief will be privileged and will override state and territory anti-discrimination legislation, that it's beyond that as well, that there would be things that actually are illegal now under state and territory anti-discrimination legislation that would then become legal because they are statements of belief?
Absolutely.
Correct.
Absolutely.
Thank you.
Thank you. Senator O'Neill.
Thank you very much, and thank you for taking the time to submit, and of course acknowledge a range of views amongst women about the path that they might seek moving forward. I just want to point you to a bit of evidence that was provided by the Catholic Church, and also I think by the Anglican Church in their submission today about research into Islamophobia. And you'd be well aware through the services that you provide of women who experience incredible prejudice and discrimination because they actually wear a hijab and they wear their faith literally in public. The document that was reported was research headed by Dr. Derya Ina on Islamophobia in Australia. It reported 349 verified incidents of discrimination, harassment and violence against Muslims in a 2-year period. The material's dated a little, 2016 to 17. The report found that 72% of the victims of anti-Muslim attacks were women. Given your assertion, I think it was Dr. Kelleher, that religion should be subservient to the other protected attributes. What do you say to those Islamic women who have some hope that this piece of legislation, if properly enacted, will provide them with a degree of protection that they also need?
The overturning of discrimination towards women who choose to wear a particular headdress or clothing does not need to be enshrined in a Religious Protection Act, in our view. It should be in anti-discrimination acts. And it also, obviously, if they're violent attacks...
Dr. Kelleher, this is to be an anti-discrimination act with regards to the particular attribute that is aligned with the international civil rights under Article 18. So they don't have that protection currently, Dr. Kelleher, because there is no national legislation and 2 states don't give them any cover whatsoever.
the legislation can be amended, and we're saying that it should be, and there should be more harmonisation of those clauses across states, and where states have not got, and we understand that 2 states don't, that there can be, an action by the federal bodies to ensure that they do and that they're harmonised. But making it a religious discrimination bill has so many other ramifications that for it to be enacted to protect one group for their beliefs and their women's right to choose what they wear seems a narrow interpretation of what this bill actually is going to do. And I'm not saying that women don't have the right to wear what they like, they do. I could have purple hair, whatever.
They might have a right in our discussion today, but currently under the law, with the absence of an attempt by the government in the last 8 years in their 3 terms of governments to harmonise the law, we have what we have before us. And I had hoped that we might have ended up with a piece of bipartisan legislation, but that's not been the case. I'm a Labor senator and we were hoping for that, but we are where we are. And the reality is those women that I'm speaking about are experiencing persecution because of the religious dress. You indicate that amendments should be made to this bill if it's going to advance. Do you want to make a comment about what sort of amendment you think is needed to provide that protection without giving the offence that you have, I think, very clearly indicated in your evidence so far?
We're not lawyers, so I think it's beyond my scope to suggest what the amendment might be. Di, do you have any view on that, or Emma?
I might just comment to the point, but I'm not a lawyer either, so our apologies, but it's difficult for us to necessarily be really targeted on those kinds of questions. I think the issue here is that we are not opposed to people's people. I don't want to see someone discriminated against because of their religious belief. That's a reasonable assertion from my part. I don't want to see someone discriminated against, like the women that you're talking about. I just don't want someone's religious belief to be able to be used to be able to discriminate against me as a woman or against other women. So I think we need to.
This is a general agreement about
principle.
that.
So answering to your question, it's about the balancing principle.
Yep.
So what we're wanting to do here is to make sure that statements of belief are not used to discriminate against other attributes or other people's views. That is very different to saying that that we wouldn't support something that would protect those women who are wearing their hijab from not being they're racial attacks to some degree, as opposed to religious. They're racial attacks.
But
if you want to,
not if you're a Caucasian-born woman 5 generations in Australia, and you choose to wear the hijab. There's nothing racial about it. It's only your faith that's being discriminated against.
Yes. Okay, that could be true too. All right. However, I think at the end of the day, what I'm saying is we're not opposed to. We're not suggesting that those women shouldn't be protected and they should not have to be being subjected to that level of harassment and intimidation and vilification.
Yes. Well, I'm glad that we got that on the record. In your submission on page 4, you argue that the bill would create what you describe as an additional loophole for organisations to preference persons who share their religious beliefs when making employment decisions or offering services. Isn't it already the case that under a range of existing laws across the country, religious organisations can and do preference persons who share their religious beliefs, because that is the nature of a religious community?
We just heard the Anglican Bishop saying that only 25% of Anglican community service organisations actually employ people who are Anglican or who profess the same faith.
Is there a threshold number that you think entitles religious entities to claim that?
No, there is not. But what we don't want to see is that the current level of faith-based organisations who run most of the community service organisations in Australia are given greater powers to preference, because it is about preferencing people of their own.
Sorry, Dr. Kelleher, we've just lost you for a moment there.
Oh, sorry.
We got up to preference?
Yeah, we don't want to see preferencing by organisations which receive a great deal of public money to preferencing people of their own faith over the general population who might be seeking those services.
Could I ask a clarification there?
Well, can I just finish this line of questioning? I'm really happy to cede some time to you, Senator, but I just want to follow to this thought. So in terms of, there are a number of claims made about the preferencing and provision of services. I'm not talking about that, and they've been disputed on many occasions by people before us that the preferencing is not at the provision of service level, it is at the selection of people with a shared faith perspective or a set of skills that is necessary for the entity to do its work and alignment with the principles and beliefs and the tenets and the doctrines of that particular faith tradition. So do you object to that?
We are raising the bar by saying that it may also flow through, preferencing may also flow through to the service delivery end of the work that's been.
Well, that's perhaps another matter for another inquiry, but
okay. No, I think
and that's been disputed in the course of this inquiry. Can I ask you, do you disagree with the proposition that Catholic schools should be able to preference Catholics when it comes to hiring teachers?
We're not entering into the debates about whether or not schools can choose their own faith-based staff. It's not part of our remit, unless Di and Emma have a view on that. But we are here about the health of women.
But you have made a number of comments in your submission about employers, and that's generalised. So if Catholic or Anglican or Islamic schools, for example, couldn't preference Catholic or Anglican or Muslim staff, those schools would cease to over time to be Catholic or to be Anglican or to be Islamic.
I don't think it's fair to draw the organisation beyond the health matters that they've expressed a view.
Thank you, Senator.
Chair, can I have an answer to that question? Because the claims are about employment, not just about the sector.
We're concerned that human rights, which currently are referred to as individual, may be awarded to organisations.
Sorry, could you say that again, Dr. Kelleher?
We're concerned that the rights to discriminate and preference are strengthened by a religious discrimination bill, and that can flow through to preferencing. Now, we know that already happens in schools, and they do have the right, in my view, to decide who they will employ, as every employer does. But the preferencing can also flow through, and I know this has been disputed by some. I heard evidence earlier today that they would not expel a student who expressed same-sex preferences, and we know that it can happen with teachers. So we see that there's the balancing of anti-discrimination laws in this space, very confused.
It is a difficult balance to manage a great pluralistic democracy. That is the case, and we're dealing with very complex legislation here. I do want to acknowledge the great work that so many women's health networks do for women across this country. But can I ask you, in your own employment practices, do you preference people of no faith when you employ them to do work in women's health agencies? Is that a characteristic that is, or do you deliberately seek people of faith as well to meet the broad range of needs of people of faith and no faith across the community in terms of women's health?
I'm really happy to talk to that. We try and get the most broad range of people that we can employ in our organisations so that we can provide the best support to women possible and to the biggest range of women possible. But as a pro-choice organisation, we have to ensure that the staff that we hire are comfortable giving pro-choice advice to women in terms of their health care.
Thank you, Senator.
Well, there's a whole lot more we could discuss.
Can I just ask a clarifying question, which was...
Very briefly, I've got to go to Ms Hammond as well.
Which was to do, in terms of that preferencing, what I hear you saying is that faith-based organisations that are running services, and often they are the only services that are available because, as you have pointed out, so many of our service organisations are run by those faith-based organisations. You were saying that for those, they should not be able to preference people of their own faith. Is that accurate?
The principle is that services should be provided on a needs basis, and they and all organisations will have practice policies about that, and they also have limited resources. We understand that, but it should not be those principles should not be overlain by the need to express a statement of belief that you belong to a particular faith in order to get a service.
But I'm talking about the people that those organisations are employing. So whether so whether there should be an ability or should not be an ability for those organisations to employ people of their faith.
Di?
I don't think that we're saying that they shouldn't have some ability to necessarily employ people who have a values alignment with the organisation and what it's providing. However, we are wanting to ensure that they're not able to discriminate against people who don't necessarily share the faith.
Okay, thank you.
Thank you. Ms Hammond.
Thank you. Thank you all for appearing here today, and I echo previous senators' comments recognising the work that the Women's Health Networks do around the country. I just want to pick up on the service provision. We have heard evidence that there's no discrimination in the provision of services, and to the extent that you have evidence that is happening, I think it would be really useful for you to submit it to the committee so that we can consider it and have a look at it and the impact on it. And I think that's particularly relevant in rural and remote areas. But one point I did want to make, and I probably misunderstood you, a comment that was made, it sounded like it was critical of the fact that a lot of our social services are provided or have been traditionally provided by faith-based organisations. The point that I would think we should also recognise is that historically that was because nobody else was stepping in and doing it. So I think I just want to reframe that a little bit. So the work that Anglicare does, the work that the Salvos do, the work that the Good Sammies do, and that they've all done, and Vinnie de Paul, historically and traditionally, it's because, and they would say it's because of their faith that they've stepped in to service provision. So I'm sure I misunderstood that it's sort of a criticism that they shouldn't be in that space. But I just wanted to clarify. I'm sure that that's not what you're saying.
No, that's not what I'm saying. And we understand that it's historical over, 150 years at least, that faith-based organisations have stepped in to do that work where the state has not done that work.
Yeah.
States have chosen to step back from that work. And maybe it is because of their beliefs, but the state has a responsibility to provide services as well. And where state funding is provided to those organisations, it should be ensuring that there is no discrimination.
When the service is provided, absolutely. Yeah. And as I say, if you've got evidence of that happening, and I'm particularly concerned about those areas where, for me, living in a city, I've got a choice. I can go to that health practice or I can go to that health practice. But, in other areas or other people may not have that choice. And so if there's evidence that people are being denied services, and given that you're Women's Health Network, women are being denied services, particularly in areas when there's only one health provider, I think we need to be aware of that because that's it's not appropriate in our country.
Thank you very much.
We'll take that on notice. Yeah, we can take that on notice and provide that to the committee.
Thank you very much.
And there's also sometimes reluctance for example, one of the clients that used our service was very reluctant to go to a faith-based organisation for support because she's a lesbian. And so she felt that being a queer woman, if she went to a faith-based organisation, she would experience discrimination. So, and this was based on her historical experience. Yeah. So I think if you are funded to deliver a community service, you have to be really ensure that there's a standard that is upheld by the people delivering the service, that statements of belief are not religious belief are not delivered to people seeking service when that may not align with the people who are seeking service belief system.
Thank you, and I want to thank you all for appearing before the committee today. We've extended your time, and I thank you for giving it so generously. The committee requests that answers to questions or information, as you've been required to put on notice, are provided to the committee secretariat by close of business on the 20th of January 2022. Thank you very much.
Thank you so much.
Thank you.
Uh, 20 seconds. Yes, they are. Hold up, I've lost him. No, we'll go straight on. Yep, grab a cup for sure. I now welcome representatives of the Australian Medical Association via video conference. I understand that I'm sure that I saw your name. Hello. Yes, I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. Yes?
That's correct, yes.
For the Hansard record, will you please state your full name and capacity in which you appear today?
Yes, Dr. Omar Khorshid. I'm the President of the Australian Medical Association.
If you've provided a written opening statement, would you like it to be incorporated into the Hansard transcript?
I actually don't know if I've provided a written opening statement, but I certainly am happy to give one.
Thank you. I will now invite members of the committee to ask questions, and I'll start with Deputy Chair, Mr Graham Perrett.
Thank you, Chair, and thank you for your very detailed submission, Dr Khorshid. The AMA submission outlines several concerns it has with the bill. One of those is that Section 9 of the bill may, and I quote, limit the education, training and career development opportunities for many doctors, end quote, which in turn may limit patients' access to healthcare, particularly in rural areas. My understanding is that healthcare is already stretched in some rural areas. Would you agree with that? If so, what would you expect the impact to be on people living in those areas if this bill is passed in the current form?
Thank you very much for the question. I think it's important to acknowledge the critical role that both hospitals and other health services such as aged care facilities play in the delivery of healthcare in Australia, and it puts them in a rather different position to perhaps other faith-based organisations in that they're supplying a necessary service, a critical service that is sometimes there is no alternative to in the community. So the application of things like this potential religious discrimination bill can have an impact on health services, and that's what we would be most concerned about. The specific issue that the AMA has with the potential for employment to be affected by someone's faith is one that we've not really seen in practice. We have to acknowledge that we have many of these organisations around the country, some of which are very, very large, and we've not seen evidence, or at least I've not seen evidence of faith being used to affect someone's employment status or their ability to work in a facility as a visiting medical officer or anything of the sort. And in fact, myself as a non-religious person, I spend most of my time in the private practice working in a Catholic hospital. However, we would be very concerned if the bill created a circumstance where an individual health practitioner's employment could be affected by their faith because, as I said, of that critical role of these facilities in the community, that there isn't necessarily a choice. Often they're providing public services under contract with state governments, for instance, and it's not as though there's an alternative service down the road that either a patient or a health practitioner could access should a faith-based organisation choose to act in this way. So we're concerned about the application of this bill to health facilities at all. And I think in our previous submissions, we suggested they be removed. But if they are going to be retained, then we need to have those safety nets in place to make sure that there are no negative impacts on health service provision, which is not, it's not usually the core health service provision. It's usually in the areas where that provision may clash with the faith-based organisations' views or beliefs. And we have a number of circumstances where that is a little difficult to negotiate at the moment around the country. But when it comes to employment, as I said, we've not seen evidence in the past of that being a problem.
Dr. Khurshid, my question particularly went to rural areas. Would you like to turn your mind to that side of my question, or do you need me to repeat that?
So with the rural side of things, the main issue would not so much be the impact on a disproportionate impact on rural facilities of these sorts of decisions being made, because we've got no evidence that they would be made. We've not seen them being made in the past. And I'm not sure that the faith-based bodies that run these facilities would make decisions like that just because they're allowed to. If they did make them, then yes, you could certainly see an impact on the provision of health services in rural areas, particularly where those faith-based organisations are the only option. But I don't believe that's particularly likely, given that that sort of behaviour has certainly not occurred in our view in the past.
All right, thanks, Dr. Khurshid. Your submission raises concerns about Clause 12, the Statement of Belief provision. A previous submitter, Mr Erlam from the Council on the Ageing Australia, also raised concerns about the Statement of Belief clause and its impact on aged care. He was asked about Queensland's voluntary assisted dying laws and whether Clause 12 would impact someone wanting to use those laws. Mr Erlam's view was, and I quote, "We can see voluntary assisted dying as being something that people are talked out of trying to do," end quote. Would you agree with that view of the impact of Clause 12? And I realise if you've worked at Catholic hospitals, and I come from Queensland, where I know we used to say that the Mater, 1 in 6 Queenslanders were born at the Mater hospital. We used to say something like that. So would you like to make comment on that?
I can make some general comment, but I would need to come back to you in writing on the specifics of Clause 12, which I don't have in front of me.
All right, thank you.
I could certainly say that there is a general concern that access to health services like voluntary assisted dying, which the AMA, of course, has mixed views on in the first place.
Of course.
There's no doubt that access to those sorts of health services are going to be different.
Could we say health that involves matters of conscience? Is that the way to talk about them?
I think that would be reasonable, yeah. And there are other examples, of course, with issues,
fertility,
health, pregnancy,
abortion.
Correct, yes.
Yeah. Okay.
Yeah.
Okay.
So yes, we do believe that the fact that these facilities are run by faith-based organisations can impact access to those health services. But as to the specific effect of Clause 12 on that, I'd have to get back to you on that.
Okay. Well, my next question might be along those lines as well, but your submission suggests amendments to Clause 15. The AMA suggests that Clause 15 may cause conflict with professional standards. Can you give the committee an example of how conflicting legislation and professional standards may impact on patients? I'm not sure if you want to go to your submission or do you want to...
Yeah, our submission does address this issue. We are very much of the view, and this is one of our main points, that the professional standards are well described that apply to health practitioners, in particular to the medical profession, through our medical board, through the Code of Good Medical Practice, through other codes of ethics like the AMA's Code of Ethics and the international agreements such as the Declaration of Geneva. These are appropriate professional standards that all doctors are held to, and they put the patient's interests above the practitioner's interest and the practitioner's views as the number one consideration.
The practitioner's faith even?
Including above the practitioner's faith, yes. So
Okay.
the interest of the patient must be the first interest. Now, that doesn't mean there isn't a way to continue to provide health services in settings where there is a clash there. But number one, the patient's interest must be first and foremost. The patient's medical interest must be first and foremost. And therefore, if this bill conflicted with that obligation to provide the best quality healthcare that we can, or conflicted in terms of what standards a practitioner is being held to, then that would concern us. And again, the examples are around these difficult areas where doctors may have conscientious objections to care. That was why the AMA was not comfortable with the conscientious objection clause in the previous version of the bill. We're pleased that that has been removed, but we're still concerned that the bill doesn't really clarify enough that professional standards should be the first and foremost consideration. And if this is going to stay in, then we would certainly recommend very strongly, we've said so in the written submission, that any standards specifically applying to health practitioners be directly discussed with the medical board and other key practitioners to make sure that they are at least consistent with what we would call good medical practice.
And I think your submission, so final question, Chair, but that you make it very clear that the community trusts the medical profession and your ability to regulate yourselves, in terms of ethics and making decisions in very, very, very difficult areas that we've touched on. So I would certainly echo that position that I see in my community. Doctors, the medical profession is trusted to self-regulate in this area. So thank you for your submission and the work that you do. Thanks, Chair.
Thank you. Dr. Korshid, I'm going to ask you one question and then I'm going to hand to Ms Hammond. I'm curious the percentage of regional and rural GPs that the AMA represents in terms of membership. Do you know that offhand?
I don't have a number offhand as to the proportion of regional rural GPs that are our direct members, but as the only body that represents all doctors, we see ourselves as representing our entire profession. There are, of course, other bodies that represent subgroups of the profession, including rural doctors and, of course, general practitioners. But we take the overarching advocacy role in consultation with those other bodies. And so our membership rates and the numbers of people who pay for our services are much lower than the overall number of doctors in the society, but we're still representing all of them.
So just to clarify, I'm looking for what kind of engagement you've had with rural and regional GPs who frequently carry the kinds of complex issues regarding moral questions, whether it's abortion, whether it's end of life. How many of those doctors have you engaged with to understand their perspective in terms of the number who are religious, who actually are practicing Christians or other religions? How many of those are part of your discussion and are engaged as stakeholders?
Thank you for the question. Look, we have, as any advocacy and membership body, we have structures in place. We have our state and federal bodies. We have committees, subcommittees and councils that represent various parts of the profession, and they are engaged in our policy determinations. Now, we've not surveyed our membership on these specific questions, if that's part of what you're asking. So we've not gone out to every member and asked them what they think on these specific areas. But we do have a Rural Doctors Committee, for instance. We have rural doctors on our federal council. And so as we determine our positions on areas, all of our formal positions are taken through processes that give rural doctors and every other type of doctor that is represented on the AMA a voice in all of our determinations. As I said, we don't go directly to the membership on detailed consultations like the submission for this paper. That is handled by our executive team and our federal council as appropriate. But, we are listening to the voices of rural doctors in all of our policy determinations.
So do you have an idea generally in your membership how many people are religious, whatever that religion might be?
I don't have a specific idea. I would suggest that it follows the community, and doctors' rate of being actively practicing a religion is likely to be decreasing at the same rate it is in the community. We certainly have doctors who hold extremely strong views, very strong religious views, and incorporate that into their lives and their practice every day. And of course, we have others who don't. And I think it's highly likely with over 100,000 doctors in the community that we have that full breadth of religion that will largely match that in the community.
Excellent, thank you. I'll hand you over to Ms Hammond, who's online.
Thank you. Hello, Dr. Caution.
In a minute.
So just for clarity, the removal of the conscientious objection clause, you are pleased that that has been removed from the bill?
That's correct, yes.
Because that is dealt with under professional rules, isn't it? Or state and territory laws, am I right there?
Yes, so we have our codes of conduct specifically address conscientious objection and areas where doctors' views may conflict with the services a patients need, in areas like access to abortion, for instance, voluntary assisted dying. Some state and territory laws are quite specific in areas around conscientious objection, and that varies state by state. But again, some jurisdictions have very specific laws around voluntary assisted dying and access to abortion, for instance.
Yeah. Okay, I just want to get to get a bit of understanding. I have concerns about health provision in rural and regional, but the chair has touched on those. But just in general terms, now there are a lot of private health providers in Australia, and they provide great service. But a number of them, majority in the Catholic hospital, in the Catholic healthcare system, don't provide certain services now. That's correct. But to be accredited and to be able to open up a hospital is not just a question of building a building and they will come, is it?
No, hospitals, like the rest of our health sector, very much relies on the people that run them. The systems, the quality and safety, but in particular, in the case of medicine, the expertise of staff that you're able to attract to run your facility.
Yeah. But they go through full accreditation. I mean, we've got a really, I think our health system and the people who work in it are fabulous, but we have a very strong accreditation system, don't we?
We have an accreditation system for hospitals that is very strong, and of course, the hospitals themselves have systems to ensure that the practitioners working within them are appropriately credentialed, trained, etc. So there's lots of regulatory systems that are all working in conjunction that underpin the safety of our hospital sector, that's for sure.
Yeah. So I guess where my thinking is just going at the moment is that we already have a system of public health and private healthcare. We already have faith-based healthcare providers. And again, I'm leaving aside rural and regional because I do think that's an issue that we really need to look at. But we already have them that provide different services. Isn't there then an element of, irrespective of this bill, to ensure that healthcare provision is adequate across the board actually comes down to government contracting, identifying and reimbursing and paying, the way we set up the healthcare system across Australia to ensure that all services are provided. And, so if one particular hospital system doesn't provide a service, we ensure that that service is provided by somebody else and is accessible to the same people.
That's right, and it's made difficult, I think, where you have a faith-based provider as the only provider in a geographic area or the main provider. And it can be tricky then to provide access to services that are core medical services that don't fit with that organisation's faith. And that is a problem for government, as you correctly point out. And in the circumstances I'm aware of, workarounds are put in to make sure that those services are available in those geographic areas for people who need them. Where it gets, as I said, more tricky would be rural and regional, and you have the only provider, and that's where some of the professional standards and in some cases laws that require practitioners to make effective referrals, for instance, have come in because of that concern over access to healthcare for people who need it.
Yeah. Can I also just clarify, my understanding of the healthcare system is that private hospitals don't actually employ that many doctors. Doctors get rights to perform there, but public hospitals, they do employ doctors, don't they?
Yeah, there's a variety of arrangements. The private hospitals do employ some doctors, definitely junior doctors, and in some cases senior doctors in various roles, but the average private hospital is very much a visiting medical officer model, where rights of private practice are granted and practitioners practice their own trade within that facility. But in doing so, they have to abide by the bylaws of that facility. And so in the case of Catholic hospitals, for instance, there are certain services you are just not allowed to provide. And if you did provide those or were seen to be even discussing them, then you'd be in breach of those bylaws. So there is, even though you're an independent practitioner, there are limitations on your practice.
Yes. But isn't it also the case that most VMOs would have rights at a number of hospitals and also potentially have their rooms somewhere else? So what they might not do at a Catholic hospital or an Adventist hospital, they might actually do at another facility nearby?
Yeah, that's correct. And I think although there are some issues, as I said, with the services that are not available in faith-based hospitals, at the end of the day, there are alternatives. And as you correctly point out, those practitioners who, as part of their normal specialty, would provide some of those services simply do so at another facility, should they choose to work in a Catholic facility.
So I guess, and this is my final question, is leaving aside rural and regional, but just in sort of city areas, do you actually think that this bill is going to change the way things run at the moment in terms of the provision of healthcare?
As I said at this, in response to a previous question, we've not seen any significant evidence of the employment or engagement of practitioners being affected by that practitioner's faith, as long as they're providing the services that they're supposed to be providing and they've got the appropriate training and credentialing. Those, from our experience, those practitioners are able to work. It's perhaps different in upper level management in those facilities. There's probably more of a requirement to be of the same faith at those levels. But for the on-the-ground services, it's really around those services that are not allowed to be provided, and we've not seen any evidence. Having said that, if this bill made it explicit that you are able to discriminate on the basis of faith in terms of appointing a VMO, employing a nurse, then that would limit the employment prospects of practitioners. As we've mentioned, some of these facilities are public facilities, they're training facilities, and we don't believe that would be a positive move. That would be a regrettable move, and it shouldn't be seen to be a good outcome. But as I said, I don't have any evidence that behaviour would occur, because it certainly hasn't, in our view, in the past.
Okay, thank you very much.
Senator Rice, do you have some questions?
Thanks, Chair, and thanks, Dr. Khorshid. Look, I just want to actually start by acknowledging that we're in the middle of a pandemic, and to thank you for appearing before us today, and to thank the AMA for all of your important work and the work of doctors absolutely overworked around the country. Yes, I just wanted to, in fact, in relation to that, I mean, do you think that this bill should be a priority as the pandemic continues? I mean, what's the impact of you having to put in time to be, considering this bill, for example?
Thank you for the question. This bill is certainly not something that the AMA is pushing for, and we don't believe that there is any problem in healthcare that is solved by this bill. However, if the bill is needed for other reasons, we are simply seeking to minimise any potential negative impact on healthcare or access to healthcare for Australians through our submission. Whilst the pandemic is all-consuming, as you correctly point out, we do recognise our role as representatives of our profession, and we are more than happy to engage in discussions like this and indeed in pushing our own agenda as in other areas around healthcare as the pandemic continues. So very, very happy. It is slightly distracting, as you point out, but that is the purpose of the Parliament is to legislate, I guess, and we're happy to appear before you and share our views.
Thank you. Look, I now want to go to the where in your submission you talk about the statements of belief, where you say that you continue to have concerns in relation to statements of belief where the bill will lawfully enable statements to offend, humiliate, insult or intimidate people or groups such as women, LGBTIQA plus people or people with disability, noting the prohibition of where a reasonable person would consider the statement would threaten, intimidate, harass or vilify. But you say that this threshold leaves extensive scope for bullying, harassment, intimidation of people or groups of people such as women, LGBTIQA plus people and people with disabilities, to name a few, that can lead to serious risk of harm to their health and well-being, and this particular provision of the bill may conflict with professional standards and guidance for doctors set by Australia's medical regulators. Could I ask you to talk about those serious risk of harm, and also about that conflict between the sort of professional standards and guidance?
Yeah, thank you for the question. I think our main point is that we believe our professional standards for doctors should be the overarching and highest level of, or the thing that drives our practice, rather than being overridden by a law that enable conduct that would otherwise be unprofessional or illegal. Whilst many religions, or most of them, wouldn't be suggesting that people make statements that offend others, there are some religions and some views within some religions which clearly, if expressed, have the expression of those views has the potential to harm individuals in society, as is detailed in our submission. And we don't believe that it would be appropriate for a health-based organisation to make statements of belief like that do actually potentially harm people in order to explain why you can't access that particular type of service in that facility or with that particular doctor. It's potentially too great a freedom, and we believe that the professional standards should apply, and that there be no law that says a lower standard is okay in order to defend your own faith, that you should still not be able to make statements as a health practitioner that offend vulnerable people in the society. That is ethically very worrying and would be a negative direction for our health profession to be going in.
And so it's your understanding that this bill as it stands at the moment, that those statements of belief would override professional standards?
That is how I've been briefed by our counsel who've had a look at the bill, that there is the potential for that to occur, and although we acknowledge the change in the threshold, but we still think there is the potential there for that to occur, for that to be permitted under the bill. And it is, I guess you have to test it if a bill, if a law specifically allows certain conduct, and that is in conflict with professional standards as regulated by the medical board. I guess I don't know what action the medical board might take if a practitioner still breached its standards that are expressly allowed under a different law. That gets a bit complicated, and I guess we're saying we'd like there not to be any conflict there, that the standard behaviour be crystal clear, and one that all or the majority of the medical profession would aspire to and agree with.
Thank you. And yes, the fact that there is that lack of clarity, if not, it seems that those statements of belief would override it, is of great concern. I asked a question of one of the religious organisations this morning about statements such as a patient with HIV/AIDS being told that that was a punishment from God. And their response was, oh, well, surely they wouldn't be able to say that because it would be going against their professional standards. But what you're saying is, no, under this legislation as it's drafted, they would be able to say that, even though it potentially would be against professional standards.
That's our understanding. It's certainly our concern, and we would like absolute clarity. We think that would be preferable. That practitioners be very well aware of their obligations as they are currently, and that not be muddied by a new law that potentially creates confusion around what is okay, what is legal, and what is not.
And finally, could I just ask you to go to that if this legislation was enacted and then we did have, other witnesses have described that, we will have legal cases for decades, what the potential implications might be for medical professionals that were then caught up in sort of long-running sort of case law legal trials. Is that of a concern to the AMA?
Certainly, we don't want to see our we don't want to see our members or members of our profession acting in ways that would land them in this situation in the first place. But there's no doubt if doctors are making statements in public that result in them getting caught up in legal action, it's extremely stressful. It affects the quality of their practice. It affects things like medical indemnity premiums, for instance, that all other doctors have to pay in order to help fund that kind of action or defence, defending doctors who've tried to do either the right thing or the thing that they believe is right according to their faith and what they believe this law says. So I think all of that should be prevented if at all possible, and hence we've made these statements in our submission.
Thank you. Actually, I did have just one last question, which on the first page of your submission, you said that it's essential that the provisions in any religious discrimination bill maintain the level of protection offered by existing state and territory anti-discrimination laws. Otherwise, there's the potential to further marginalise particular groups of individuals who may already face stigma and uncertainty when trying to access healthcare or particular health services. So can I read from that you think this legislation, given that it does override state and territory laws, that you don't support that element of it?
We believe the standard that has been set by the state and territory anti-discrimination laws is appropriate, and any move to downgrade that protection for people would be a negative move. Yes.
Thank you.
Thank you, Mr. Andrew McLaughlin. Senator McLaughlin, I apologise.
Yes, I have a question. Can you give us some data on how many complaints or unprofessional conduct investigations you conduct in a year in relation to those people that have acted in accordance with their stated religious beliefs? I'm really looking for what is the size of the problem from the association's perspective, or in fact, how many have refused to give medical care because of their religious beliefs?
Thank you for the question. We don't have great data on any of that, and we're not the regulator, so we wouldn't receive the complaints anyway. That would probably be a good question for the regulator, and they of course take complaints on all aspects of medical care and the practice of other health professionals as well. I think, like many of these very difficult areas that get discussed, sometimes the potential for problems is bigger than the actual size of the problem. And I think, we focus on what could happen a lot of the time rather than what is happening. So I acknowledge that point, which I think you're making, which is that this may not have a massive impact size-wise, but I think the impact on the vulnerable groups can be very disproportionate to what you might call the impact on the overall provision of healthcare in Australia. those groups that are vulnerable in these areas have already got a number of health and mental health issues that they're dealing with, and adding to those in order to provide freedoms for other people is something that we would certainly struggle with.
That view you're expressing there is anecdotal, I take it, rather than evidence-based.
Well, it's based on, it is anecdotal, but it's also based on, it's the views of the people with whom we engage as we develop our policy in these areas. But I can't give you any data on the quantity of these issues that come up with regulators, or that how often they arise in the community. I don't have any data on that.
Could you take on notice for me if the AMA has formed a view on the numbers that have come out of complaints? Because obviously your association would look at how many complaints going through to determine its codes of conduct. So in the event, if there's a publicly stated view, I'd appreciate it if you take that on notice.
Okay, I'll get back to you on that.
Clear there?
Yep.
Sorry, because we're doing it by telephone. The other thing is, how does a person who's a member of your body who is of strong faith have a voice? I was a little unclear on your responses to the chair. I mean, are they just a member, or do you seek their views out in particular, as you would other views?
Yeah, so we have a number of different ways to gather the views of our membership. Some of it is passive, so members who have strong views on issues write to us, and we respond, and we collate that kind of feedback. On areas of particular controversy, we will sometimes go out to the members and survey them. And an example of that was informing our position on euthanasia and physician-assisted suicide, where we knew there were going to be very strong and views on both sides of those arguments within the profession. And we felt unable to come to a position as a group of, for instance, 30-odd people on a federal council of the AMA. And so we sought to engage the membership formally in that way. Members who participate in the AMA in our state bodies and our federal body their views are obviously sought on a range of issues, and those members who participate are of a range of different backgrounds. So there are people in our structures of very strong religious views, and there are people who don't have those views. But we don't have for instance, a special interest group of doctors of Christian faith, for instance. We don't have that kind of structure. But it's, we have an incredible breadth of advocacy that we work on, and our capacity to go to the broad membership, the 30-odd thousand members that we have, just under 30,000 members that we have, on each issue is very limited, because they don't respond. It's too much, and we have a huge agenda that we have to deal with in a relatively quick basis. Often, our submissions that are required on issues like this, we only have a few weeks in which to collate them, and it's just, you can't go to every member on every issue, but we certainly do on those issues that we feel need the full attention of the membership.
Thank you for that, Chair. I have no further questions.
Thank you. Senator Pratt, I believe that you may have a question, just flagging that we have 5 minutes. Yeah, we might have to put some on notice. Thank you.
Thank you. I do have a question, and thank you to the AMA for your evidence today. May I ask, please, in the context of what you were saying just previously with regard to the data about the number of practitioners that might be affected by these changes, in terms of those that have had complaints made about them, would such data be a true reflection of the problem if there are practitioners who currently feel constrained in their conduct because of the restraints, the current regulation that does uphold professional standards and ethics?
So we're quite comfortable with the idea that our members are constrained in their behaviour by their professional standards. That's the whole point.
Yes, I am too.
Yeah.
I am too. I guess what I'm trying to is to come to terms with the other senator's question who was trying to negate the significance of the problem by saying the problem isn't very large anyway, whereas you drew the evidence back to it's still being significant because of the impact on vulnerable communities. But if you were to license such behaviour, could we use the current data about it not being that much of a problem as a reflection on whether this is a desirable outcome or not?
Yeah, I think I would agree with your point that if that we couldn't use our experience with doctors' behaviour now to predict what might occur if the laws change. We would hope that doctors would choose to abide by their codes of conduct, even if other behaviour was legalised. But we can't be certain as to exactly what would occur, and some people do have very strong views in a number of areas. I do agree with your point, yes.
And can you give me an outline of where that conduct is currently codified? I know it's codified in the context of reproductive rights, medical care of the dying, and some healthcare in relation to gender.
Yeah, those are the areas where we're seeing where we've seen problems, or where access to healthcare has been experienced by patients to have been limited by the views of doctors, particularly in those rural areas and where you don't have a choice of doctor. And that's why we are seeing it, as you mentioned, codified specifically in certain circumstances. However, the broader requirement to act in the patient's best interest is codified through the Medical Board's Code of Conduct, Good Medical Practice, and through our own Code of Ethics, etc., as I mentioned before, including the World Medical Association's Declaration of Geneva and, of course, the International Code of Medical Ethics.
And just finally, I wanted to ask, our previous witnesses from Women's Health spoke about issues such as domestic violence and the kinds of referrals that they make, and concerns that they've seen when they've had women that have been subjected to violence that have been told by various services or religious bodies that they should return to the primacy of that relationship. Would such a statement be consistent with good medical ethics? And if the primacy of marriage is one of the beliefs that is supported by this legislation in the context of medical care, what ramifications could you see coming off that?
To respond to your question, I guess I'd say that to begin with, that of course, ethically, any advice coming from a medical practitioner to a victim of domestic violence should be to the benefit of that individual and their circumstances at the time. And of course, circumstances will be different, and should not, a practitioner's faith shouldn't determine the advice that is given to a patient who's presenting with, having been a victim of domestic violence. That's crystal clear.
I would very much agree. So what does that mean in the context of a statement of belief around those things? In the room where a medical consultation is taking place, or in a broader practice or broader advocacy in someone's role as a doctor, if you're appointed to a board or something like that?
Yeah, so we would be of the view that that is an example of where the statement of belief could create harm in the community and could also create confusion as to a practitioner's obligations and make it less clear to the practitioner as to what is acceptable behaviour and what is their responsibility as a leader in the community. And obviously we have medical practitioners who may well be leaders in religious communities as well as as a medical practitioner. But in our view, when you have the hat on of being a medical practitioner, you must abide by the codes of conduct, the legal frameworks that underpin our practice, because, as has been mentioned in our submission, the role of the doctor is a highly respected role. It's one that must not be misused for other purposes. And in many communities, just being a doctor means your voice is extremely loud and extremely influential. And that's why, as we've stated very clearly in our submission, we would not like to see any conflict between a religious discrimination bill and our codes of conduct as they are existing at the moment.
Thank you,
Okay,
Senator Pratt. If you could ask your last question on notice, please. I need to go to Senator O'Neill.
What kind of amendments would you like to see to the bill to resolve those potential conflicts between a professional code of practice and this legislation?
Dr. Caution. Yes, on notice. Thank you. Senator O'Neill.
Thank you very much. I don't know if you heard the evidence of the Australian Women's Health Network. As a person of faith with a particular view, I hold that strongly, and I'm pleased that I can do that in this pluralist democracy. But I was very concerned by the degree of anxiety they had about access to services that was put on the public record today. In your responses so far, you've indicated that AHPRA really has the responsibility of looking after these matters of professional negligence or mistreatment. Senator Rice is chuckling because we've got another inquiry going on to AHPRA, particularly about the cosmetic cowboys and the claims that are made to professional capacity there. So I would appreciate, this would have to be, I guess, on notice, a response to the claims that were made there, because they have certainly raised my concern. I know that access to services in regional rural is very, very problematic, but I think what they said today was so frightening for people who hold a non-faith view, or people of faith who hold a particular view about particular issues. Unable to access services is a problem. This is my particular question, though, with regard to guidance around social media, because that's one of the platforms where these issues could be contested. AHPRA provides the social media guidance for health practitioners, including in relation to social media use in a doctor's private capacity. Can you, at this point of time, foresee a situation which a doctor or another health professional breaches AHPRA's professional standards, but it's a breach that cannot be dealt with by AHPRA or the medical board because an attempt to do so could constitute discrimination under the Religious Discrimination Bill? If you need to take that on notice.
Yeah. I think the short answer is yes, we're concerned about that, but happy to take that on notice and provide a clearer answer. Could I just ask, though, your question on women's health and access to services? I didn't hear that evidence.
The Secretariat will provide it for you, Dr. Khorshid, so that you can have a look at that.
Yep.
It was concerning. I mean, I think we really need to acknowledge the full breadth of perspectives about, life matters, conscience matters, etc. But where those range of views exist in a community and people are unable to access a service, that is highly problematic.
Thank you. Thank you for appearing before the committee today, Dr. Khorshid, and for giving your time. The committee requests that answers to questions taken on notice are provided to the committee secretariat by the close of business 20th of January, and they will provide you with the information that has been alluded to.
Thank you very much.
Thank you. That concludes today's hearing. On behalf of the committee, I would like to thank all those who've made submissions to the inquiry and made representatives available today. I would also like to thank Broadcasting, Hansard and the Secretariat staff for their assistance today. The committee stands adjourned. Thank you.